All right, that's Q. Instruction Q is the same as your 24. Do you want to withdraw?
24 withdrawn.
Okay. 25, the difference between murder and manslaughter is malice. I'll just put that to the side till we get our waterfall instructions, okay? 26 is you may infer malice from the use of a deadly weapon, which I
We
think.
already have that in.
We have
Yes. What number is that? Do you have it just
That
for the record?
Thing.
Or letter?
I'm pulling it up, Judge. Willful deliberate.
Deadly weapon.
Deadly. R.
R. Okay, so R is the same as your 26. Do you withdraw 26?
Yes, Your Honor, we'll
Okay,
withdraw
withdraw
26.
26. Then we're skipping 27's already been withdrawn, so we get 28. Once the Commonwealth has proved there was an lawful killing, then you may, but are not required to infer that there was malice and that the act was murder in the second degree, unless you want to just put this to the side for the
Yes, please.
charging instructions. Okay, we'll put that to the side, Mr. Carroll. And then we have 29. Again, that seems to be the verdict form, so or actually, that's another charging instruction for second degree. Okay, so we'll put that to the side. All right, instruction 30, that's a penalty
Welcome in, everybody. I'm Annie Yu.
And I'm Katie Lasso.
And we are once again joining you on this Friday, which is unusual, but with the impending snow, court will be held today starting at 10 a.m. So we will be joining you until we take you live inside the courtroom. Of course, Katie, you've been following every minute of this. I know I had to break away for some shows and things like that, but we just want to first and foremost thank all of you for continuing to tune in every day with us, engaging on our YouTube channel. Lots of great questions coming in through our texting system as well. And let's share that number real quick. It's 202-895-5599. So keep those questions coming because Katie, you have been also spending a lot of time with our legal experts, our attorneys, about just where this trial is headed, what we've learned so far. Let's take our viewers back to day 7 yesterday.
But Annie, I do want to mention today we've been having legal experts, but today we will have a body language expert here during the lunch break, so around the 12:30, 1 o'clock time frame. She'll be able to take some questions, but we're also going to go through some of the footage, the body camera footage.
I love that.
And some of the moments where Juliana was testifying and when you see Brendan reacting, and she can kind of weigh in, so definitely stay tuned for
I think that is riveting, and I think I mentioned that early on to you that, gosh, as I watched this play out in week 1, to me it was interesting, the body language, the mannerisms, the things that he would be jotting down, like what does this all mean? Perhaps we can read deeper into a behavioral expert type, so be sure to stick around for that. Today is day 8, January 23rd. Yesterday, though, on Thursday, a lot of the focus became the officers. We saw a lot of text messages revealed, and we heard a lot of testimony from the officers that were involved in the investigation.
Right. And a lot of the officers who were transferred out of the homicide unit, out of the forensics section, because of some of the decision making that went on, really focused around Detective Brendan Miller, who was in the forensics, the digital forensics section, and who had drawn this conclusion through his forensics analysis collection that he did not believe Christine Banfield ever lost control of her devices, and that goes directly against that catfish theory, if you will, and that's what the defense has been calling it, a theory. When I spoke to our legal expert yesterday, he said the theory word, you know, it casts doubt, making it sound like, oh, it's not factual, it's a theory. So it's a big word.
And digital evidence is pretty standard. I mean, it does not lie, right? Did you gather from yesterday that her devices were only being used when she was home?
Yeah, so it's complex, right? So the digital forensics, when they were questioning Detective Brendan Miller, he was talking about how his data shows that the device was being used, but you know, at the end of the day, unless you're sitting next to the person, you don't know who's actually holding the device. So while he's looking at the patterns, things like what else was she doing around the time that those messages were being sent on the Gmail account and that FetLife account, he's looking to see what else is going on. Is she doing other activity? And his analysis showed that he believed Christine was on her phone. She was messaging with Juliana on WhatsApp. She was shopping on Poshmark. But the thing is, he says, you know, that doesn't mean she was he says it shows data-wise that she was in control, but at the end of the day, we're talking about devices that are connected to our laptops, right? If you have an iPhone, you have a MacBook, it's all connected.
Or a watch.
A watch, right. So, and you know, we heard from Juliana that she said they were using Christine's laptop. So,
when she was home.
Right.
That they would get it from her somehow when she left it by the door because her laptop was always with her. So I think the defense was trying to dismantle, you know, the thoroughness of this investigation.
Right. Yeah, a lot. And we heard from several investigators, 7 different people from the police department. And one of the first people, you know, there were 2 people that took the stand right off the bat, but I think the first really interesting person that took the stand up there, as we were talking about, was Detective Leah Smith. And she was asked a lot about her time as a homicide detective on this case. You know, Annie, I know you were very interested in what she was saying, and she kind of pushed back on
I think she was a critical piece to the narrative that we've heard. You know, she was a big part in the room where she spoke to her fellow. She was a homicide detective at the time. Let's be clear about that. Detective Leah Smith, homicide detective with Fairfax County Police, and she suggested that there was a push to adopt this narrative that supervisors were pushing on the officers, and this narrative that officers needed to get behind. But to the defense, she is very important. And she was basically saying that she was urging her fellow colleagues, hey, we need to keep an open mind right now. We don't have enough evidence or DNA or anything in front of us to tell us that this specific narrative is the way to go. We need to stay open-minded, and she was really a critical voice in the room.
Yeah, and we actually have audio of kind of that moment where she's talking about the pressure they felt. So, you know, we would like to try to play that for you. But essentially, she's talking about some of the pressure from upper leadership within the department, and talking about how there was this push to either you choose one of these theories, you got to get behind one. And she was like, I don't do investigations based on theories, but on evidence. We do have a couple of other people that spoke yesterday, so let's see if we could get to any of the audio of them speaking. One of them was John Patrick Bruce, and at the time he was a captain for the Major Crimes Bureau. He went on to become a deputy chief, and you know, he was asked a lot because he is the person who was essentially responsible for Detective Brendan Smith transfer. And you know, he said that he did not want Detective Brendan Smith to ever do forensics analysis for the Major Crimes Bureau ever again. But you know, he was asked about that, and then he did make a point to say, yeah, I didn't want him in that unit, but I did retain him in a different unit. Are we able to play any of that audio of him talking about that? All right, let's take a listen to that if we can.
It was not the data that I had issue with, it was the interpretation. And I think probably some of his analysis went outside the bounds of what he would normally do.
All right, so that was actually Lieutenant David Giascio, and he was one of the other investigators, one of the other supervisors here. And we can just talk through some of this a little bit. But you know, John Patrick Bruce, going back to him, he was talking a lot about how he had a forensics background himself, and he felt like the data that was presented, the summary, if you will, not necessarily the data, but the analysis, that was really where they were going. They didn't agree with the analysis of that data. So they're not saying his data was wrong, they're just saying his interpretation, they didn't quite agree with it. And you know, is it because they have different evidence? That's what they said. Or is it because they wanted it to fit their theory, if you will, and that's what the defense
So
was pushing.
fair to say that that testimony revealed concerns in the digital data?
It did, but then, you know, we would hear the prosecution come back up and once again say, hey, at the end of the day, you have no physical proof to say that that phone was in her hand at that very moment. And we did hear Detective Brendan Miller say, unless I was sitting next to her, I wouldn't know who had the phone at any point. If we move on to Lieutenant David Giascio, you know, he talked about some of the evidence that came out that they were able to uncover, and he was very adamant that Juliana wasn't the reason that Brendan Banfield was arrested. Brendan Banfield was arrested in September of 2024. Juliana had been in jail already since October of the year before, but that following October, so a month after Brendan Banfield is arrested, is when Juliana takes that plea. So he is saying, you know, we arrested Brendan before Juliana recanted, if you will, changed her story. And I think that kind of went against what the defense was hoping was going to happen. Lieutenant Giascio also talked about how when they were doing their research and looking into some of the evidence, they went back into Christine Banfield's data and to what her activity was. We're talking about a woman who was a NICU nurse, and he said that their data, they went back several years and they never found her researching any of these things prior to this. And they never even saw that she visited any pornographic sites. So that was a flag for them as well.
So watching every minute of it, do you think that the defense did its job to dismantle the thoroughness of this investigation? And I'm leaning on what our legal experts share, which I thought was really good, because I think anyone watching is thinking, gosh, this is a lot of details. Where is all of this going? I mean, when the day started, we heard John Carroll, Brendan's attorney, sort of ask these long-winded questions, and it just felt like it was dragging on, right? So to anyone watching, you're thinking, where is this going? And in fact, that was brought up. I thought it was interesting that our legal experts said, look, there may not have been some bombshell or fireworks on the surface of what was being said, but if you really listen to the little details, all of it is adding up to something meaningful. And he said to also bear in mind that the job of the defense's position isn't to present a theory, right? Their job is to basically poke holes in the government's theory of what happened. So it doesn't have to prove anything other than that, just a reasonable doubt.
Yeah. There was another person that was brought up to the stand yesterday, in addition to all of the people we were speaking about, and that was Sally Fayez. She's with the Victim Services Unit, and she was talking at length about her first encounters with Juliana and the little girl, the 4-year-old little girl. Because remember, there's a 4-year-old little girl who lost her mother here.
It's an awful situation.
Father's on this, in court facing murder charges. So a really tough situation. But Sally Fayez was able to speak kind of at length about the moment that concept that maybe Christine was set up first came to thought. Are we able to play that clip of Sally Fayez? Let's take a listen to that if we can.
What was it that happened that raised in your mind the question of Christine having been set up?
At the hotel. So from my understanding, we had an intel detective in the lobby of the hotel that we had everybody in, and she had asked Juliana, "Can I call you mommy now?"
When you say she, who are we
I'm
talking?
sorry.
Christine's daughter?
Yes, said, "Can I call you mommy now?" Juliana, again, I don't remember her answer. She said yes. And then she said, are you going to marry my daddy? And Juliana said, "I wish."
Okay. Thank you. I don't
Sure.
have any other questions, Judge.
All right, redirect. Or is this witness subject to recall? All right, you're free to go, ma'am. Thank you. Your next witness?
A pretty powerful moment.
I would say that's a bombshell.
Yeah, and to give a little context there, she's talking about the day of the killing, possibly the days after. She wasn't clear on exactly when that happened, but they had intel officers in the hotel where they had taken Juliana, Brendan, and that little girl, because obviously the home is a crime scene. And she did make mention that Brendan, Juliana, and the little girl were reunited, I believe the same day as the killings. We know that Juliana and the little girl were taken to headquarters to answer some questions and be interviewed about what had happened. And Brendan, meanwhile, was taken to the hospital. So they were eventually reunited at the hotel, and there were intel officers at the hotel. And that conversation is what one of the intel officers told Victim Services, but also told investigators. And so that kind of poked a hole in the defense's concept that this catfish theory was because of Juliana. So it was pretty early on that they were starting to think something's off here, and then they kept looking into it.
Right. And remember, Juliana did testify in week 1 that the reason why divorce wasn't an option was because Brendan would have to share custody of their daughter, and money was involved.
Right.
Divorce was not an option. So they decided to create or come up with this this elaborate plan to kill 2 innocent people.
Right.
Just a horrific situation.
Yeah, and of course that's the prosecution's side of it, and the defense is saying, no, that's not what happened. And we're seeing what he's trying to do is really poke holes. And I'll take you back once again to those opening statements we heard, the prosecution saying, trust the blood evidence, and we've seen them presenting a ton of blood evidence. And then Juliana is our bonus, right? Juliana is the narration. She was there. She knows the story. But then we've heard John Carroll say, the defense attorney say, forensics don't lie, people lie. So I think John Carroll even brought that up even yesterday and today. He kept going back to that. The forensics don't lie, right? The forensics don't lie. And I think that's where we heard the prosecution say, right, the forensics don't lie, but the forensics don't show the full picture. We're talking about people here. Yes, there's data, there's science, but there's also people and human behavior.
Well, let's dig a little deeper into the human behavior and lying. If you're a member of the jury and sitting back taking all this in, you know, we learned through those letters, those extensive letters that Juliana wrote to family and friends and Brendan, that she was in talks with producers about potentially selling her story for money.
Right.
She was asked about that, but also the letter where she was expressing frustration about, why am I having to pay for my attorney when he's not even doing his job? And John Carroll, Brendan's attorney, asking, were you paying for your attorney? Were you paying for your legal fees? To which she replied, no. Small or big lie, I mean, that is a poke at her credibility.
Yeah, and that's his whole goal here, right? He wants the jurors to not believe Juliana. And, you know, when we were talking to the legal experts, not just yesterday, but we've had several different legal experts, and they've all been so wonderful to chat with and giving so much perspective. But one of them was talking about how, you know, he's putting the focus on Juliana. So the more attention he can put on Juliana, the less attention is on his client. And so he's really trying to transfer that energy, and that's what we've been seeing.
As we inch closer to our opening of the court here, taking you live, I want to ask you this. Remind our viewers of what our attorneys, our legal experts have weighed in about Brendan taking the stand.
Yeah, so they don't think he will. And I think they're saying, you know, does it do any good to have Brendan take the stand? I've asked each of them individually, do you think he should? And all three have said, I wouldn't put him up there if he was my client unless I had to, unless I thought he could get up there and say something. Because the thing is, if you put him up there from the defense standpoint, okay, you know, they're in control of the conversation. But then you have to allow the prosecution then to ask questions. Do you want the prosecution to ask him questions? What are those questions going to be? How's he going to react? The jury is watching every move he makes.
Every move, including the mannerisms, the human behavior aspect of it. So I know you're going to have an expert joining you, and that will be interesting to listen in on. So be sure to stick around. And you said that was going to happen during the lunch break.
The lunch break, yeah. And let's actually talk a little bit about what happened at the end of the day, real briefly, before they start back up. You know, we heard the judge. Obviously, we're here today. This is because of that impending snowstorm, and the judge made it clear that she really wants things to wrap up today. She wants the evidence to be done today. So she said to John Carroll, do you think you can complete all of your witnesses today? He said he had 2 to 3 more witnesses he planned to call, so we should be hearing from them. And then the plan is to
Looks like Judge Ascarati just took her seat and everyone is having a seat. Let's take you live inside the Fairfax County Courthouse now for day 8.
Waiting to find out some specifications, because he asked me those questions, which.
All we need is his email, and then Shannon can send him a link, and we just need to know what time, or if he's going to be prepared for whenever, we can send him the link right away.
I told him as soon as I had some sense of timing that I would let him know, and he'd say.
And that's up to you, whenever you want to do it, but we can send the link to him now.
Okay.
Do you want to give the email to?
I can definitely do that, Judge. Is it possible? I told him I would give him a call back to confirm that.
Sure. Do
Can
you
I
want to do
just
it right
step
now?
outside
Yeah, just step outside.
Okay.
Right now, that's fine. Well, I'd rather get that done to make sure we can get him taken care of. Sure. Yes, sir. Yes, sir. All right, we'll go ahead and send your witness the link now.
Yes.
And then whenever you're ready for him, if you could give us a little heads up beforehand so we can get everything set up in the courtroom. We might take a break right before that. Also, Shannon's going to ask IT to be in the courtroom at that time with the help of the remote witness. I know you have been professed as a technology guy, at least self-professed as a technology guy, but I would feel more comfortable if IT was in the courtroom to assist you with any
Yes.
matters with the remote witness.
I 100% agree, Judge.
Okay, good. All right. Are we ready for the jury?
Yes.
Okay, Detective Miller, if you want to come back to the stand. Good morning, ladies and gentlemen. All right. Your next question for Detective Miller, Mr. Carroll? Yes, sir.
Good morning, Detective Miller.
Good morning, sir.
We finished off yesterday, and we had talked about a couple of issues, and I wanted to raise those again with you. Now, when you testified yesterday, do you remember the screenshots that were shown to you?
I remember seeing screenshots, yes.
Okay. And the screenshots were relating, I think you'd called them images, correct? I'm talking specifically about the portable case information.
A portable case is not an image.
But you had referred to it as an image, because we sent you pictures.
I don't believe I referred to it as an image.
Aaron, may we approach the bench for a
right.
second? Sir, did you image or acquire all of the devices in this investigation?
Data was acquired from all the devices in this, yes, by
And
me.
did you acquire that data?
Yes, I did the acquisitions for these devices.
And did you acquire the images and all of the data that came from these devices in a forensically sound manner consistent with your training and best practices?
Yes,
Did you process the extracted data using forensically approved and verified tools?
yes,
This is the same data you produced to detectives and supervisors during this investigation, correct?
The data provided for discovery would have been the same that I provided to the detectives, yes.
Okay. So, and these were produced from the devices you acquired and they were turned over in discovery as required, correct?
Yes.
There are four open, I'm going to show you four open magnet portable case files with the court's permission on a laptop for you to be able to review. Can you please confirm that these productions are you made for the respective devices, Christine Banfield's laptop, Christine Banfield's cell phone, Juliana Peres Magalhães' cell phone, and Brendan Banfield's personal cell phone? And I'll show you this so you can make that determination. Aaron, may I?
This is fine.
Aaron, may I approach the witness?
Okay, if you, can you show what you're going to
Yeah.
show to Ms. Ann? Go ahead, sir.
Sir, I'm going to show you.
You're going to have to use a microphone somehow.
If I use your microphone. Sir, I'm going to show you some items, magnet portable cases for 4 separate extractions. And you're welcome to look and confirm for yourself. Take your time. There are 4 separate files down here. So if you'd like, you can make sure that you're certain as to what it is you're looking at. I'll step back.
Thank you.
I recognize them.
Okay. And starting with the first one, you tell me what you're on, and we'll go either left or right, depending on it.
I'm on the furthest one on the left, which is titled Christine Lenovo Repars.
Okay. And what device would that be for the ladies and gentlemen of the jury?
That was the Lenovo laptop.
Okay. And that was Christine's known laptop?
That was the device identified that she used, yes.
Okay. Did you have an opportunity to look at this is a portable case, correct?
Yes,
Okay, and this is the portable case that you provided in discovery to the defense or to the Commonwealth, and then they provided it to us?
yes,
Okay, and this is what you provided to anyone else who wanted access to it, such as Detective Bryant and Lieutenant Giacchio?
yes, this was provided for everybody for review.
Was the data that was provided in with regard to the laptop, was that the data that Lieutenant Giacchio was reviewing?
I would imagine, but I can't speak to what he was reviewing at any given moment if I'm not there.
And so when you were talking with him, was it ever discussed as to what it is that he reviewed?
There were many conversations. As far as any particular item out of any one of those conversations, it's hard to pick out, but this would have been one of the things worked off of to discuss the items.
Okay. Let's move on to the next one.
Yes, sir.
I believe in order it would be Christine Banfield's phone. Is that correct?
Yes,
Okay. And same questions. This is a portable case based upon your work extracting from Christine Banfield's phone.
yes,
And did you have enough time to look through that and make sure that that's accurate as to what your work product was?
as best I can in a short period of time. I
Okay.
can't go through every item.
Actually, to tell you the truth, if you need to go through every item in order to be able to say that's what you were working on, we'll have you do that.
I mean, this appears to be the portable case generated by me, which would have been provided.
Okay. And that's the item that, or the data that comes from that, or what you provided to the Commonwealth to provide to discovery in our, for the defendants.
Yes,
Okay. And was that, if you know, was that discovery provided to Juliana Peres Magalhães' lawyer?
I don't know personally what was provided in discovery to her attorney.
Is it fair to, well, when did you provide that to the Commonwealth?
I provided everything to the detectives, and then that was subsequently provided to the Commonwealth.
And when was the time frame for that?
For speculation?
Overruled if you can answer.
I would imagine it would be prior to a discovery order.
Okay, I'm just trying to get a timeline. How long did it take for you, if you can tell from your work product, to arrive at that data compilation?
I mean, I can tell that it was scanned in on February 3rd,
February 3rd of what day?
2023.
2023. Are you certain of that?
So when I'm looking at the case processing details on this page, I can see that that phone was scanned in by me into Magnet on 3/3/2023.
Oh, 3/3, okay, sorry, March.
I'm
3rd.
sorry.
Okay, that makes sense.
If I misspoke.
Let's go on to, and I'm sorry, let me just finish up those questions on Christine Banfield's phone. Was the data that was recovered from your extraction, was that the data that was also provided to the lead homicide detective at the time, Kyle Bryant?
Yes, everything I had was provided.
Okay. And was that also provided to whoever else was interested in digital forensics, like Lieutenant Giacchio?
I would imagine anybody who needed to review it, it would be accessible.
Okay. And did you know that, or was there any sort of protection as to that data in terms of the investigation?
As in, was the portable case password protected? Is that what you're asking?
I'm asking, was the portable case open to every police officer in the police department, or was it open to people specifically with regard to this case, or is it even smaller people that were involved in the case and only needed to see it? Do you know how it was restricted?
I would imagine whoever needed to look at it would be able to, based on what was provided to detectives.
Okay.
Judge, I am going to object to the speculation if he's imagining he doesn't
All right,
know.
sustain as to speculation.
Now, sir, let's move on to the third portable case that you created. Do you identify that?
It is titled Nanny Phone.
Okay. Would that be a title that you gave to that document in that portable case?
Yes.
Okay, so you remember doing that?
Yes.
Okay. And same questions. The data that was extracted from that, was that what you provided to Detective Bryant as part of this homicide case?
Yes.
And was that what you provided to or gave access to? And I'm not going to try to pin you down on who or what, but it sounds like it was available to anybody who wanted to look at it.
Yeah, that would be, once I pass it on, I can't speak to who else would have looked at it and when.
Okay, that's fine. And that was also, I think I may have said this, that was included in discovery or to Detective Bryant, who would have given it to the Commonwealth for discovery, correct?
I would imagine so, yes.
Okay. Now, and just to be consistent, this would be what Detective Bryant could have looked at and Lieutenant Giacchio could have looked at.
Judge, objection asked and answered. He indicated he gave it to Kyle Bryant. From that point forward, it's accessible. He doesn't know who else saw
Asked and
it.
answered is all I need. Thank you. I'll sustain the objection.
Fine. If it's asked and answered, that's fine, Judge. Can we move on to the fourth item that you're looking at there?
Yes.
And what is that?
It's a Samsung Galaxy S23 Ultra.
And who is the owner of that?
Let me look real quick. I believe this is Brendan Banfield's phone.
Okay. And same questions. You extracted data, and this is the source of that data, correct?
This was what was provided to the detectives, yes.
Okay. And describe what a portable case is for the ladies and gentlemen of the jury.
A portable case is a report that is generated through a forensic tool called Magnet Axiom. It is a way for the information that is in Axiom to be put into a readable format, similar to Axiom, but not quite as robust. But it's in a format that someone would be able to navigate in a more user-friendly method.
And once you do your extractions, is this the format that you would rely upon in answering questions that may come up, things like that?
I think that would depend. If there are certain things that are better able to be seen in Axiom itself versus in a portable case, but again, the data is in here.
Okay. Would you utilize that as a resource if you needed to know something about the data that was in there?
Yes, I would use this to search for information.
Okay. Your Honor, I'd move the first file, which would be named 120, Defense Exhibit 120, which would be the portable case for Christine Banfield's Lenovo laptop.
All right, any objection?
Judge, is counsel going to be able to share that with the jury?
You're not publishing it this time, just into evidence, is that correct?
Yes.
Any objection?
Can we approach?
Okay. All right, 120 in evidence.
Sir, moving on to Christine Banfield's phone, which would be the second file that we reviewed. Your Honor, we'd move into evidence as exhibit number 121.
All right, any objection?
No, ma'am.
Sir, the third portable case that we've just discussed is named Nanny phone, correct?
Yes.
Your Honor, we would move that into evidence
Any objection?
pursuant to
No objection.
as defense exhibit 122.
122 in evidence.
And sir, the last file, which you've identified as Brendan Banfield's phone, Your Honor, we move that in as defense exhibit 123.
Any
No objection.
123 in evidence.
Court's indulgence.
Yes, sir.
Your Honor, I don't have any further questions
All
for
right.
Detective Miller.
Cross-examination?
No, ma'am. Thank
All
you.
right. I hesitate to ask if he's subject to recall.
Potentially subject to recall,
Okay.
Judge.
All right, sir, since you are subject to recall, just do not discuss your testimony with anybody at this time, okay?
Yes,
All
Your
right,
Honor.
thank you, sir. All right, your next witness.
Your Honor, I'd recall Harry Lidsky.
Okay, can you retrieve his laptop too? Thank you.
Can we leave that there, Judge?
Oh, you need that? Oh, never
Yeah.
mind, sorry. All right, he's already been sworn. All right. Sir, just a reminder that you're still under oath, okay? Of
course.
All right, thank you.
Sir, calling your attention to what has been moved into evidence as Defense Exhibit 120, 121, 122, and 123. Are you familiar with those exhibits?
I am.
And have you had an opportunity to review those exhibits?
I have.
And state to the ladies and gentlemen of the jury, what did you do in your review as a digital forensic examiner?
Well, as Detective Miller indicated, these portable cases facilitate everybody to visualize the data from the respective devices, ourselves included. We use these, and we're able to look at both user accessible files, like what you would see on your phone, and we're also able to see the data behind the data frequently, which can be informative depending on the nature of the investigation.
And do you understand these items to be verified data extractions performed by Detective Miller using appropriate tools and best practices?
I do. I've reviewed his reports and came to the conclusion that he did everything exactly the way he should have and the way he was trained to do it, using the tools that are approved by the industry and accepted by the courts.
And do these items, specifically the exhibits, provide us an opportunity to review the raw data extracted from their respective devices in a forensically sound manner?
They do. So the nature of the case, in addition to giving us visibility, bless you, into all of the data on the device, we can't alter anything, and that's what makes it forensically sound. That's what the term, how the term is defined. So anyone using this can't add anything. We can't delete anything. We can't change anything. If there was a virus on the device, it stays sandboxed within the case. It does not spread to our computers. So it's helpful in a lot of ways.
And so is this considered a safe environment in the world of digital forensics?
It is, and that's the nature, the forensic and forensically sound. It prevents, it's not like blood evidence, but it prevents cross-contamination so that what's on here is on here exactly the way it was when the device was either imaged or acquired when Detective Miller did it back contemporaneous to the event back in 2023.
Based upon your review of this data, were you able to draw any opinions related to this case?
I was.
And what were those opinions?
That catfishing did not occur.
And did you produce any demonstratives that you can display to help walk us through your findings?
I have.
Aaron, can you display to counsel and the witness?
There's nothing on the screen at the moment.
I'm connecting, sorry.
There you go. Well, I have your screensaver. Okay.
Thank you, Aaron. Sir, the items that we're about to show relating to your findings, the digital forensics have been identified in the stipulation documents, correct?
They have.
And did that include Brendan Banfield's phone?
Yes, it did.
And Christine Banfield's phone
Yes.
and the laptop?
Christine's laptop, yes.
Juliana Perez Magalhães' phone?
Yes, among other devices, but these are the 4 central ones I reviewed,
Social media records from Google, FetLife, Facebook, among others?
among others, yes.
Video from surveillance?
Yes.
Judge, objection leading?
All right, sustain is deleting.
What, if any, items were related to surveillance?
There was some video surveillance. There was electronic and physical surveillance involved in this investigation. That's all that comes to mind with regard to surveillance.
Did you rely on any interviews?
I was made available to the entire investigation. That included videotaped interviews of the co-defendant, Ms. Magalhães, both transcripts of interviews that she conducted with the police, with the Fairfax County Police, interviews of witnesses, as I think Detective Smith testified to yesterday, like neighborhood canvases, notes, things like that. I've reviewed everything in this case.
Okay. I'm going to show you a slide. And Your Honor, we're just trying to determine what our previous number was for it.
What, if you show it to me first, and I
Yes.
can let you know. Let me see. All right, I have it as 86.
86. And I believe 86 was...
It's not in evidence.
Not in evidence. Sir, can you identify...
Is it a different number? I'm
this-
sorry, just hold on.
Judge, I had, sorry, I'm scrolling back to 86. I was under the impression this was likely
Okay.
110.
This is your first slide after the
After
the titles page?
the title page,
This is the first one
Okay.
you have.
first one.
And that's the first one you started with him when he was originally on the stand?
Yes.
Okay.
Yeah.
Your Honor, if I may?
Yes, sir. Is it-
It's changed a little. This is
Okay.
technically
So it
new.
is different,
It is
okay.
different, yes.
All right.
Well, then,
Okay,
we'll-
so.
Apologies.
Okay, so this was not the first one that you had seen?
It's
The second or third?
it's a change of the first. It eliminates the
So this is not
party
85
number.
at all, so if you want to give us a new number.
I think it's new.
124, Judge?
Let's give this a new number then.
So this, Your Honor, we identify this as Defense Exhibit 124.
Okay, thank you.
Sir, do you see the slide here?
I do.
And what does it reflect?
This is a Facebook message sent by Christine Banfield.
And what, if anything, did you look at to determine this slide?
Even though it's a Facebook message, this was recovered from her mobile phone. So a lot of the data on our phones can occur in multiple places, right? So our email is on our phone, but it's also on the server of our respective email provider. This is a Facebook message. It likely is or was on the Facebook server, but this particular message came from her phone.
And was the phone one of the things that the portable case that was moved into evidence through Detective Miller?
It was. I believe this was 122.
Okay. Your Honor, I move Exhibit 124 into
Any
evidence.
objection?
Objection hearsay.
All right, hearsay?
Sir, Your Honor, I believe this is an artifact of the portable case.
You've
Which,
got past the foundation. I agree with you. But now that we're past that hurdle, the next hurdle is hearsay.
and Your Honor, I think this is an artifact, and it's for whatever it is part of the portable
I'll
case.
sustain the objection to hearsay.
Sir, can you look at what would be marked as Exhibit 125?
That's in evidence.
Yes.
Hold on a second. That's already in evidence. Okay, so
This particular,
I think that is in evidence as 110.
No, I have it as 109, and then yesterday he clarified for the record, they use as 109.
I'm sorry, I can't.
She said
Okay,
this was clarified as 110.
110, that's what I have it as well, 110. 110 in evidence. Yes, so it's already in evidence as 110.
sir, what is this artifact? Or can you explain what this is?
This is a calendar entry, a saved calendar event from Christine Banfield's mobile device or phone.
Okay, and is there anything notable in that artifact?
The date,
Okay, and any other aspects of the calendar entry?
it's what you'd expect, I think, from a calendar entry. It's a date and time. It was on Mrs. Banfield's phone, and the Gmail account associated with it was the one that I believe was hers, attributable to her.
You're all right. I believe that was admitted as
It
Exhibit
is, and it's already
110.
being displayed to the jury.
Okay, thank you. Is there anything else about that particular artifact, Mr. Litsky?
Was an estimate for 10 a.m. for windows. I could talk about why I think that might be informative.
Why would that be informative?
Objection, Judge. Calls for facts not in evidence.
Overruled, I'll allow it.
Well, from the information I reviewed in the case and the testimony this week and last, the window replacement was a topic at the window replacement at the Banfield house was a topic discussed. I think this reveals that the window replacement project was, number one, dates back to 2021, far earlier than.
Objection calls for speculation. This particular document just says estimate 10 a.m. windows. We don't know if they had other window replacement projects.
I'll sustain the objection.
So in 2021, Christine Banfield was scheduling a window estimate at 10 a.m.
Okay. Sir, I think this might be 111, Judge?
I don't think this,
112.
Thank you, Sylvia. He owes you something at the end of this. All right, 112. And it's not in evidence.
Sir, do you identify this
No.
slide?
No, Judge, this was previously offered and denied.
It's not in evidence.
Correct.
Right.
So
It was previously offered. We'll see what happens. Okay. Go ahead, sir.
Sir, can you identify this?
Yes, these are messages sent by Christine Banfield from her device, excluding any other party.
And what is notable within these messages?
Their discussions about having the windows
Judge,
replaced.
objection. He's testifying to the subject matter.
All right,
It's hearsay. It's
sustain the
denied.
objection.
What about the date and time?
These are from June 28th, 2022.
Sorry,
You just changed
I know,
these.
sorry. My big fingers.
There you go.
Sorry, did you see that before my fingers caused it to go?
Yes, these are from mid-2022, late June.
And sir, do you see the item on the screen?
I do.
Okay, and what is this?
More messages from Christine Banfield.
Objection as to the hearsay. He cannot testify to what's in the document.
What's notable about the date and the time on this particular message?
Is this 114?
It should be, Judge.
I just want to make sure, for the record. It's okay, this is 114.
114.
These are from December 3rd, 2022.
just approach for a moment? Your Honor, I'd move to enter Defense Exhibit number 114.
Objection, hearsay.
All right, I'll sustain the objection.
And sir, as to the windows, did the information that you received as an expert in forensics, digital forensics, did that inform your opinion?
It did.
Okay, and what is your opinion about the window replacement without getting into the hearsay statements?
That the project originated,
Objection, judge calls for speculation. To refer to it as the project assumes that he is correlating this information with what occurred that's been admitted into
You
evidence.
want to rephrase?
I'll
That's
rephrase. With regard to the subject of windows, without specifically talking about a project, what does this indicate to you and what conclusions can you reach?
that Christine Banfield contemplated or explored window replacement in 2021 related to issues of age and condition of her existing windows.
Judge, objection, he's testifying to the content.
all right. He gave his opinion. All right.
Yes, yes.
Next question.
I think you just have, what's essentially, you can't go with the writing that's on there. Thank you. Now, sir, I'm going to show you what will be marked
125.
Your Honor, I believe defendant's 125.
Okay.
Sir, do you see the picture on the screen there?
There's no picture.
It's text. But yes,
You see that?
I do.
Okay. Does Your Honor see it?
No, you have to go to the next slide, I think, is what you're trying to get to. I mean, all we have is writing. Is that what you're talking about? Or
Yes,
You want a
yes.
picture?
It's a picture of writing.
Okay, it's writing. Okay, that's what he said. Okay, 125, okay. Yes, we can see that.
Okay. And you just see that, correct?
Correct.
And was this something that you reviewed in discovery to inform your opinions relating to the date that it shows on there?
This is something I reviewed from discovery. I read it after my opinions were formed.
Okay, so let's just make that clear. And I think you had testified before. In what order did you review the items in evidence versus Detective Miller's findings?
I performed all of my work first before looking at Detective Miller's findings.
And so is this something that you looked at after you had arrived at your conclusions?
Yes.
Okay. And is this something that you relied upon in arriving at your conclusion today?
I didn't rely upon it. I have it here because Detective Miller said it in a way that it was both accurate and succinct. I couldn't do much better, so I copied his work.
Okay. And in terms of how would you characterize, so what is this part of, this particular statement that's before you?
Objection, if he's going to testify to anything that's contained in the document, regardless of whether or not he copied it, it's hearsay.
All right, I'll sustain the objection.
What document is this part of, a part of that you're looking at?
This is from Detective Miller's executive summary.
Okay, and did you hear any evidence in the court relating to Detective Miller's executive summary?
I did.
Okay, and who were the witnesses who were speaking of that?
Detective Miller.
Objection, calling for hearsay. The jury had the opportunity to hear the
All
testimony.
right, I'll sustain the objection.
Do you recall who, well, okay. Is it fair to say this was mentioned in court?
Yes.
Okay. And sorry.
126?
Sorry, Judge, I just,
Oh,
a little premature, I was
All
getting
right.
it ready. So to avoid hearsay, because this is a written document, can you tell the ladies and gentlemen of the jury how how this affected your conclusions as a result of your examinations?
This didn't affect my conclusions other than to corroborate them after I was done, seeing that our findings were aligned.
Okay, and do you agree with what you see on the screen here that's hearsay that the jury can't see?
I do.
Sir, do you see the next slide on the screen?
I do.
And if you can describe what you see there on the screen.
Judge, I'd object to any description of the content, hearsay.
There are pictures there, Judge.
So if you could just maybe limit it to the pictures.
Okay, let's start with the pictures.
Okay.
Do you recognize those pictures?
I do.
And are those pictures that you were able to identify independently within the data that was provided in discovery for the defense?
Yes, I was.
Okay. And if we can look at the first picture, do you have any idea based on digital forensics where that picture was taken, or actually not where that picture was taken, where that picture came from?
The picture on the left?
Yes.
The picture on the left came from Christine Banfield's phone.
And the picture on the right?
Also.
Okay, and what processes did you utilize in order to reach those conclusions?
Well, as I was reviewing the data from Ms. Banfield's phone, I found them. They were familiar to me because I had seen them from other sources, such as search warrant returns from FetLife. I'd also seen one of them in Facebook returns. That a return is data provided by a service provider in response to a warrant. So I'd seen them both from multiple sources.
And the one on the left that you've identified, is there any way to know the timing of that based upon your analysis?
I believe it was January 17th, around 8 p.m.
And January 17th is significant in this case.
Objection,
what?
counsel's testifying.
Sorry. What's the significance of January 17th in terms of the issues in this case?
Yeah, and the photo, I believe, was actually closer to 7:30 or 7:20. January 17th was the day that the FetLife account, which is obviously important in this investigation, was created. That is the user profile. Somebody set up an account on FetLife, and one of these pictures came into play.
So let's take this opportunity to talk about the accounts that were set up that were alleged to have been run by Juliana Peres Magalhães in her recant. What were the accounts that we're talking about?
So there's 3 accounts. There was the Gmail account, there was the FetLife account, and then the third would be the Telegram account.
And can you explain to the ladies and gentlemen of the jury, what's the significance of those 3 accounts and how are they linked?
So each account is linked to at least one other account, and that's significant for me as a digital forensic examiner because it's sort of a one or done. And the way the accounts were set up, so the Gmail account was set up first. The Gmail account was used to set up the FetLife account. So you couldn't set up the FetLife account unless you knew about and had access to the Gmail account. To have access to the Gmail account, you'd have to know it existed, and then you'd have to have the password to log into it. So the Gmail account sets up the FetLife account. The FetLife account was used to move conversations over to Telegram. So all 3 accounts are linked, and anybody that had knowledge of any one of the accounts owns all 3 of the accounts. You couldn't use one without the other. You couldn't jump into a Telegram conversation without knowing first how it began from FetLife, and you couldn't get into FetLife without...
Judge, I'm going to object to the speculation, wouldn't be able to, there's no foundation for that.
All right, I'll sustain us to that, just that part.
Okay. In terms of the objection relating to foundation, what did you rely upon in order to inform those opinions that you're telling the ladies and gentlemen of the jury?
The content of the data within the accounts and my knowledge of how accounts work in the FetLife responsive documents from the Fairfax County Police Department search warrant. It says right in there that the user email associated with this is the Gmail account. So the user connected the accounts. The Telegram connectivity is based on the content from the FetLife messages. Please contact me. Do you have Telegram? Please contact me there.
Sir, I'm going to have you look at the next slide. Is this the foundational artifact that supports your testimony to the ladies and gentlemen of the jury?
So this is a picture that Ms. Banfield took of herself on the evening of January 17th.
Your Honor, I'm sorry. Is that 115?
This would be 127.
127. Your Honor, I move that in as Defense Exhibit 127.
Any objection to 127?
No, ma'am.
Okay, 127 in evidence, so you can publish it to the jury.
And so if you can just if you can just explain to the ladies and gentlemen of the jury what the artifact, what's the significance of that artifact and what you took from it to arrive at your conclusions.
So it's a picture, obviously, of Ms. Banfield. I'd characterize it as a selfie in the mirror. The file name and date, or the file name, that's what I'd call a typical Samsung or Android file naming convention. So in line with what I'd expect to see for a picture taken by a Samsung mobile device. At the very bottom of the screen, you can see that it is a Samsung phone model SMG991U. The dates and times, the date and time here that's relevant is January 17th, 2023 at 7:20 and 45 seconds p.m. If you look at the file name 4 lines above, that is the typical Android file naming convention, and that's comprised of the date. So we see 2023-0117 underscore, and then 1920, which is 7:20 in 24-hour time.
Now, the software and the make and the model, is that significant? Does that corroborate anything that you've identified?
Yes, the make and the model is corroborative. This phone was, in fact, a Samsung SMG991U, which informs me that this picture was actually taken in what we call native to the device. So it's a photo both contained on the device, but taken by that device, rather than one you'd get in a text message or email as attachment.
Your Honor, I don't believe I've previously identified it, but I would put it in as Defense Exhibit 127.
This one, it's already been, and it's been published for the last.
Okay, I'm sorry. I just want to make sure I'm covering my bases.
Okay.
Sir, I'm going to have you look at this item. Do you see that on the screen?
I do.
And are those digital artifacts that you relied on in arriving at this?
You could call them.
Describe what you have, what you see in that slide.
So this is part of the responsive documents received in this case from Facebook. And so the information, it is digital, it is artifacts, but it's not recovered from a device so much as from provided by Facebook from their servers.
Okay. And did you create this slide?
I did, yes.
Okay. And what's the significance of the notations on the left side? Actually, Your Honor, I would move to enter into evidence. I think Defense Exhibit 127?
128.
128.
128. Any objection to 128?
No, ma'am.
All right, 128 in evidence published, please.
Sir, can you explain to the ladies and gentlemen of the jury what those markings are, both on the left side of the picture and below the picture?
Yeah, so as I said, this is information that was provided by Facebook. This is where Christine shared this photo with Brendan. Just starting at the top left and working down into the right, the author, Christine Banfield, so it was sent by her from her account. It was sent on the service providers, in this case, almost universally, provide us with documents in UTC, Coordinated Universal Time, versus or Greenwich Mean Time. So it needs to be adjusted. So this in February, or January, I'm sorry, we need to subtract 5 hours. So that's why it's appearing as January 18th instead of January 17th. But January 18th at midnight and 20 seconds, midnight and 20 minutes is actually January 17th at 7 p.m. and 20 minutes here on the East Coast. So she sent it, and the body of the message she sent was new bathing suit, including, and the artifact below that is just the attachment, which is this photo, and the name that, the associated data that Facebook includes with that.
So let's just have a little discussion about UTC time. You called it Greenwich Mean Time, correct?
Objection, mischaracterization. He said that it is universal, and it is a 5-hour difference. I believe it's been asked and answered.
I think he can explain it, but yeah, go ahead.
Okay. I'm sorry, was that a stipulation that it's a 5-hour difference?
Yeah, absolutely.
Okay. And so we don't need to explain too much now. Why are some items in UTC time versus present time?
My experience and what I believe to be the reasons, and this is universal with service providers from my experience, Google, Facebook, phone companies as well, they just provide everything in UTC time. So they provide it in one time zone and you have to do the work. Otherwise, they'd have to send records to Fairfax in East Coast time. They'd send them Chicago in Central time, LA, and they're providing records to law enforcement and legal counsel all over the world. So they just send it as UTC. That's, I think, why UTC exists, sort of to give us all something we can all start with and work with personally from there.
Thank you, sir. Can you look at this next slide?
Yes.
Is that something that informed your opinion that you've been telling the ladies and gentlemen of the jury?
Yes, this is a digital artifact from a laptop.
Okay. And is that the laptop, Christine's laptop, that was introduced into evidence through the portable case with Detective Miller?
It is.
Okay. And can you explain, Your Honor, I've moved that in as Commonwealth's Exhibit 129.
Any objection?
No objection.
129.
Sir, can you explain to the ladies and gentlemen of the jury what that is and how that's significant?
Sure. This is a Windows event artifact. It contains the security identifier. So for Windows computers, every user is assigned a security identifier number, and that's the long number we see on the second line down, ending in 1001 on this case. So that just informs us of which user profile was active at the time that the activity took place. So a computer, if you have a shared computer in your household with 4 people, each one will have their own unique security identifier, and that's what you get when you log into your profile, and that's why your things will come up, your information, your email accounts, versus somebody else who might be using a shared computer. It could also be in play with, for work computers that are shared as well.
Oops, sorry.
Sorry, the time and date are just that, and these have been, this is in East Coast time because of where the computer is located. And down to the bottom, the third line up, just tells us what this event represented, and this is just simply a log on to this device by that particular user with the security identifier of 1001.
Sir, I'm going to have you take a look at this slide. Is this a slide that you created for this presentation?
This is a screenshot of an artifact from the same computer.
And what's the significance? Well, Your Honor, I moved this in as Commonwealth's Exhibit number 130.
Any objection?
No objection.
130?
Sir, if you could, go through this. What is the significance of this artifact in terms of a digital forensic analysis?
Similar to the last, this is just another standard Windows event that we often see when a computer is either powered on or logged onto. So the time of this, if you want to compare it to the slide before, is likely within milliseconds. A lot of things happen when we start our computers that go on in the background. The previous slide was the user logging into their account. This is just reflective of the computer probably almost immediately joining the Wi-Fi account for in this case, what I know to be the Banfield home.
Your Honor, with the court's permission, he's referenced the previous slide. I'm going to put it back to the previous slide.
129 is in evidence, so you can go back to 129.
So that's the previous slide. Can you just highlight what it is you were talking about in terms of the timing?
Yeah, so if we look at the created date time.
Judge, the Commonwealth will stipulate that they show the same time.
Okay. Stipulation that it shows the same time. Thank you. So is there anything additional that you need to testify to about that slide?
No.
Do you see a slide before you?
I do.
Okay. Your Honor, that would be identified as Defense Exhibit 131.
All right. I'm just making sure we didn't see it yesterday. I'm not sure we did. So we'll make it 131.
I don't think we did, Judge.
Okay, 131.
May have.
Sir, do you see that?
I do.
Okay. And if you could just describe, was this something that you utilized in your forensic analysis of this case?
Yeah, I think there are other images that are associated with this that will come up in progressive clicks, but this is using artifacts from the laptop that I examined, or the portable case that I was using to examine artifacts from within the laptop. This is a sort of sequencing of events in chronological order, and that's, I think as I described before, something we do looking backward in time and following events on a device might help inform who was using the computer, and certainly the time and date and what they might have been doing.
Your Honor, I move this in as Defense Exhibit number 131.
Any objection?
No, thank you.
131 in evidence.
If you could please publish that to the jury. Sir, can you just explain, they didn't have that on the screen when you were...
Sure. These are the artifacts that I've located on Ms. Banfield's laptop, and this just shows that shortly after the computer was logged on and joined the Wi-Fi, that she opened a browser and navigated to or viewed a Google website and her email
Judge,
inbox.
objection calls for speculation. He doesn't know who it was that looked at anything. He can tell us what the computer did.
All right, I'll sustain the objection.
The person whoever was using the computer opened a Google website and Google inbox related to Ms. Banfield.
And sir, what's the significance of the email, the Gmail account that's identified in the second line there versus other Gmail accounts?
So this one became known to me through my review of all of the evidence in the case as Ms. Banfield's sort of go-to email account. This is not the alleged suspect email account that we talked about as being formed on January 9th.
And what was the alleged suspect Gmail account that you referred to?
That was the one that was used to then set up the FetLife account in Telegram. It's the account, the alleged suspect Gmail account was the one that received communication from FetLife, both the FetLife service provider and from users wanting to message through that account.
Okay. Sir, I'm going to show you this next slide. Do you see that?
I do.
Your Honor, I'd move that in as Commonwealth's Defense Exhibit 132.
All right, any objection to 132?
No objection.
All right, and evidence can publish?
And so tell the ladies and gentlemen of the jury what this is.
So again, chronologically, this is, it looks like just under a minute later, whoever was using this computer was now able to see the draft email box within their Gmail account, the Ms. Banfield's Gmail account, also the sent email box or account messages from Ms. Banfield's account.
And where are the sent emails that you're referencing?
It's the now fourth line down. You can see on the title of the slide, also on the left-hand side for the URL, that's just showing that the sent mail box or tab was open at this time.
Okay, and the draft mails are the one, well, you tell me. I'm not going to.
Yes, the draft is right above it. Usually parenthetically, when there's a number there, for us email users, that reflects the unread messages in the respective accounts.
Your Honor, did I move that into evidence?
That's in evidence already.
Okay. Sir, do you see this new slide, which is incorporating the old slide?
Yes, I do.
Okay, and what's the significance of that? And then if you identify it, then I'm going to move it into evidence. So just identify that as a slide, and Your Honor, I'd identify it as Defense Exhibit 132.
133.
133.
Any objection to 133?
No, ma'am.
Okay.
Again, just chronologically, this is more activity shifting away from one service provider to another, from Gmail to Facebook in less than a minute.
And the timing is in the second column?
It is. So this would be January 17th at 10:01 and 10 seconds p.m.
Okay. Sir, I'm going to move on to the next slide. This will be identified as Defense Exhibit 134.
Any objection to 134?
Sorry, Judge, if I just have a second. Judge, I understand that the slides are just successive.
The only new thing is the artifact information.
Right, we're just adding one item at a time.
Is
Oh,
it-
okay,
No
sure.
objection?
No objection.
134.
Sir, as Ms. Sands said, this is a progression of items, and there's a new portion. Can you describe what that is?
Yes, so this is artifact information relating to the login of now the alleged suspect Gmail account. So we can see down at the bottom of the highlighted section, this is CBRN 920 at Gmail. That's different from the email that we see at the top of the screen for C. Banfield. So this is significant because now, again, we're talking about a login to the account that's central to this investigation. So whoever was using the computer at this time at 10:03 and 4 seconds was clearly aware of the account and had the credentials because this is a successful login.
Sir, do you see that slide, the new slide?
I do.
Okay, and there's, as said before, there's one additional piece of evidence there. Is this something that you created and something that you relied upon?
It is.
Okay, Your Honor, I move that in as Defense Exhibit 135.
Any objection?
No.
135.
Sir, if you can explain to the ladies and gentlemen of the jury the significance of this in terms of digital forensic analysis.
So the content to me is not as informative necessarily as the sequencing. So We had Facebook at 10:01. If we look just above the Google login we just discussed, or the Gmail login we just discussed, we have the Gmail login at 10:03, and now we're back in Facebook at 10:03 and 35 seconds. The significance of the highlighted portion in the last artifact, or the newer one that we're reviewing, is that we're looking at a media attachment within Facebook. Obviously, for any of us who use it, there's a lot of different things we can look at, but in this particular one, we were looking at a media attachment.
Sir, if you could look at the next slide, which would be identified as Defense Exhibit 136. Please explain to the ladies and gentlemen of the jury, is this something that you relied on in your digital forensic analysis?
Yes, it is.
Okay. Your Honor, I move that in as
Any objection?
Defense Exhibit 136.
136 in evidence, publish.
Go ahead, sir. Can you explain to the ladies and gentlemen of the jury what this significance of this in the line of messages?
Yeah, so as we might imagine, as we do things on our computers, things happen in rapid fashion, and when we slow down and sort of look at what's happening on the back end and visualize it that way, it seems to make sense. So just before this, at 10:03 and 35 seconds, we are looking at a media attachment, what I believe is a photo on Facebook. And then 5 seconds later, at 10:03 and 40 seconds, we have a download of a photo in the Chrome browser that was being used at the time. And this is a download to the computer.
Thank you, sir. I'm going to ask you to identify as Defense Exhibit 137. Can you look at that, sir?
Yes, I can.
And is this something that you analyzed and created as a result of your digital forensic analysis?
It is.
Your Honor, I move that in as Defense Exhibit 137.
Any objection?
Nope.
137 in evidence, publish.
Sir, can you give some context, or can you explain to the ladies and gentlemen of the jury how you obtained this and what the significance of it is?
Sure. So again, each of these is building on the previous artifact, but so at 10:03:40, we had the photo downloaded to the computer. At 10:04 and 23 seconds, so under a minute later, that same photo is emailed as an attachment from the alleged suspect Gmail account to the alleged suspect Gmail account. And the email attachment, if we look at the file name on the very bottom that ends in 1973_n.jpg, we can see that that's the same file that was downloaded from Facebook 2 lines above it at 10:03 and 40 seconds.
And sir, this is identified as Defense Exhibit 138. Is this highlighting what you just said?
It is. This is just drawing attention to the fact that we're correlating now the same photo, and this is one of the things we do in digital forensics. We can follow an artifact around as it goes, and that can be informative.
Your Honor, can I move that in as Defense Exhibit 138?
Any objection?
No, Judge.
All right, 138.
The ladies and gentlemen just see that. Do you want to direct them as to what the change is in this?
Oh, I'm sorry. Yeah, this is just the annotation I described, just showing that these two artifacts are linked. The download,
Sorry.
it's gone.
I
There it is.
I'm a big fan.
The download a minute or so before the email.
Okay, thank you. Sir, I'm going to have you look at the next slide, which will be identified as Defense Exhibit 139. What is that?
These are WhatsApp messages from Ms. Banfield's cell phone.
Okay, and what, if anything, how did you arrive at, how did you get these digital forensic artifacts?
From the review of the data provided from the portable case related to Ms. Banfield's cell phone.
And, Your Honor, I move this in as Defense Exhibit 139.
Any objection?
No.
139?
Can you explain to the ladies and gentlemen of the jury of what the significance of this communication? And am I correct, this is all on January 17th?
This is on January 17th, yes.
Okay.
So I think as Detective Miller said rather well, context matters, context is helpful. So we don't, to help determine user attribution, which is always the big question for us in the digital forensics field, we don't just look at one device, we look at everything we possibly can to inform what a person was, where a person was. If someone's device is being used by someone other than the owner, if they're physically removed from it, we can draw that conclusion. So I was simply looking at Ms. Banfield's phone at the same time frame that I was looking at her laptop, so we can see the date is January 17th, and the timing is right around the same time that we were looking at from the computer a moment ago, right around the early 10 o'clock hour.
Sir, I'm going to move to the next slide and have you take a look at that. Can you identify that slide?
I can.
And just to be careful here, is the left side of the slide what was on the previous slide, 139? Were those the communications that you were talking about on the previous slid?
Yeah, so.
Do you want me to go back so you can see it?
No, I have them both.
Okay.
Would you like me to describe this?
If you could describe it.
Yeah, so one of the things that the forensic software allows us to do is both look at the artifact in sort of a raw form that might be useful for us, but it also allows us to visualize a conversation just like we would on our devices. So we'd have, sort of a comment bubble or a chat bubble on the right and the left as we talk with somebody.
Okay.
So it's just a visual representation of the same data.
And so without getting into the conversations, were you able to determine that a conversation took place?
Yes.
Okay. And were you able to determine who the conversation was between?
Yes.
Okay. Your Honor, I'm not going to present
It's
that.
just ID'd as 140, that's fine.
140, okay.
Is this a good time for a break, Mr. Carroll?
It'll be fine, Judge.
Okay, all right, let's go ahead and take our 15-minute recess at this point. Please do not discuss the case with anybody and don't do any outside research, okay?
Okay, we have been watching day 8 of the Brendan Banfield murder trial out of Fairfax County. Court got underway shortly after 10 a.m. and we heard from two of the individuals we heard from yesterday called back on the stand. And for me, it felt like they were challenging the digital forensic evidence from both sides, prosecution and defense. What have we learned so far about the evidence?
Yeah, first we heard from Brendan Miller. He's the detective who was the focus of yesterday's entire testimony. We heard from 8 people yesterday, and everyone was talking about Detective Brendan Miller's forensic digital findings. And
Yes,
his
it was all
conclusion,
surrounded
right,
around his findings.
and his findings that he did not believe Christine ever lost control of her devices. The reason this is so important is because the prosecution's whole theory is that Brendan and Juliana set up a Gmail account,
catfishing
a
theory,
Telegram
yeah.
account, and a FetLife account. And those 3 counts are important, as we heard the past few hours, hour and a half, really. It feels like so much longer, but it's important because the prosecution has said Brendan and Juliana set all of that up and set Joseph Ryan up to look like he was the one who killed Christine, that Christine invited him to the home.
Which is the catfishing theory, that Christine was not behind the accounts. But Brendan Miller, who has been called back to the stand, his summary is that, or his findings, is that she never lost control of her devices, which is critical for the defense. And both sides have spent, time challenging it, and really the integrity of this digital evidence. We learned there were a total of 3 accounts. It was Gmail, the FetLife, and the Telegram account. And Mr. Litsky was going on to say that in order to, the Gmail account was created, and then the person used that Gmail account and password to then create the FetLife and the Telegram. So it was all linked.
Yeah, his
together.
exact quote was, "You wouldn't have access to one without access to the other two."
That's
so that
what
was
he claims,
He's
right?
saying, and just for some context on who he is, he's a private investigator. He was originally called to the stand not yesterday, but the day before, and he was called to the stand to analyze Detective Miller's findings. He then was taken off the stand, and Detective Miller was brought back on the stand to explain his own findings. So it's interesting that they brought him up here again, because we spent much of the morning, all day yesterday, hearing from Detective Miller about his findings. So to have Harry Litsky, who's a private investigator who specializes in forensic analysis, coming up and talking about this, it's interesting. He's been showing a lot of the screenshots. Let's go back probably to the beginning of when he came up to the stand. He was showing some of the conversations that he was able to track down, and one of the big ones was involving those windows. We've been talking about the windows,
The
and
window factory.
The window factory, the gentleman who testified that he had helped the Banfield family reinstall brand new windows for the entire home. Triple pane,
right?
There we go. Triple pane windows, which
And just a little context here, we're not window experts, but we got a glimpse of it. Most people who look into these windows are satisfied with double pane windows.
According to him.
According to our window guy. But he was saying in this case that they were shopping for a triple pane, which I think it was 30% additional coverage of sound and energy. Yeah, sure. So, but yes, we heard the window situation come back up, that it was scheduled for 10 a.m. on the date of, it dates back to 2021, that Christine's phone showed evidence that someone corresponded with the window company for scheduling a window estimate. Yeah.
So
to which the prosecution objected.
Right. So I guess the thing is going back to Brendan Miller, right, where he said he's able to attach devices and he's connecting devices to activity, but you can't connect a device to a person per se, because unless you're sitting next to them, seeing that they are physically holding the phone, we were talking about it during the hearing. So many people have access to our phones. I mean, your loved ones may have your passwords, right?
My daughter has my passcode. Anyone can get into it. I mean,
so that's
when I say anyone, my immediate family.
Right, so that's why the prosecution is saying, unless you're in the room, though, you wouldn't know who has whose phone. So it's interesting to see this continue to be the conversation. But that window one's important, not just because of the window expert, because Juliana testified that the window, soundproofing the windows, was part of Brendan's plan.
Yes.
That plan, going back to that.
Yeah. Okay, well, speaking of interesting, we also heard that it is quite possible that Brendan Banfield may take the stand. Now, whether that's today, we're not sure, but we are on good authority that this could happen, that Brendan Banfield could take the stand. So we'll be watching this closely. Stick with us, continue to stream. And while we're on this break here with the court, probably resuming in about 10 minutes or so, let's talk about also more about Mr. Litsky's witness statements, because he really got into the weeds of the digital footprint of what time and what day and who this was sent to. Those are critical pieces to the timeline.
Yeah, and I think it all is going to, though, we keep hearing these main points given, and then we go into the weeds, but then they get back to those main points. And his main point is that these 3 accounts are connected. And if somebody was accessing one of those accounts, then they knew about the others. So he's trying to show different snippets where Christine, her phone was used, and it appears
there was a picture.
Right,
I mean,
a
we
selfie.
We saw Christine's picture there. She was in a bathing suit, and she apparently snapped this photo, and it was sent to an account
on Facebook.
And it was, captioned "new bathing suit." To me, and this is just my personal opinion, it didn't seem suggestive or sexual in any way. I mean, you could have been sending that to a girlfriend. I don't know how critical that piece is to this, but I think his point was just trying to prove that this picture was taken from her device, and on that same day, it was then sent directly from her device to this Facebook account, right?
Yeah.
Or Facebook message.
So he pulled up all the data to the photo. And so I'm not sure that everyone knows this, but when you take a photo, your phone captures all this data about it. So when you send that photo to somebody else, it'll show in the data, when you go back into the metadata, you can see that the photo was taken by this person, what phone is attached to the photo. You can see when it was taken, what time, sometimes the location, depending on what settings you have. So he's going in there and analyzing the photo, and per his analysis, I'm struggling with that word today, he says this was taken by her phone and it was stored in her phone when it was sent to Facebook. So he's not saying, from what I understood, that this photo was implying that she was being suggestive, right? He's
but
saying
do we
she
know
had
it
access.
was Christine?
Right.
We don't know if it was
He's
Christine.
saying you do know because it's a selfie. So he's touching on that and saying the time lines up to show that it was her in this moment. Who was that being sent to? We don't know. Is that relevant? We don't know. So a lot there. But he's really just trying to go back to that point that if she had access to her phone then she had access here and here and here, and then she had access to this account. She knew about this account, and then just putting little sparks of doubt in the jurors' minds.
And that's what the defense's job is to do, is to basically break down what the prosecutors are trying to say. And now it's up to the jury to decide, right? They have to decide and contemplate what is being presented in front of them. Was Juliana a big role in planning this nefarious, evil scheme to kill Christine and Joseph Ryan? And then she took this plea deal to get out of it herself and say, hey, it wasn't me, it was Brendan. So that is what the defense is trying to dismantle.
Yeah, and I'm curious to see what's going to be happening next. You know, yesterday at the end of the hearing, the judge said, I really want things to wrap up tomorrow. That way we can do closing arguments next week. She had the attorneys both come in this morning and go over jury instructions. They have to share their jury instructions, and then those instructions are going to be either at the end of today or early next week, given to the jury before they go into deliberations.
Yeah, and the timing of whether Brendan Banfield takes the stand today, I find that to be interesting because if he does take the stand, and let's say he's the last person for the day, that is going to leave an impression on the jury as they go into the weekend, a snowy weekend, where they have lots and lots of time to think about what has played out. I don't know, I'd be curious to hear from our legal analyst, is this part of a larger plan from the defense? We'll have to see.
So actually, I can give you some context for that because I've been in touch with Frank Salvedo, our legal expert who's been here a few days. He wasn't supposed to be here with us today. We do have a body language expert coming in for the lunch break, but he's going to be joining us after that, and he'll be joining us at 3:15 and then for a recap to kind of talk about if Brendan does take the stand, to analyze that, what the decision making there was. He did send me a quote. And he said, you know, this is a surprising development. He was very shocked. He literally texted me, oh my goodness, he's taking the stand. And he said, it looks like Mr. Banfield has exercised his independent right to testify. And he said it's a high risk, high reward situation. So obviously I asked him, what do you mean by that?
Yeah.
And he said it makes it high risk, high reward because if he does well, then he stands a decent chance at an acquittal. But given how well the trial has gone for him so far, it is high risk. So he's saying he believes the defense has done a good job to prove their case.
So this really could go 50-50.
Right. He said the trial now becomes all about him, not about the au pair, and he has a lot of things to explain, and one misstep could spell disaster. And I think that's key here, because the defense will ask him the questions that they have planned out, they've rehearsed likely. But then you don't know what the prosecution's going to get up there and ask. And I'm curious to see if he does take the stand, if we see John Carroll make sure the day ends with him having the last word with Brendan Banfield.
Well, let us know what you think. Our number is 202-895-5599. Continue to not only text in your questions, but also send us your comments and your analysis of what happened so far, what's unfolding inside this courtroom. I know a lot of you are interested in this very high-profile case. Let us know your thoughts, and how do you think Brendan will do today if he does, in fact, take the witness stand? Another thing is, the focus on the officers involved. That was much of the day yesterday, and we learned so much out of the investigation piece. And John Carroll, of course, hyper-focused on, did they do a thorough job of this investigation, really trying to paint this picture that there were mistakes along the way, and therefore my client, there are certain loopholes, there are certain holes in this case that we really need to look closer at.
Yeah, and I'm looking forward to hearing from Frank, not only about Brendan Banfield possibly testifying, but also that, because, you know, yesterday was really about the police department, and there was so much focus on that. At one point, I turned to our legal expert who was here and said, it feels like the department's on trial right now and not Brendan Banfield. And he said, well, they kind of are on trial because their work here, how they performed during this investigation is a huge part of this case. So, you know, we learned so much about that investigation, and we heard from a lot of people who are no longer in the homicide unit. We also heard from Detective Leah Smith, I believe her name was.
Homicide detective at the
Right.
time.
And her testimony was so interesting, I think,
strong.
to both of us, because she said the detectives in this unit were told, there are two theories here and you need to get behind one of them. And she said that goes against everything she stands for. And she was very vocal, according to her, in telling the other detectives, we need to not have theories. We need to do our job and base this on evidence.
And keep an open mind.
And she said that in the end, they did base it on evidence. When the prosecution said to her, why did you end up ultimately arresting Brendan Banfield, again, a month before Juliana took that plea agreement, and she said it was because we got the blood evidence back.
I seem to also recall along those lines, it was the deputy chief.
John Brush?
Yes. He had mentioned something about Juliana being arrested first, and
Right.
was asked why was she arrested first, and he stated that that was their window, their opportunity to get closer to Brendan Banfield.
Yeah, both he and Lieutenant Giasio both talked about that pretty at length. Let me go back to my notes, but he, you know, Lieutenant Giasio, his testimony was a little more interesting to me because it almost felt like, oh, was he not supposed to say that up there? Is he kind of walking that line? Was he good to say that? But he said that, let me see if I can find the notes, that they had Juliana, she spoke Portuguese, so they had an officer doing a lot of the translation. He did say, though, she filled in the blanks, but they already knew this. And I think that takes us back to the testimony we heard from Sally Fayez as well, that they were already starting to be like, hey, something's off here.
Right, which is why they went and arrested Juliana, right?
Right, that
I mean,
was
they
part
had
of it.
enough grounds to get her into custody and therefore get closer to Brendan, maybe learn more or question her.
Right. He said that they arrested Juliana. You know, he backtracked a little bit and said they arrested Juliana because they had the evidence to arrest Juliana, but that it was definitely helpful when she started to work with detectives.
Right.
But again, that didn't happen until after Brendan was arrested. So
I think he also mentioned that it was, you know, it's a moment of cooperation. Is she willing to cooperate with investigators, but also a self-admission? What are you willing to talk about on your own without questioning?
And I think it's also important to mention here, they had been listening to her calls from the jail. So there were some text messages shown on the screen yesterday between Lieutenant Giasio, at the time, I believe he was a captain, Brush, then became a deputy chief, but at that moment he was a captain, and Sally Fayez, and those text messages included recordings from the jail. And so that was a big part of their investigation too. They were listening to those calls from jail, Juliana likely calling Brendan. At one point there was a text on screen that said, we can get him to fold. So interesting that they were already like, if we keep putting the pressure, if we can just get him behind bars, he'll fold too.
I definitely think Brendan taking the stand at some point is a big, big deal. And so again, we are curious as to hear what you all think will happen in court today as we continue to watch day 8 unfold. I'm not sure how many more witnesses the defense has on its list, but you know, some of the comments that I'm hearing, you know, people are very invested in this case because not only the situation, it's an awful, horrific situation. There's a young child involved. People were killed. This is terrible. But the interest in this case, I think, is indication that, you know, these two people, the woman Juliana came to work for this family to take care of their daughter, their young daughter, and then they, you know, this affair starts, this romantic relationship behind the wife's back.
Less than a year before the killings
The
happened.
timeline is incredible. I mean, just the speed in which the relationship began the moment she moved in. I think it was like a month later.
October of 2021, she moves to the home to be the au pair. August of 2022, she says the affair started.
Right, and 10 months later.
October 2022 is when she says Brendan came to her with the plan, and then February 2023 is when Christine and Joseph Ryan were killed.
And another sticking point, the police officer, the female officer who took the stand yesterday, the last,
Fayez, yeah. She's with Victim Services.
Yes, Victim Services. She also stated what the little girl, their daughter, had said to Juliana.
Right, so they had intel officers in the hotel where they had taken Juliana, Brendan, and that little girl, the 4-year-old little girl, because their home was a crime scene. And she said the intel officers overheard a conversation between Juliana and the little girl saying, "Are you going to be my mommy now?" to Juliana.
Are you going to marry my dad?
Right, "Are you going to be my mommy now?" And then Juliana said, "Yes." And then she said, "Are you going to marry my daddy?" And she said, "I wish." So interesting.
I believe she also said, "Can I call you mommy?"
Yeah.
To which Juliana said yes.
A lot here.
A lot here for sure, but bear in mind that the job of the defense's job is isn't to present a theory, but rather to really
reasonable doubt.
Yes, to raise reasonable doubt. Again, I know a lot of you are hung up on this as we are. Divorce apparently was not an option. Juliana made that clear on her testimony that Brendan Banfield did not want to share the custody of their then 4-year-old daughter with Christine, his wife, and money was involved. So this is what Juliana says was planned.
Yeah, and they're in a break right now. They're in a 15-minute break. The next break is the lunch break, and we will have a body language expert here to answer some of the questions you may have, but also we've pulled a bunch of different clips of Juliana, the body camera footage of Juliana, but then Juliana on the stand, both with the prosecution and the defense, as well as some clips of Brendan for her to analyze and kind of weigh in.
Yeah, I think that's good, because there have been moments when Katie and I are watching this, and he has this stoic facial expression. What does that mean? Also, he gave Juliana a double look. Okay, looks like they are getting back inside the courtroom now. Let's take you back live to Fairfax County Courthouse.
I brought one of the warmer that you will. Thank you. Share with me.
All right, your next question.
Thank you. Mr. Lidsky, I'm going to have you look at the next slide, and if you can just identify it. Can you see that on your screen?
I can.
And is that something that you utilized in your digital forensic analysis?
It is.
Your Honor, I move that in as exhibit number 141.
Any objection?
No, ma'am.
141.
Sir, can you please explain to the ladies and gentlemen of the jury what's the significance of this artifact?
Sure. This ties into the prior slide and artifacts that we reviewed, or the ones from the laptop, 2 slides prior. Again, we're just going chronologically and looking at what the user of this device was engaged in. Of note, and it might be helpful to go back 2 slides to the previous blue one. We're seeing a bouncing between applications and between accounts. That's helpful for me in this case, at least, because part of the information that I was aware of from witness interviews or co-defendant interviews is that when this device, which was the subject of alleged misattribution, removal, and use by another party or parties, that when the laptop was in that possession, it was just, we were just using the account or It was directed account usage. Here we're seeing a shift back and forth. So we started with Gmail at the beginning of this 2 slides ago. And then we went to Facebook, and then we had a download, and then we saw the suspect alleged account or alleged suspect email account in use. Then, and now here at 10:05, so this is all within a 5-minute window, we're back into Ms. Banfield's sort of the non-suspect account, so just her personal email account.
Sir, I'm going to have you look at the next slide, which is what you just described to the ladies and gentlemen of the jury. Your Honor, that would be exhibit number 142.
Any objection?
No, thank you.
Sir, can you explain to the ladies and gentlemen of the jury what's the significance of the additional line that's down on the bottom of this slide?
Yeah, it's merely just a continuation. The first line of this demonstrative, or sheet of the demonstrative, is at 10:05 at 17 seconds, and that's looking at a particular email. So that's where we see on the second and third lines, respectively, sent mail. That's the sent mail box and the inbox with a lot of unread messages. The first line is an actual specific message.
Sir, I'm going to have you look at the next slide, which will be identified as exhibit 143. Do you recognize that slide?
I do.
Do you recognize the additional line?
I do.
Okay. Your Honor, I move that in as exhibit 143.
Any objection?
No, thank you.
143.
Sir, can you explain to the ladies and gentlemen of the jury the significance of this artifact?
Sure. So this is a Google search for FetLife, which obviously is important in this case. Of note is the timing, again, looking at what's occurring right before this. So at 10:05, 10:06, 10:07, we have activity within Ms. Banfield's email account. And here at 10:07, basically 10:08, now we have a Google search for FetLife. So we've moved, the user of this device at this time has moved from one to the other.
Your Honor, I'm going to move on to the next slide.
All right.
Sir, can you identify what will be marked as exhibit 144?
Yes, I can.
And Your Honor, I move that into evidence.
Any objection?
No.
144.
Sir, can you please explain that additional line and how it relates to the ones that you've already discussed?
Sure. So this is typically after a Google search and relatable. The search results come in, and very frequently users will click on a link. So in the third line down, we have a search for FetLife, and then immediately after, within under 30 seconds, we have a visit to the FetLife site.
Your Honor, I'm going to move to the next slide,
All right.
and this will be identified as exhibit 145. Sir, is that an artifact that you utilized in creating this slide?
It is.
Okay. Your Honor, I move that in as exhibit 145.
Any objection?
No objection.
145.
Sir, please explain the significance of this additional artifact to what you've already described for the ladies and gentlemen of the jury.
So this is a second login to the alleged suspect email account, the CBRN 920 Gmail account at 10:12 p.m. My experience is you cannot be logged into two Gmail accounts at once on the same device. So looking up to the top row of this slide, we're into Ms. Banfield's sort of personal email account. So at that point, this computer was logged into the C. Banfield RN account, and now we're seeing a relog in back to the CBRN 920 account.
And is there any way to know what device that is?
That was from this laptop, from Ms. Banfield's Lenovo laptop.
Your Honor, I'm going to move on to the next slide.
All right.
And that will be identified as Exhibit 146. Sir, is this an artifact, or is this a slide that you created based upon your digital forensic analysis?
It is.
And Your Honor, I move that in as Defense Exhibit 146.
Any objection?
No.
146?
So moving on, sir, can you explain to the ladies and gentlemen of the jury what the significance of the data that's before them?
This is from Ms. Banfield's mobile device. This is a little bit later in the 10 o'clock hour, from 10:43 to 10:46 p.m. And these are just website visits that were performed using her mobile device at the time.
Your Honor, I'm going to move to the next slide.
All right.
And this will be identified as Exhibit 147. Sir, do you recognize that artifact?
I do.
And is that something that you reviewed in preparing this slide?
It is.
Can you please explain to the ladies and gentlemen of the jury what's the significance of this? Oh, I'm sorry. Your Honor, I move that in as.
Any objection?
No.
I think she said no.
Oh, you said no.
I'm sorry, no.
Okay, all right. 147 evidence, sorry.
Okay, now it's on display, so if you could please explain that to the ladies and gentlemen of the jury.
Yeah, this is simply opening the photo app on the Windows laptop.
Your Honor, I'm going to move to the next slide,
All right.
identified as 148.
Any objection to 148?
No.
148 in evidence.
Sir, explain to the ladies and gentlemen of the jury what the artifacts are and how they're significant.
So the user of this device at this time, using the Photos app, edited the photo we saw back at the beginning of these slides. So if you remember the photo we saw that was downloaded from Facebook to the device ended in 1973_N. And now we see at 10:47 p.m. a new photo ending in 1973_N edit.jpg has now been used by the Photo app on Christine's laptop.
Your Honor, I'm going to move to the next exhibit. Sir, do you recognize this exhibit?
But I do, it's just a call out for.
Okay, it'll be identified as Exhibit 148.
149.
149, I
Any
apologize.
objection to 149?
Well, he didn't make the circle himself, but I don't object.
Okay, 149 in evidence.
And I'm sorry, if you could, the jury now sees that. What were you saying about that?
Yeah, that the circle is just a call out to what I described, just taking note of the file name.
Your Honor, I'm going to move to the next slide. This will be identified as Exhibit 150.
Any objection to 150?
Nope.
150.
Sir, can you add?
Yeah, it's just a further call out to the tail end, the 1973_N edit.jpg.
And when you say call out, what your explanation was?
Yeah, just drawing attention to the significant part of the file name.
Your Honor, I'm going to move to the next slide.
All right.
Sir, do you see the slide in front of you?
I do.
Okay, and this would be identified as Exhibit 151.
151. Any objection to 151?
Judge, if you could lay foundation for how this slide was created.
All right.
Sir, what is it that you examined in order to create this slide? Can you explain?
Sure. I reviewed the responsive documents provided by FetLife to create this. I took screen grabs or snippets of those documents, which are rather voluminous, and I consolidated what, for me, what the salient points were into this slide.
And this is specifically related to this slide, correct? I'm sorry, to the topic of this slide.
Yes, this is the important information from the FetLife documents for this discussion related to this slide, yes.
Okay, Your Honor, I move that in as Commonwealth's or Defense Exhibit 151.
Any objection there?
Judge, I do. Unfortunately, it's out of context, and I think best evidence would require the full document be used.
Do you have the full document?
Judge, I believe that's part of the stipulations that were put in relating to the FetLife documents.
Correct, and we've admitted the full document into evidence. I think that is the document that should be used.
I don't have it right now, Judge.
All right.
We can move on from
If you
151.
can supplement it with the full document, then we can
Yes.
put it in. Okay.
Your Honor, I'm going to move to what will be identified as number 152. Sir, do you recognize this slide?
I do.
Okay, and I think there's been an objection relating to the full document, but what's the additional information that is on this document?
It's the addition of a photograph.
Okay, and what's the origin of that photograph?
Objection, Judge, asked and answered. We've already talked about this photograph. It's been admitted into evidence.
Okay.
Okay. Your Honor, once we get the full
Okay.
document, then I'll
Sure.
ask for it to be admitted. I'm going to go on to the next slide, Judge.
Okay.
Sir, can you identify the artifacts that were used to make up this slide?
Yes, I can.
Okay, and where did they come from, and what's the significance of them for the ladies and gentlemen of the jury?
These came from Ms. Banfield's cell phone. They are web searches.
If I may just interrupt for a second, Your Honor, we'd move this in as Defense Exhibit number 153.
Any objection to 153?
No objection.
153?
Sorry, I didn't mean to interrupt. Go ahead.
Okay. These are web searches or website visits from Ms. Banfield's cell phone from January 17th, from 10:49 through 11:29 p.m. They're informative in that the 10:49 artifact at the top was about a minute after the FetLife account was created, so for timing, it's informative. For the middle column, we can see what the website was, or what was the website that was visited, what the content was. So that can be informative for a digital forensic examiner in helping determine potential attribution based on the content. So is it content related to one person over another? Is it related to, in this case, a catfishing theme? Is it related to, or is it what we might expect from a user's normal activity? It's also, I'm sorry if I can add one.
No, please.
Timing also is informative, obviously. If somebody's device is in use and we can assign attribution, then it shows that they're awake and in possession of their device. And obviously that was, for me, that was something important for this investigation to take note of.
Now, if just to deviate for a moment from that, in digital forensic analysis, what, if anything, do you do to try to determine a pattern of life regarding the use of devices?
Yeah, I can typically just looking at use over time, what's normal for a user. I've done that with mobile device tracking, cell phone tracking when I was in law enforcement. You can infer patterns from the data from use over time. On Ms. Banfield's computer, based on one of the statements the co-defendant made during her interviews, and I believe, again, a testimony was that she dropped her backpack by the door and didn't touch her laptop after that. I looked backwards for about a year in time of her user activity, and she was frequently using her laptop well into the evening from 10.
Judge, objection is to speculation. He can tell us what the devices were doing.
Now sustained.
If you could just explain what you were explaining as to what the devices were doing at what period of times, in terms of the pattern that you just described.
Sure. Ms. Banfield's device had a history of activity, devices had a history of activity well into the evening for an extended period of time, both
Was
before.
there a time frame that was consistent during that period of a year that you went back?
It was frequently between 10 or 11 p.m. and 1 or 2 a.m.
Your Honor, I'm going to move to the next slide. Sir, do you see that slide?
I do.
Is that a slide that you created?
It is.
And was it based on your analysis of digital forensics?
It is.
Your Honor, I'm going to identify this as 154.
Any objection to 154?
No.
Or 154 in evidence?
Sir, please explain to the ladies and gentlemen of the jury what the significance of these artifacts are.
So here we have another, the date is still January 17th. The time is from 11:32 through 11:35. These are from Ms. Banfield's mobile device. We have a couple of website visits on the top and the bottom, and in between we have a number of email email inbox visits with a Google, a couple of Googles in between. Of note here towards the right, the second to last column on the right, the digital forensic software we use can tell us whether a device was local or synced, among other sources. So we can see where we see local, it means in this case, the two local artifacts were website visits on this device itself. The intervening artifacts that are labeled as synced tell us that those could have come from a secondary device and are being replicated here as a result of Google's ability to sync accounts. If you're logged into your account on more than one device, what you do on one might appear on the other.
Now, the January 17th, what was the significance of January 17th again?
The FetLife was created around 10:48 p.m.
Okay, and so the timelines of all of these slides that the jury has seen are significant in terms of this setup.
Objection, counsel's testifying.
What's the significance of it relating to the times?
Well, we've just walked through what was occurring on Ms. Banfield's laptop and her phone in the 45 minutes or so before through the 45 minutes or so after. And recalling the first slides we saw Windows log on to the laptop. So we've seen, the activity that evening began around 10 o'clock when we first started running through these.
And are you, based upon the analysis that you did during this slideshow presentation, are you able to opine as to, within the degrees of digital forensic analysis, your opinions as to what was going on January 17th?
I am.
Can you provide that opinion?
So, again, revisiting the originating slides, we saw a logon with Ms. Banfield's security identifier to her profile, at least on her laptop, around 10 o'clock, joining the Wi-Fi, which our computers do automatically. Immediately, we went into her email account or the user of the device, went into her email account, and then we started seeing other activity. We saw the alleged suspect Gmail account be logged into, and then we were back into Ms. Banfield's Facebook account where we viewed an image, a picture, a digital image. That image was then downloaded, and these are all happening within either seconds or a minute. That downloaded image was brought to the device early in the 10 o'clock hour, I think around 10:05. And then we saw, 30 or 40 minutes later, the Photos app opened up, an image edited, and that image would ultimately be uploaded to the FetLife account during the account creation. All the while on Ms. Banfield's phone, there appears to be certainly user activity. As Detective Miller said, context is hard, and we might need other corroborative data to see who was conducting that, but it's certainly unrelated. I think the website visit about Kristen Chenoweth has nothing to do with the scheme here at hand. So we can infer, and we do, and this is just one event in a timeline of many significant events, but we can draw inferences based on the totality before, after, during, and the content of who might have been operating. What I didn't see was a gap in time where a device that appears to be going in and out of accounts related to the scheme and not related to the scheme was exchange hands, like misappropriated. I didn't see any gaps of time where where somebody might be using a device and then go to the bathroom and the device would be taken, potentially somewhere else in a house, used by somebody else and brought back. I didn't see gaps here for this particular event where that either occurred or even could.
Objection calls for speculation.
All right, let's sustain as this last part.
Okay. Based upon the analysis, in terms of the statements that you're making, what are your conclusions?
I didn't see anything here that indicated loss of control of the device. I'm not able to say who was in control of the device for the entirety of this period, but I did see inconsistencies in that the usage was not confined just to the accounts related to this investigation. In this case, that would be the suspect alleged Gmail account and the FetLife account. So interspersed with that, I saw personal account usage with Ms. Banfield's accounts.
All right, thank you. Mr. Klitsky? Sir, do you see the first slide before you?
I do.
Okay. And this, what's the topic that we're dealing with in terms of this particular piece of evidence?
So this is a snippet of a video interview with Ms. Magalhães. I believe in this particular clip, she's answering a question about the Telegram account creation and the associated activity. I think the deleting of the SMS code that was used to stand up the Telegram account.
Your Honor, I'd identify this as defense 155 and move this into evidence.
Objection, hearsay.
All right, I'll sustain as to hearsay.
Sir, do you see the slide that's before you?
I do.
And what, if anything, what does this say? Or what, I should say, what's the significance of this in your digital forensic analysis?
So this was recovered from Ms. Banfield's cell phone, and it is the Telegram 2FA code, I think the two-factor authentication code that was described in testimony.
Okay. And, Your Honor, I would, I've identified it as 155,
156?
156. I'd move that into evidence, Your
Any
Honor.
objection to 156?
No, Judge.
All right, 156 in evidence.
Okay. And, sir, what's the significance of this particular artifact with regard to the issue of the Telegram setup?
So the relevance here, I think, is corroborative information. Lieutenant Giacchio spoke about that yesterday, and it's important to discern the veracity of witness or co-defendant statements or testimony. This artifact was recovered from Ms. Banfield's mobile device. From my understanding of the investigative materials provided to me, this had been deleted by Mr. Banfield. It wasn't deleted. It was still there. I understand.
Objection as to the mischaracterization of previous testimony.
If you want to approach, let's knock this out.
Talk slow, my computer's restarting.
Mine is not restarting, so if we need to.
Can you open the document up? I just think that's actually not being in drive. Should.
And, sir, going back to this artifact, this was related to, I think you said, the Telegram setup and the two-factor authentication?
Correct.
Okay. And what's the significance of that in the context of the Telegram setup?
That is still present on Ms. Banfield's phone.
Okay. Is that significant that that would be on her phone?
To me, it is.
Okay, and in what way is that significant that the notice of a two-factor authentication?
The notice itself, not much. Its continued existence is of note because I find it inconsistent with the theory of the case.
Okay. Your Honor, I'm going to move on to.
Sure.
And I'm sorry, 157.
157.
And sir, do you, can you identify these artifacts? And is this a slide that you created?
I can, and it is.
And it's based upon your digital forensic analysis?
Yes.
Okay. Your Honor, I move that in as.
Any objection?
No.
Okay, 157.
Sir, can you please explain that to the ladies and gentlemen of the jury?
So these are, I believe, the 4 most recent text messages from Ms. Banfield's device over this time period. So from, late evening or night of February 18th, 2023 at around 10 p.m. through the morning of the 19th at around 10 a.m. So at 9:58 p.m. on the 18th, we have just, a message exchange with who I assume is a coworker based on the contact name. But at 2:19, so after midnight at 1:37, and again at 2:07, we have two FA codes, one of which is the Telegram code we just looked at on the prior slide. But the one before that is a signal verification 2FA code. A signal was not used in as part of this alleged scheme, but to me it's informative that other secure messaging apps were experimented. At least it appears the user of this device experimented with others. The message on the morning of the 19th, again with another coworker, is there only to show sort of bookend activity. The idea that, because the 2 FA messages from the early morning of the 19th were not deleted, they would be readily viewable by the user of the account the following morning. And so when normal sort of messaging activity resumed, the idea that, to me as a digital forensic examiner, the 2 FA codes, were not hidden or unseen by the user of this device.
And so
Objection calls for speculation. He can't testify as to what someone saw or not.
All right, I'll sustain as to the last part there.
in terms of, you said 2FA, in the event that somebody doesn't know what that is, describe what two-factor authentication is.
Yeah, two-factor authentication, 2FA, is a way a number of service providers just require device possession. It's a way for them to confirm that you're holding and using and have authority, in theory, to use the device that you're registering. So it prevents us from signing each other up for a bunch of accounts. So that's why in this case, Signal and Telegram require you to be in possession of the phone that you're asking them to permit your use on their servers.
And in a situation or in a case like this with the allegations, would a two-factor authentication code's existence...
Objection leading.
Or sustain as to leading.
What, if any, significance would that hold in a case such as this?
For me, based on my experience, both as an investigator and a digital forensic examiner, any misattribution scheme, to include catfishing, the name, misattribution is important. You want to hide your tracks. The idea is that the target of your efforts is unaware that they are being targeted, and you're exerting effort, on that on that plan. So if you leave evidence behind, if you leave something that,
Judge, objection, this is speculative. He's speaking about what people do in catfishing. I don't think he's speaking to what happened in this case, and I don't believe that
It's overruled. Okay, you can continue.
so the idea is to hide the hand, right? If somebody sees that their device or devices were tampered with, or there's usage that's not their own, they may become suspicious, they might question it. It could certainly raise a red flag. So traditionally, in my experience, one would remove all traces of their activity if in fact it is misattribution.
Here, I'm going to move on to the next slide.
Okay.
And Your Honor, I would identify this as Defense Exhibit 158.
All right. Any objection to 158?
No,
158 in evidence.
Sir, do you see that slide?
I do.
And can you explain the significance of this analysis and this slide to the ladies and gentlemen of the jury?
These are unrelated, but I felt informative activity from Ms. Banfield's phone, again, from the day before and the day after. These are other user verification codes or 2FA codes for Microsoft and PayPal, things not related to the scheme, but they tell me that the user of this device was familiar with the codes, knew what they stood for, and was unlikely to ignore a message that
objection
contained...
calls for speculation.
All right, I'll sustain the last part, speculation.
Okay, sir, can you just explain that in a way that doesn't cause you to speculate?
For me, being aware of or familiar with how a certain item works would cause me not to ignore it if I...
Objection, Judge, he's testifying as to his personal experience.
I'll sustain the objection.
In terms of two-factor authentication, how does that reveal itself on phones and devices?
It's readily identifiable by his face. I mean, we can look at the message and see what they are. Any users or people who engage in 2FA activity typically can identify them when they pop up.
Thank you. Your Honor, I'm going to move on to the next slide. Your Honor, this would be identified as Defense Exhibit 159.
Any objection to 159?
No.
159 evidence.
What does this say, Mr. Litsky? And if you could explain that to the ladies and gentlemen of the jury.
At 1:34 a.m. or approximately 1:34 a.m. on February 19th, an application was installed on Ms. Banfield's mobile device. We can see the name of it, thoughtcrime.secure SMS. That's the corporate name or the fancy name for Signal, which is a secure SMS messaging platform.
Can I just interrupt you for a second?
Yeah.
What is SMS?
It's communication, it's messaging. It's just a digital communication platform.
Okay, sorry.
Not at all. So Signal was installed on Ms. Banfield's device at approximately 1:34 that same evening. Informative, although even though it didn't play into this case and this investigation, it is, I'd say, a comparable app to Telegram.
Judge, I'm going to object to that statement. I don't believe that the witness has laid any foundation to suggest that Signal wasn't part of this investigation.
I guess foundation is the question. If you
Okay. In your examination of the evidence that has been provided to the defense, Does that inform your statement that you just made in terms of signal?
Yes, my understanding of the evidence I've reviewed is that the suspect Gmail account was in use, FetLife, and Telegram was the secure messaging application that was used. Other similar applications like Signal, I did not see, nor was I made aware of any use by those on those platforms.
Okay. Can you please continue with your answer?
Sure. Signal was installed on this device, irrespective of what its intended use was for. We saw the Signal 2FA code on the slide before, and that's expected of what we'd see with an installation. That's usually when they require us to confirm the device that we're registering. Just given that it was a secure SMS that was installed or at least reviewed around the same time that the Telegram app was also being installed, I thought it might be related, and I flagged it of interest for that purpose.
And is it noteworthy in your investigation the email account that was used?
So the email account that's on here is obviously Ms. Banfield's. That would be the account associated with the device itself in the Google Play Store, which is required to download apps. So yeah, that is the account that was associated with the phone and this resulting download or installation.
Thank you, sir. Your Honor, may I approach?
Yes, sure.
Sir, I'm going to ask you to look at the slide before you, and that will be identified as 160, 160.
I see it.
Objection to 160? Okay.
Sir, what, if anything, did you look at in order to create this slide in terms of your digital forensics analysis?
This is a data location or a location of Ms. Magalhães' device, her mobile phone, on February 20th and at 10:46 p.m.
I'm sorry, did you say the co-defendant's name?
Yes.
Okay. And what was used to create this document?
This is data recovered from her phone itself.
Okay. And the map portion of it?
The digital forensic software we use, when it encounters a location artifact, it gives us a little map.
And what's the name of that? What's the name of that software?
This is Magnet's. This is a Magnet Axiom software.
Okay. So it's the same as what Detective Miller used in extracting these devices and creating the portable case?
It is.
And so this would be identical to what you received from the portable case?
Yes, this is an artifact from within it.
Your Honor, I move that in as Commonwealth's Exhibit 160.
R160 in evidence.
So we're into it. Well, you tell me, what's the significance of this, and is it related to what you just showed the ladies and gentlemen of the jury?
This, I mean, this was a data point, a geographical data point recorded by Ms. Magalhães' phone on the evening of February 20th, basically at 10:46 p.m.
And February 20th is significant for what reason?
I believe February 20th, there was significant Telegram conversation, maybe FetLife conversation as well, and was the night of the voice verification phone call between, with Joe Ryan.
Your Honor, I move that in as, oh, I think I may have already done that. Yes, thank you. Your Honor, I'm going to move to the next slide. Sir, can you identify this slide and the significance relating to what you've just testified to?
This is part of a production from I'm sorry, this is a login to Ms. Banfield's, her true name Gmail account from the Banfield residence, also on February 20th, 2023 at 10:58 p.m.
Okay, and is there a timing issue that you're highlighting here?
Well, on the prior slide, I think it was 10:46 p.m. Ms. Magalhães, or at least her phone, was at Lifetime Fitness in Reston, Virginia. Here, 12 minutes later, we have somebody logging into Ms. Banfield's account from the house.
Your Honor, I'm sorry, I identify this as Exhibit 161,
Yes.
and I'd move that into evidence.
Any objection?
No, ma'am.
167 in evidence. Oh, 161, I'm sorry, in evidence.
Your Honor, I'm going to move back to the back slide so that
Okay,
there's
you go
context
back.
to what.
160 is in evidence.
Sir, was this the slide you were talking about, and this is the timing that you were talking about?
This is the beginning of a sequence of events and timing, yes.
Okay. And this is 161, the current slide.
Correct.
And it wasn't up for the jury when you were explaining it. Can you go over that again quickly?
Sure. This is just a representation of a login to Ms. Banfield's personal email account from the house from the Banfield residence at 10:58 p.m.
Your Honor, I'm going to move to the next slide, which will be designated or identified as 162. Sir, do you recognize this slide?
I do.
And what was it that you analyzed to arrive at the information that's on this slide?
This is a geolocation artifact from Ms. Magalhães' mobile device.
Your Honor, I move that in as Defense Exhibit 162.
Any objection?
No, thank you.
162 in evidence.
Can you explain for the ladies and gentlemen of the jury the significant aspects of this and why you created this slide?
So on the previous slide where we saw a login to Ms. Banfield's email account from the residence, essentially at the same time at 10:58 p.m., it appears Ms. Magalhães was on her way back from the gym, or she was at least mobile. She's no longer at Lifetime Fitness in Reston. She's now just on the surface streets in and around Reston.
Okay, and do you have any sense of the distance to the house?
I think it's about a 15 or 17-minute drive, point to point from Lifetime Fitness in Reston to the Banfield residence in Herndon.
Anything else about this slide?
Nope, it's just her location at the time.
Your Honor, I'm going to move to the next slide.
All right.
And is this a slide that you created relating to your digital forensic analysis?
It is.
And, Your Honor, I move this in as Commonwealth's, or Defense Exhibit 163.
Any objection?
No, ma'am.
163?
Sir, can you explain for the ladies and gentlemen of the jury what the significance of this slide is relating to February 20th, 2023?
Sure. This is data from two records. The top sort of larger font, which is not done for any purpose. It's not large for any other purpose or any significant purpose. This was Brendan's. I guess it's a swipe, but here his entry to the Lifetime Fitness in Reston on this evening. So they had him, swiping in or arriving at 9:18 and 33 seconds. The lower three lines are from, I believe, a T-Mobile record showing Mr. Banfield's position as T-Mobile recorded it, and it's not precise. However, it does reflect the nearest tower, or the tower that was handling the data to Mr. Banfield's phone at the time of the record. So we see that he swiped into the gym at 9:18 p.m. T-Mobile, again, a service provider record, is going to be in UTC, so we have to do some math. But the third line of the T-Mobile section at 3:59 a.m., that would show, that would actually correspond to February 20th, 2023 at 10:59 p.m. And he was still on the same tower. So the reason 3 towers were shown with the Roger Bacon Drive address is to show the consistency. So again, Mr. Banfield logged into the gym in Reston at 9:18. We see at 9:39, with the conversion of the first line of the T-Mobile records, that their tower at Roger Bacon Drive in Reston, which is close in proximity to Lifetime Fitness, handled his data at that time. We see on the next line at, which would now be 10:18 p.m., he was receiving data from T-Mobile on that same tower. And then the third line, which is 10:59 p.m., he's still receiving data from that same tower. So it's just one set of data points corroborating the other, confirming the other.
And so what would you conclude based upon that slide?
That at 10:59 p.m., Mr. Banfield was still in or at or
Objection
around.
calls for speculation.
It would be his device, not.
Yes, based upon, okay. I think we have to speak in terms of the devices. What can you conclude based on this regarding his device or devices?
That Mr. Banfield's Lifetime Gym swipe card was arrested at 9:18, and that Mr. Banfield's mobile device was in vicinity of Lifetime Fitness through at least 10:59 p.m. all on the evening of the 20th of February.
Here, I'm going to move to the next slide. And that will be 164.
Correct.
Sir, can you identify this?
I can.
And was this something that you created?
I did.
And what, if anything, did you use to create this?
Google Maps.
Your Honor, I move this in as Defense Exhibit 164.
Any objection?
No objection.
164.
Sir, can you explain to the ladies and gentlemen of the jury what this created slide says, and what's the significance of it?
This is just a visual representation of what I was just describing. So the red dot on the left side of the screen is just the location of T-Mobile's tower at on I think Roger Bacon Drive, and we can see where it's fairly close to the Lifetime Fitness gym in Reston.
And is there any indication of where the device is at this time?
Well, on the prior slide, we saw where Mr. Banfield's device was on the evening of the 20th between the 9 and 11 o'clock PM hours.
Okay.
This is just showing the tower that the data, what T-Mobile tells us.
Okay. And you created this to be a complement to what you had done in the previous slide?
Yes, just to visualize it. It's just to visualize it.
Your Honor, I'm going to move on to the next slide, which will be identified as Exhibit 165. Now, sir, do you recognize this slide?
I do.
And is this something you created?
It is.
Your Honor, I move this in as Defense Exhibit 165.
Any objection?
No, thank you.
165.
Sir, if you can explain to the ladies and gentlemen of the jury, what's the significance as it relates to February 20th, 2023?
This is another geolocation point from Ms. Magalhães' mobile device.
And what does it tell us?
So this is an artifact from 11:06 and 50 seconds PM, so 11:07 PM. And this is what, so Ms. Magalhães had an Apple iPhone, and one of the things that iPhones do is they create significant location visits for us. So places we go frequently, like home, work, gym, Apple categorizes them as significant locations of visits. It doesn't mean anything for us as users, but on the back end, as a digital forensic examiner, artifacts like this can be informative. So in this case, it tells me this is when she probably walked through the door, and her iPhone says, "I'm home," basically.
Your Honor, I'm going to switch to the next slide, which will be designated as Exhibit 166. Sir, what is this artifact?
This is a login to a website, a commercial website.
And what's the commercial website?
It's anova.org. It's an ananova.org website.
And what's the significance of having this artifact?
So this is from Ms. Banfield's computer, and I'm aware from the details of the investigation that she worked at Anova.
And is the time significant relating to this investigation into Telegram?
It's related to the investigation. I'm not sure
Oh, I'm sorry.
specifically the Telegram.
What's the significance of this?
Well, again, this is there was significance of this date. There are events relative to this date. So what I'm trying to do is determine attribution by looking at all the devices and everybody's location to the extent I can figure it out. So this is just another artifact as we're walking through this evening. This is also at 11:07 PM, closer to 11:08 PM. Maybe within a minute of Ms. Magalhães, or at least her device, arriving home.
Now, in terms of, you used the term attribution, I think Detective Miller used that term as well. Is that a term of art in the digital forensics world?
It seems to be a goal we're frequently chasing.
Okay. So how would you describe it in kind of plain terms for me and the ladies and gentlemen of the jury?
Sure, as Detective Miller said, it's tough for us without a video or being there to put any one of us behind the keyboard, so to speak. Who's holding the device? Who's actually manipulating the data? And as he also pointed out, other informative data points can be helpful in providing context and providing corroborative information. Just by way of an example, in this particular case, we have 3 people. Or in any case where if we have 3 people, unsure who's using a device, if two people can be confirmed out of the house and when activity on a device occurs within the house, by relative easy deduction, we can then use those external data points of confirmation of the two people out of the house to confirm or conclude that the person in the house was responsible for the data. There's not much, it doesn't get much easier than that. That's an oversimplification, but that's a goal.
How crucial is the time stamp of these artifacts with regard to your investigation into these types of investigations?
It can be quite crucial. You know, the amount of time, for example, in this investigation, you know, there are allegations or claims of, you know, device removal as part of the scheme to facilitate the scheme. So, you know, is the timing based on the artifacts facilitate that? Is there enough time for a device to be removed from somebody who's active on one and then be used for any purpose by somebody else without them knowing it, right? I mean, it's one thing if, you know, we take a shower, you know, if it's a 10 or 15-minute gap, that might lend enough time for a device to be removed, used, and put back.
Judge, objection calls for speculation.
All right, I'll
Okay. I think we've probably gone where we need to go on that. So I'm going to move on to the next slide. Your Honor, I'm going to identify it as Defense Exhibit 167.
Okay.
Sir, do you recognize that?
I do.
And what's the significance of that artifact in relation to your investigation?
This is a login from the Banfield residence on the same evening of February 20th to the alleged suspect account, the CBRN 920 account that was used to facilitate ultimately the FetLife and then onto the Telegram and the eventual meeting.
Your Honor, I'd identify this and ask for it to be moved into evidence number 167.
Any objection?
No, thank you.
67?
And once the ladies and gentlemen of the jury see that, can you please go over what the significance of this is?
Sure. As I said, this is a login reported by Google to the CBRN 920 Gmail account. So that is the email account that was being used to facilitate or to set up FetLife, and then ultimately to the communication, which led to the events of the 24th of February in 2023. This was on the evening of February 20th, and the time was 11:08 and 13 seconds, so 11:08 p.m.
And I'm sorry, did you mention the account that was created or that was used?
Yeah, yes, Judge asked and answered.
I just didn't hear, Judge, I'm sorry.
All right.
If it was, that's fine.
I did.
Okay. Your Honor, I'm going to move on to Exhibit 168. Oh, sorry. Is there anything additional that relating to your digital forensic analysis on 167 that you can explain to the ladies and gentlemen of the jury?
There is, I mean, the timing to me was significant on this particular artifact, but we'd have to point it out, go back to the slide prior.
Okay.
If
Your Honor,
that's possible.
If I may, I'm going to go back to this
Fine.
slide prior.
I know.
Your Honor, can we publish that to the ladies and gentlemen of the jury?
Judge, I don't believe it's been admitted.
Excuse me?
I don't believe it's been admitted.
I thought this was the one prior.
160.
It is.
No, that's
He didn't.
166.
Oh,
Oh, sorry.
Wrong way, I think.
My big fingers.
no, you had it. No, going backwards, sorry. This one. No, forward
Sorry.
one.
Yeah, you go forward one.
pressing too hard.
All right, stop.
Okay, sorry. You were saying to the ladies and gentlemen of the jury.
They know.
Is this one in?
166 is not in evidence.
Oh, Your Honor, move it in as,
166, no objection.
Okay, there we go. Now they can look at it.
okay, now we have context in terms of what you're saying. I apologize. Please explain for the ladies and gentlemen of the jury the significance of this, and then hopefully I'll move forward to the other one so you can talk about that as well.
Right. So this was, again, from Ms. Banfield's laptop, the Lenovo laptop. And this is an Innova.org website, a VPN. So that's a remote access to the Innova website where she worked. And this was on the evening of the 20th at 11:07. And this ties into what we were talking about earlier, the sequencing and the window. So the time of this particular access was 11:07 and 49 seconds. I know I've been rounding up and down and saying 11:07, 11:08, but this one's important to go granular. So we have this one at 11:07 and 49 seconds, and now if you could, sorry, jump to the next one. So this activity, which is a login to the suspect email account, was 23 seconds later, 24.
And this is identified as 167?
It's in evidence.
Yes.
167 is in.
I just wanted to say for the record.
Okay.
Yeah, so 24 seconds later. So that's the window we're talking about here. For me as an investigator with the facts consistent with this case, we've gone from a activity on the laptop that is unique to one person. In this case, to my understanding,
Objection calls for speculation.
All right, that's sustained.
Can you explain it in a different way?
we've gone from unrelated activity on the related activity on the laptop unrelated to the scheme. 24 seconds later to something central to the scheme. So we've gone from an Innova website to the suspect Gmail account in a 24-second window.
And just so we're clear, the Innova website was, what device was that on?
Ms. Banfield's laptop.
Okay. Your Honor, I'm going to move to the next slide. This will be Defense Exhibit 168?
Yes.
Okay, thank you. Sir, what is this artifact?
This is a login or usage of the Telegram app on Ms. Banfield's laptop computer.
Okay. And is there anything significant about the start time and end time, I guess?
The start time is of most significance here at this stage of our chronology. It's at 11:09 and 12 seconds p.m.
Your Honor, I'd move that in.
Any objection?
No, thank you.
168.
I apologize. Mr. Lidsky, can you explain that to the ladies and gentlemen of the jury to give them context?
Sure. This is the Telegram app in use on Ms. Banfield's laptop at on 2/20/23 at 11:09 and 12 seconds p.m. So now 59 seconds after the suspect Gmail account was in use, also from a Windows device at the residence.
Your Honor, I'm going to move to the next slide. Your Honor, may I just consult with counsel?
Right.
Is this the one that you guys have?
asking if we even need telegram. Well, which telegram? We admit so far, but we put the whole thing in. Yeah, we put the whole thing in. We put the whole thing in, so. We moved in everything, the whole document. I'm not necessarily, if you're just trying to highlight it, it's already admitted.
Your Honor, I'd move this exhibit in as Exhibit 169.
Any objection?
Just confirming with counsel that this is extracted from our previously
Your
admitted
previous
exhibit
exhibit.
of all of
Okay.
the messages. No
All right, so
objection.
169 evidence.
Thank you. Sir, what is this?
These are the telegram messages between the account purported to be used by Ms. Banfield and Mr. Ryan.
And does that coincide with what we previously saw?
Yeah, these are just a subsection of the messages exchanged on these two accounts. This relates to the time period that we're reviewing currently. So this is February 20th, 23, beginning, the first blue bubble on the left is at 11:17 p.m., and then 11:18 p.m. for the green, and then later at 11:18 p.m. for the next blue.
Your Honor, I'm going to move on to the next slide.
All right.
I believe that'll be identified as Exhibit 170.
Okay.
Sir, do you see that on your screen?
I do.
And, excuse me, what's the significance of this item?
These are FetLife messages from the night of February 20th, 2023.
And, Your Honor, I move these in as Defense Exhibit 170.
Any objection?
Again, same judge, I believe we've got
Okay.
the entire document in already.
All right, 170.
Now, sir, can you explain to the ladies and gentlemen of the jury what it is as a digital forensic examiner you're looking at in the context of your investigation of February 20th?
Sure. Well, again, on this particular date, we have some key events. On this particular, at this particular time, we've got key device usage or potential attribution and location information for the three people central to the investigation at this point in time. That's Ms. Banfield, Ms. Magalhães, and Mr. Banfield. This is a subset of the FetLife records that we've been talking about. This is particularly for this evening at this point in time, and these are only the outgoing messages from the account purported to be used by Ms. Banfield. So these, if the messages don't make sense, it's because you're not seeing the entire conversation here. We're just looking at the outbound responses from the account in question relative to this discussion.
And the name at the top there, what's the significance of that?
So one of the messages this evening was about starting, and this is in the larger, for what I analyzed in the larger FetLife communication, we saw where Telegram was installed in the prior deck, I think on the 19th. Now we're seeing where we start to transition from FetLife to Telegram by the person using this account.
Mr. Carroll, is this a good time to take a break then?
Yes, yes.
All right, let's go ahead and take our lunch break at this time, ladies and gentlemen. Again, do not discuss the case with anybody and don't do any outside research. Again, sir, since you're still testifying, do not discuss the case with anybody to include the defense team. We'll come back at 2:05 then?
Thank you.
Yes, thank you.
All right, you have been watching the Brendan Banfield murder trial here on WUSA 9+. Thank you so much for staying with us. We have been reading your comments. We've been hearing from so many of you, and I appreciate that. And I do want to start by saying if you do have questions about anything that's been going on in this trial, you can text 202-895-5599. Now, I would like to introduce the lovely woman sitting here next to me, Janine Driver. She is a body language expert. I know you have a ton of experience. You want to go through your credentials real quick?
Yeah, Katie, I'm excited to be here, even though it's under such sad circumstances. My background's ATF, the Bureau of Alcohol, Tobacco, and Firearms. I was there 17 and a half years. My specialty is detecting deception and analytic interviewing and firearms trafficking, which of course this involves a firearm, but not trafficking. And I spilled my career into writing a couple books. You Say More Than You Think, You Can't Lie to Me, and one became a New York Times bestseller, translated in, I think there's like 22 languages now. And I weigh in on cases just like this, often for Court TV and other big media outlets. I'm excited to share my content and analyze what's happening here and separate fact from fiction. And it's not just body language, there's words also, Katie, and you at home. It's called statement analysis. There are certain words that people say that have hidden meaning, and so we'll peel that back. And I'm going to talk about, I already just was watching the au pair, Juliana, a second ago, and we're going to talk about hand gestures. And we're going to talk about, even we saw Brendan just now in court. We saw him doing a chin grab pose, which I found that was very interesting. When we grab our chin, we're about to win. It's a sign that people have a little too much confidence maybe in the moment, or they're faking confidence. So it's going to be interesting to pull back the layers here in the case, and I'm open to answering any questions that people call in for you and take it from there.
Yeah, we're looking forward to getting some of those questions. Again, let's put that number up on the screen for you one more time, 202-895-5599. And I appreciate even that quick little glimpse of what we're going to hear from you, Janine. I do want to go back, though. You know, it is day 8 of this trial. Hard to believe. They are trying to wrap things up today. We will see if that happens. We have heard that Brendan Banfield may be taking the stand today, so that is definitely something we're keeping an eye on. But let's take you back to last week, specifically back to the opening statements where we heard both the attorney for the defense and the prosecution lay out what their plan was for this trial. If we're able to, let's take a listen to that.
Case of Commonwealth versus Brendan Banfield. Mr. Banfield is present in the courtroom with his attorney, and the Commonwealth is present.
We're here today because Brendan Banfield, the man seated behind me, killed his wife, Christine Banfield, and another man named Joseph Ryan.
The murder of Christine Banfield by Joe Ryan occurred on February 24th, 2023.
They sneak up the stairs to the bedroom where they hear Joe Ryan and Christine. Brendan enters the bedroom first, shooting Joe in the head, picks up the knife that Joe had brought, and stabs Christine repeatedly in the neck. He directs Juliana to shoot Joe a second time with her gun. Brendan spends the next several minutes manipulating Joe Ryan's body, in the process leaving Christine's blood on Joe's hands and pants.
The arrest of Juliana Peres Magalhães took place in October of 2023. And the whole reason she was arrested was to flip her against my client. You won't hear any dispute as to the relationship between Brendan Banfield and Juliana Peres Magalhães. But there's an awful lot more to look for, ladies and gentlemen.
The blood puts Brendan Banfield standing over Christine, stabbing her in the neck until she died. While Juliana presents us with the narrative, it is the blood evidence that you can rely upon without a doubt.
Digital forensics doesn't lie. People lie. And there are going to be plenty to see.
All right, so those were the opening statements, and you know, a lot has happened, Janine, since then. I'm going to have you talk about more of those moments in just a minute, but I do also, we've heard so much testimony. Some of the biggest testimony we heard was from Juliana Peres Magalhães when she took the stand. We do have some highlights for you, if we could take a look at that, of just some of the highlights of the first and second day of testimony.
I need help. There is my friend. She just was stuck in the knife now. She's bleeding a lot.
My name is Brendan Banfield. I'm a federal agent. This is my house. There's somebody here. I shot him.
What did you see when you went into the bedroom?
At first glance, I saw a female that was nude.
She was covered in blood with a gentleman standing over her with bloody hands.
Who is the shooter? Who shot who?
Brendan, he's an officer.
He first asked, does he have a pulse? He did follow up with, is she breathing? Or is she going to be okay? Was what he said.
What's going on this morning?
Brendan said, no, police dropped the knife, and he was saying, I'm gonna kill her, I'm gonna kill her. And I don't know, he started stabbing her. I think Brendan shot him.
Initially, we walked outside, allowed the first ambulance to leave, and then Mr. Banfield was taken into a second ambulance.
What, if anything, did you see him do while you were in the hospital room with him?
He washed his hands.
And before he washed his hands, had anyone swabbed his hands to preserve samples of blood that were on his hands?
No, I was trying to be empathetic.
Yes. No, I understand. Was there anybody who told you not to do that?
No, sir.
This case under penalty of law.
Yes.
Thank you.
Or you can have a seat.
What I told the detectives that day, it was the version Brendan had told me. Brendan said he yelled, police officer, and she yelled back at Brendan saying, Brendan, he has a knife. That's when Brendan first shot Joe. He got on top of her, and that's when I first saw him stab her with a knife. And I just start telling him, he's moving, he's behind you, and that's when I fired the shot too.
Did you see him interacting with Joe or Christine after you shot Joe?
Well, he was still stabbing Christine, and he got her blood, a handful of blood, and he starts dripping on Joe's body.
You asking the ladies and gentlemen of the jury to believe that you came out during that time frame because you wanted the truth to be known versus any time the year before that?
Well, the fact that I took a year to accept my plea, it does not mean that I didn't have any intention to tell the truth before. I had a video call with the producer who works with Netflix, and they want to make a movie or documentary about my case, and he explained in terms of compensation. So they were thinking about $10,000, but I want to negotiate. I want more than this.
You were charged with murder because you shot someone. Am I wrong?
No, you're not.
And so why would you deserve something because of that?
Not because of that. I didn't say that I deserved something because of what I did.
I didn't hear any details, so feel free to tell me why.
I'm saying for after, when this is over, for me and my family. And again, for everything we've been through.
All right, so those were some of the highlights from the first few days of testimony. We have obviously heard so much testimony since then. Janine Driver here with me, a body language and words expert, and we are going to hear from her in just a moment. I'm sure so many of you want to know exactly what she is thinking as she watched some of those clips, and then we have a ton more clips for her to take a look at. A reminder, if you do have questions for her, you can text 202-895-5599. You see it there on your screen again, 202-895-5599. All right, so I do want to bring in Matthew Torres. He has been in the courtroom all morning long. Matthew, if you can hear us, we know that court started at 10 a.m., but prior to that, there was a conversation between the attorneys and the judge. Can you share with us what you learned came out of that conversation prior?
Yeah, so at 9 o'clock, that's really, they were discussing jury instructions. And so at one point, the judge asked John Carroll, the defense attorney, who his witnesses are going to be, and she asked if Brendan Banfield would be taken to stand. He mentioned about 2 to 3 witnesses today, one of them being Brendan Banfield. So according to prosecutor Jenna Sands, as well as other attorneys who were present in that courtroom, that Banfield is expected to be one of the witnesses to take the stand. As far as the exact timing, that part we don't know. Of course, the digital forensics expert that's currently on the stand still needs to be cross-examined. Carroll still has this line of questioning left before they move on to the prosecution side of things as far as that argument. So a really big deal, something that we did not expect. Certainly the reporters who've been covering this, talking amongst ourselves, we were surprised that this was going to happen. But if there is any indication, according to one police source of mine who I spoke to there in the courtroom, it's a pretty big indication as far as how the case for the defense is going if Brendan Banfield has to take the stand.
Yeah, and I'll add, Matthew, I've been talking to one of our legal experts, Frank Salvedo. He's going to be joining us for that 3:15 break that they take, and he is very surprised that Brendan Banfield would be taking this stand. I do want to ask, we've been talking about some of the people that have been in the courtroom, the family members who have been there. Are you seeing the same family members that you saw last week and in the past few days?
Yeah, it's been consistent. Certainly the Brendan Banfield's father and stepmother has been there the whole time, and sitting opposite from them on a different bench is the side of Christine Banfield. Parents, presumably the sister, potentially two other relatives, have been consistently showing up. As far as Joseph Ryan's side, there was a relative, potentially a friend, who showed up fairly consistently last week. This week we have not seen them. There was one man representing Joseph Ryan's side. Yesterday, we weren't able to confirm as far as the exact relation, but there is specific victim services coordinator really accompanying each victim side of the family, one for Christine Banfield's and one for Joseph Ryan. So that one male individual was with the second services coordinator that accompanies the victim's side of the family. So really consistent as far as the other side throughout this entire trial. Ever so often we see some of the community members coming in and out. It seems like there have been 2 or 3 who've been consistently showing up at some point during the day.
And Matt, I'm curious to see if we see that room really start to fill up if Brendan does in fact take the stand today. I know yesterday that the judge was saying she really wanted things to get wrapped up today. It doesn't seem like John Carroll is moving that quickly. I know she told him, I want you to be done with your witnesses for the day. Are you getting any sort of sense of if he is trying to move quickly, if this will in fact be a close to evidence today?
According to Jenna Sands, again, the prosecution's attorney there, she says that he is supposed to have 2 witnesses today. So if this person on the stand right now is the first and potentially Banfield is the second, then we should at least get to him, and potentially we can have the defense resting its case today. I haven't been able to speak to John Carroll. Obviously, he's occupied and really busy, especially going down the hallways and figuring out his case. But so far, yeah, it seems slowed down a little bit, especially after yesterday. When we had Brendan Miller, the digital forensics investigator for Fairfax County Police, taking the stand, as well as starting that today. If anything, Katie, that's when we really see things slow down. That's when we start seeing jurors kind of slump over their chairs, kind of lean forward, starting to look at us, some of them not really taking as many notes. Certainly when you have exhibits to show, a bunch of numbers, a bunch of timing, and a lot of different digital evidence, for instance, that can be hard to follow. And in a way, you can see, especially last night, jurors kind of losing track, losing steam, shall we say. Even today with Brendan Miller not really capturing the attention of the jurors, I would say. This one with Lidsky, who was on the stand on behalf of the defense, it's been interesting, especially as they detail every moment, every second that's been used as far as the accounts created, the websites that were checked out on these devices from Christine Banfield. It's painstakingly processed to go through each one. There have been moments that have helped, I think, the defense. There have been moments where you can kind of see jurors who are really not following.
All right, thank you so much, Matthew. I know you got to get back in the courtroom and a lot to do there. We will check back in with you and keep an eye out for if and when Brendan does in fact take the stand, if that is today. All right, thank you, Matthew, so much. We do want to go back to Janine Driver, body language expert here with us, also a word expert. Before we get started, if you do have questions for her, you can text 202-895-5599. Now, I do want to begin with Brendan Banfield. You know, we may see him take the stand today, but I'd like, if we can, to play some video of him up on the screen. And this is going to be video of him crying, or seemingly crying, as the audio of one of the body cameras is played. And it's really the moments where he's finding out that his wife is no longer alive, and then praying with the chaplain. So if we can take a look, I'd love to hear your thoughts watching this.
Okay, as we watch this footage, I want you to notice the forehead. So the forehead is right in front of the brain. The forehead is a map to how someone is really feeling. With authentic sadness, we see the inner eyebrows pulled together and up. So when people are faking sadness, which is what I think is happening here, we see a little distress here in the eyebrows, just a little bit. But when we're faking it, you'll often see people do this. By the way, we have an ears, nose, and throat doctor for a reason, Katie, and you at home. They're all connected. So fake crying, we saw this in the same exact courtroom, by the way, a couple years ago with Johnny Depp's wife, Amber Heard. I was in the courtroom when Amber Heard was fake crying, very similar. So what you'll see with fake crying is the head will go down. People will wipe away fake tears. There's nothing even falling down on his face here. Authentic sadness, the eyebrows pulled together and up, and there's a deep swallow. So we're not seeing that deep swallowing happening right here. We're not seeing the distress in the forehead that would be equivalent to authentic sadness. So let's see here.
It's okay.
Also with sadness, the corners of our mouth, Katie, and you at home, curve down when we're sad, and we're not seeing this here. We've seen these crocodile tears before with other cases. There was a man named Neil Entwistle. He was here from the UK. He killed his wife and his young daughter, and same thing in a courtroom back in the day on Court TV. We analyzed this fake sadness. We've seen this as well with a staged murder, Dalia DiPolito. I don't know if people remember that back in the day. She hired an undercover cop to kill her husband. They pretended he was dead when he wasn't, and when she first found out he was dead, she had the same fake tears here. So this you'll often see with fake sadness, people being exasperated, like that. Ears, nose, and throat doctor, ENT, they're all connected. So when someone is sad, the rolling of emotion happens like a roll. It's slow. It's not just all of a sudden I'm sad and then it disappears. Right. So fake sadness, will often see people look down like that. Now, let me play devil's advocate. Authentic sadness, we look down too. Most people look downright. So I like to say, when you think I'm downright angry, I'm downright disappointed. So you can remember when someone's eyes go downright, you're reading someone else's movement, not from our perspective. Because us watching, someone's right is different, right? My right side is their left side. So we're looking downright. So if I'm here talking to you, Katie, and you ask me an emotional question, and I take a second and I go, that makes sense. We have sighing happening when we're sad. And again, these inner eyebrows pulled together and up. Let's imagine if like you had a little fishing line right here. It's hard to fake. I'm sure the actor Jim Carrey could do it. It's really hard to just fake it. And that's why sadness, when it is fake, we can spot it. And for the viewer at home right now, all you have to do is watch it and feel. See, we have mirror neurons. So when someone is scared, we feel scared. That's why in great movies with great actors, when they're sad, we're sad. But when you watch fake crying, something doesn't happen inside of you. You're like, I'm just not feeling it. And that's the difference between a great actor and a fake actor, a bad actor like we see Brendan doing here. I believe this is fake sadness. And you're not feeling it. Marion Jones lied. I don't know if you remember her, but she was a track star. She lied about taking steroids. And she had this big, huge radio interview and TV interview, fake crying, and no one bought it. Again, watch someone in their emotional state. If you're not feeling it, we have mirror neurons, which means you yawn, I yawn. We are human beings, we are connected. So when we're just not feeling overwhelming sadness, then it's probably fake. Which it is here.
That's so interesting, and it's impressive that you nailed down so quickly the belief that it was fake. There was not a moment of hesitation for you.
No, because that's not authentic sadness. When you see it, your heart, it's like, oh my God, this man's wife died. She was killed, and you just feel the anguish. You feel the sadness, right? And you're not feeling it right out of the gate. So as soon as that clip came on, not seeing the inner eyebrows pulled together and up, that anguish, and the face being, I mean, I can fake sadness better than him. By the way, there was another guy out of Chicago that staged that fake hate crime. I don't know if you remember him, Jussie Smollett. And he staged this fake hate crime, fake cried also on camera, and no one was buying it. You know, so you just trust your own gut. You know, we have nerves in our stomachs, that's why we say trust your gut, that are communicating with our brain. And here's the deal. Body language shows up before thought. So if we can begin to learn how to decode body language, you know how someone feels before their brain knows how they feel. But he's coming in being prepared to fake cry. His brain is involved first, and then the body language. So it comes across as incongruent. It's not that slow roll that I was saying should be happening here.
But let me ask you this. I know you have a law enforcement background as well. You know, I'm sure there was a conversation, I've spoken with our legal experts all week about the conversation that likely happened between defense attorney John Carroll and Brendan Banfield. Do you think it was part of the plan, like you should cry? Does this look like a staged cry at this moment to kind of get the attention of the jurors?
I doubt that a lawyer was coaching him to fake cry. That would surprise me if someone's saying fake cry. I think maybe they might say, be in your emotions, or sit with it, or, you know, break eye contact, maybe something like that. I can't see a lawyer really saying like fake cry, but maybe, you know, give less eye contact, sit with your emotions a little bit. And he just fails at it. He just fails at it. And you look at it and you go, this is not a broken man. This is someone faking. Even the way he's touching his face, Katie, you can feel that it's so mechanical.
You mentioned his chin before the break, and you mentioned how he was leaning on it.
Yes.
Talk more about that.
Well, I like to say, so our brain is where, when we're very stressed, we'll start to touch our face. They're called pacifiers or self-touch gestures. So if I said, who's on the phone, who's on the phone, who's on the phone, who's on the phone? This person stresses me out the most, right? Because who's on the phone, it's like, I don't want to deal with this person. So what happens is, when we are stressed, we have an increase in these face touches and pacifier moves on our body and our face. The face ones are high stress. Here what we're seeing is these fake touches to throw us off his track. They're mechanical. Earlier, when I was talking about the clip from today, while he's live in the courtroom, he started chin grabbing. And I like to say, when we grab our chin, we're about to win. If you are in a meeting, or if you're in sales or business, and you notice you start to get nervous and you're touching your throat or rubbing your neck, a great 7-second quick fix is stop rubbing your neck and grab your chin. Look how intelligent I look, right? Now it looks like I'm going to law school. Now I'm the lawyer, right here. So when we grab our chin, it sends the message that I have calm thinking pose. I'm thinking, I'm processing. Now, could he be coached on this? 100%.
Well, we also know he is a former IRS agent. Is that something you would learn?
Oh, 100%. He already knows about body language. The IRS, when you're being trained, any of the federal law enforcement, you're either training at the Federal Law Enforcement Training Center, FLETC, over in Glencoe, Georgia, where I taught and trained, or you're over here in Virginia at Quantico. I think the IRS trains at Quantico, but there are nonverbal classes that they take. But here's the deal. People always say, Janine, but when you teach people how to spot someone is lying, aren't you teaching them how to be a better liar? The opposite happens. So the more you know how to tell if someone's lying, the worse liar you become, because now he's thinking, oh, I've got to touch myself, because people under high stress touch their face. And now that's where that roboticness comes in.
Overcompensating.
He's overcompensating because he knows. By the way, we saw this too with, what's his name? He murdered his pregnant wife and her unborn son, Connor, Scott Peterson. So Scott Peterson, he said, but he was a smart master manipulator. When he was asked, tell me about Lacey Peterson, when you last saw her, the ums disappeared. She was wrapping Christmas presents in the living room. All of a sudden, his ums disappear. When detecting deception, we're looking for a change in someone's baseline. So someone like Scott Peterson, similar to what we have here with Brendan, smart enough to know the everyday person thinks that liars The everyday person thinks that when someone is under distress, we touch our faces. And so it comes off as robotic. We're looking for the anomaly. And we have it right out of the gate. And I know that your viewers are smart enough to feel immediately, I'm not buying it.
We've seen a lot of the comments from people on YouTube and, you know, just texting in that they're not buying it. But, you know, we always want to play devil's advocate. Maybe he is crying. Everyone grieves differently. You know, who knows?
Correct. That's correct. That's great. And I love that you said that. Yes.
Yeah. And I think I've learned that through this process of seeing so many people at the worst moment of their lives. People do grieve differently. Some people start laughing. So it's interesting, though, to hear about the different tells, especially the face touching. Let's transition to Juliana. You know, we've seen her quite a bit up there. Maybe we will see Brendan Banfield today, or maybe that'll be a few days from now. But, you know, I'm sure we'll chat with you more once we see Brendan and the way he talks to the jurors. But let's get to Juliana. When she was testifying, there's a part of her testimony where she's talking about the moments after she fired the shots at Joseph Ryan. If we could take a listen to that, I'd love to get your thoughts on that after.
Yeah.
What did he look like when he saw Brendan?
Shocked.
After Brendan shot Joe, did anyone say anything?
If anyone said anything?
Yeah, did anyone say anything in the room at that point?
Yeah, because Brendan ran to Christine. She was still on the floor, and I think that point she had seen me, and she said she had asked her what to do to Brendan. I think regarding to that he shot Joe, and she said my name. She told me, Juliana, call 911.
All right, Janine, just quickly, your initial thoughts after watching and hearing that.
The big thing that's popping out for me here, Katie, and you at home, are these tongue protrusions that we see. When someone sticks out their tongue, it can mean a bunch of different things. It can mean, I just got away with something. It can mean, this is easier than I thought it might be, because we see her tongue come out when she talks about her plea agreement that she gets. Hey, I don't believe that I should get off because I shot someone. It's for something else. And then we have that tongue protrusion that comes out. So it could also be, that was risky. And so I want you to think, and I know this is overly simplistic, and I got slammed for this once on CNN with Anderson Cooper, which is when someone sticks out their tongue, it's like a little kid that goes, na, 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 you know, and they would see that. It's like, I'm getting away with something here. And so we see a lot of tongue protrusions with the au pair, Juliana here, and it's not planned. This is usually where there's a spike in stress and anxiety. I don't think she consciously is aware that her tongue is coming out, but
Just
it's
a
happening.
natural reaction.
Yes, and it's happening many, many, many times here. And so when there's a spike in stress and anxiety, you'll see that, or when someone is holding something back, or they think they got away with something. So they'll all of a sudden. And the next time we put in a tongue protrusion, sometimes you might be watching a court case at home and the tongue, while someone is thinking, sticks out like this, right? They'll go.
Yeah.
If someone is thinking and sticking out their tongue, that is deep concentration. So I want you to imagine we're threading a needle right now, right? So we have the eye of the needle, Katie, and I'm trying to get that thread through. You'll see someone stick their tongue out as they're doing that. Deep concentration, that deep focus. When you see that, when someone is listening and the tongue protrusion is happening and it's sitting there, you have to stop and say, does it make sense that the person would have to do a deep focus right here? Like if I said, what color is your blazer?
Right.
Do you have to have deep focus, right? Do you have kids? Yes or no, right? Ask me, do I have 5 daughters? No. Right. Why do I have deep concentration? So when we see Juliana, if we see Brendan on the stage today, or on the stand today on the stage, you can tell I'm a keynote speaker, I always think in the stage. But if we see him on the stand, we're gonna look for those deep concentration tongue protrusions, which is, does it make sense that there's deep thought here? Juliana's body language is very interesting, not just here with her tongue sticking out, but other footage that we've seen along the way. When our hands get involved, maybe we'll see some stuff here, some footage. When our hands hold to ourselves, I'm holding something back. When I reveal my hands here, it's, hey, I'm telling you the truth. So I am looking for these hand gestures coming out. I'm not seeing it on the stand. Granted, we're only seeing from this part up.
Right.
But we are certainly seeing some of these tongue protrusions.
Yeah, and you mentioned the hands, and you know, this conversation that you just watched, that was when she was being questioned by the prosecutor. She probably felt a little safer with them when she was being questioned by the defense. I would love if we could go back a little bit and show you some of the body camera footage. I know we were watching that. I'd love to get your thoughts on the body footage, if we could play it, but also hear your thoughts as it's playing. I think that would be great. Are we able to do that?
People upstairs. I can mark her if you want. Thank you. I'm sorry. What's going on this morning?
I was going out with the ball.
It's okay. Take a breath. It's okay. Take a minute, okay?
We need some water.
You want to sit down somewhere? No.
I just need some water. I'm sorry, English is not my first language.
Oh, you're fine.
I was going out with the ball. I told her it's her daughter.
Okay, yep, she's sitting over there.
And then I forgot our lunch.
This is performative compassion, what we're seeing here. This is performative. And the reason I say that is even though she's involved in this shooting and prepared this murder with her host dad, Brendan, look at how big her body language is getting. She's doing a half Superman pose or a Superwoman pose, right? We see her right hand go on her hip many times. Her left hand goes up to her forehead. She's taking up space. She is trying to generate some confidence here on what she's going to be saying to the police. And how do I know that? Because when we look at footage, when someone was involved where you're there at a murder scene, you tend to get smaller. You are self-soothing yourself because you're in this shocking moment. But she's taking up big body language. Why? This is performative right here. She has her staged comments of what she wants to give. Look at this big body language here. This is out of sorts for someone that was just involved. Even if you weren't a participant in the murder, if you just were there, this is out of place when we look at footage from other crime scenes, this big body language. By the way, she's also, look at her head is held up. She's not in internal dialogue or emotions. So emotions, we talked about briefly, Katie, a second ago, is downright.
Right.
So where is she going?
She's going up left.
She's going up
Yeah.
left. You know what that is? It's called visual recall. So she is visualizing what she said she was going to say happened. So we see this too when Jussie Smollett with his staged hate crime over in Chicago a couple of years ago, because she already has a different visual in her head. Remembering not reality, she's not processing downright, which is emotions. She's processing through the story her and her host dad, Brendan, had already concocted prior to this murder. Now she's getting small. Why? Because she just gave a whole bunch of lies to us.
Right.
She's now exhausted, she's depleted, and look at, she's almost in the fetal position.
Right.
This is like you just did something very scary. She should have came in the fetal position, but she comes in big, taking up space. After she says that first initial, here's what I promised I would say,
Yeah.
then what happens? Fetal position, really small, on the ground, almost like a little kid. Why? Because it wasn't the murder that is making her small. It's the lying about the murder. That's actually the big ask for her right here mentally is, okay, I got out the most important stuff. Now I'm gonna get small. Does this make sense?
Yeah, no, it
So it's
definitely
out
does.
of alignment here. We should see smallness when it begins. Like, oh my gosh, like, think about a Far Side cartoon, right? We become a smaller target. We don't walk around saying, hey, look at me. Look at me. That was her generating confidence to say what she promised she would say. It's out of sync when we see crime scenes like this.
Okay, Janine, I do see that we are getting some questions, so I'd love to ask you some of those if you're ready for it. And again,
Yes.
if you have questions at home, you can text 202-895-5599, and we will try to get to as many of them as we can. The first question we have is, does she, as in you, believe the au pair is as naive and innocent as she has tried to pretend?
No. I mean, come on, she's a grown-up adult. She's traveled from another country. English is a second language. Do I think she's naive? Absolutely not. She's not. She was responsible for a little baby, a little child. So, and by the way, do I think just because someone's not naive, do I think that means they're intelligent? No. I mean, she was posting pictures with her host dad in the bathtub, you know, and then putting an emoji over his face. I mean, this is not someone who is showing high emotional intelligence. By the way, anyone who says, okay, yeah, so the only solution is we have to kill her because you'll have to pay child support and you won't have custody. I mean, this is someone who is not exhibiting high emotional intelligence or high IQ in general. I mean, get divorced, let the chips fall where they may. I mean, murder is a big deal.
Yes.
This is a big deal. So do I think she's naive? No. Do I think that she should be held responsible for her behavior? Yes. And according to the court, you know, once she's finished with doing what she's doing here, she'll probably be back on her merry way and living her own life. Like other people that have gotten away with murder that I won't mention some names, but we've seen people. I do not think she's naive.
Do you think the prosecution was trying to present her that way? I don't know if you saw photos of her before, but she had this long blonde hair. The photos they shared were red lipstick, all done up, tight clothing, but now we're seeing her with this brown hair. She's got the thick glasses on, no makeup. When we do see her face, there's clearly no makeup. What do you think is happening there?
Well, this happens across the board, right? So we saw this with Jodi Arias. Jodi Arias slaughtered her boyfriend, Travis Alexander, stabbed him many times, shot him. We saw this with Casey Anthony. And quite frankly, we've seen it with non-murderers. When Paris Hilton got out of jail, you may remember, Paris Hilton came out and she was holding her hands like this when she exited jail, like she's like a princess from another land, you know. Without a doubt, the defendants and the people that are on the stand, they are being coached. Their body language matters, their hairstyle matters, their outfits that they're wearing.
Clothing color.
It all matters.
Yeah.
Clothing color 100% matters. It impacts the jury, it impacts the judge, it impacts us, the viewers, as we're watching people at home, whether we give them credibility or not. So without a doubt, going to that natural color, not having the lipstick, not having cleavage out, it's setting up this young woman who came from another country to help, you know. I'm not buying it, and clearly your viewers and your writers,
they're asking about it.
They're probably not buying it either, especially when you see that change. This is what I was saying, that I think the word manipulative is really important here, is that be careful of us being manipulated by the optics. And here's the deal, you know, we are manipulated by optics. My son's going to Japan this year, August to August, for his junior year of college, and I found something fascinating about Japan. If you're marketing, if you have a picture of ice cream and the ice cream is this big, when you open it up, it has to be the exact same size, and that doesn't happen here in the United States of America. So we change our color, we change our advertising. All this is visual marketing to manipulate us at home, to think this is just an innocent person that got fallen into this web of an investigator that works for a federal agency in the government. I don't think that's what happened here. It was not a spontaneous thing that happened.
Yeah, you're not buying it for a second. All right, I do want to play you one more soundbite from when she is being questioned by the prosecution, and she's talking about why she told police what she did in that body camera footage that we just watched. If we could take a listen to that.
What I told the detectives that day, it was the version Brendan had told me. If I was ever to talk to a lawyer, or this is ever going to happen, like this is what happened. The version I told the detectives that day, and that I eventually also told his lawyer the same version.
Okay, so what do you think of this when she's explaining all this?
Well, we see the tongue protrusions that we talked about quite a bit already, and we see her lips disappear. What I say is, I like cheeky expressions, Katie. When we don't like what we see or hear, our lips disappear. So if you and I were talking, you go, Janine, I'd love to have you back, and I go, that would be great. And
so
my
you're
lips
saying
disappear.
no.
Well, it doesn't mean that it's no, but it means there's a spike in stress here. Maybe that we're supposed to have a big storm tonight. Are we getting a foot here in Fairfax County area? Are we going to get 2 feet? So my lips disappearing means there's something I'm withholding from you. It's like you opened a file cabinet and you opened a file that says top secret. So emotional control. So lip roll equals emotional control is what Dr. David Matsumoto says. So I say when we don't like what we see or hear, our lips disappear. So we have that right there at the end of what she was saying, along with those lip protrusions. Now what's very interesting here, which I don't think she was probably coached on, I think she did it naturally, is at the end of this comment, she did a head tilt. And when we tilt our head, this is I'm innocent. This is very childlike. This is I'm paying attention here. This is like, please don't hurt me, I'm protecting my neck. So we saw this with when Barack Obama was running for president for the first time. He was being asked by Bill O'Reilly different questions. Do you think we're in a war right now with Iraq? If we are, what will you do if you become president? People who watched the interview said Bill O'Reilly was easy on Barack Obama. But people who listened in their radio said, Bill O'Reilly let Obama have it. Why? Because in the interview, Bill O'Reilly had his head tilted. Do you think we're in a war right now? If we are in a war, what will you do if you become president? And it looked like he was throwing a softball. But if you heard it, it was strong. So why do I share that with you? This head tilt at the very end that you just saw at home, that is like, see, I am an innocent person. I am naive. And I think that she probably didn't do it intentionally, but in her brain, she's like, I'm just a victim here. I'm just a victim here. And it comes across as childlike.
All right, well, let's switch over to what the defense and her reaction to some of the defense line of questioning. I think we're both going to see the same on this, that she has a different personality up on the stand there. If we could take a listen to when she's specifically being asked by the defense and reading some of the letters about the Netflix deal that she was trying to negotiate. I'd love you to listen and react to that.
Just give the details as to why you think you deserve something.
In my point of view, it's always been most about my family and what I've put them through, what they've been going through since my arrest and all this had happened, what they've been struggling with. And so my whole point was about helping them, because that was something that when I was working before. And if they can have something to help them, I want them to have it.
Okay. But you're saying we, which includes you. Is that right? And
Well, yeah.
You deserve something. What does that mean?
Take literally the word we, yeah, that's me.
So what does that mean, you deserve something?
Judge, I'm going to object. It's been asked. She just answered it, and she answered it very well.
Overruled. Can you ask?
So I'd love your reaction here, but then I do have a follow-up clip where this sort of continues that I'd love you to look at as well. Do you want to react to that one first?
Yeah, briefly. Well, of course, we see the tongue protrusions coming out again, and then we see this face touch happening once there's a little pause, like objection, and I believe that she was probably dying to scratch her face during that time. I have no doubt in my mind that she's been coached, watch your face touching in general, because when people are being deceptive, they'll often touch their face, especially their noses.
Okay.
This sounds crazy, but in our nose, we have something called erectile tissue, and it's very similar to the other erectile tissue, which means when it gets overly stimulated, it gets itchy, it engorges with blood. And so when people begin to lie, especially on the stand, they'll try their best to hold back, and then all of a sudden you'll get these nose itches. You'll see this in sports, Katie. A baseball player, right, or a team will go into a bar after a game and they're all scratching their noses. Why? Because the adrenaline is pumping, the nose is getting engorged, so that face touch right at the end where there was a little bit of a pause, that doesn't surprise me.
Okay. Do want to play you another clip if we can. This is about the Netflix conversation that she was having with some of the Netflix producers. If we could take a listen to that.
I had a video call with a producer who works with Netflix, and I wanted to make a movie or documentary about my case, and he explained in terms of compensation, money, etc. Things that Josh had denied, saying that don't do that, right? Anyway, he wants to finalize the contract already, so when I live here, we can have the interview and everything else. But they want to be exclusive, so I can talk only to them. It's worth it. They want to pay because they want to talk to you too in interviews, and you share photos, videos, facts from when I was a child, adolescence, etc. Things for them to add to the movie. So they're thinking about $10,000, which would be around $55,000 in our money. Helps and it's good, but I want to negotiate. I want more than this, because if I sign the contract, I end up losing other opportunities to make more money if I talk to other producers, etc. Right? We have to think. I know I can make even more than $25,000. It would already be more than $100,000 in our money, right? Think about our future. What do we want to do?
She's obviously reading, and the last one you heard was when the defense was sort of questioning her, why is it you think you deserve this? And you saw part of that clip. There was a little bit more to it where he keeps going back and forth with her, but just, we saw it earlier. You saw the part where he said, why do you think you deserve that? Yes. You shot someone, and she said, she pauses. And that's what stood out to me, when she took that long pause and she just stared at him. What do you think is happening there? Well,
when we pause, we're trying to gather our thoughts and what we're going to say next. I think that sometimes when we watch footage, there was a TV show I used to watch called House. In House, he was a doctor, and he'd put all the, her foot is bleeding, her head hurts, and he'd write all the symptoms. And sometimes the missing link is the thing that is not on the board. And so when we watch the footage here of the au pair, Juliana, I think the missing piece that's not on the board is emotions. Where are her emotions, right? Where is the sadness? eyebrows? Where's the processing? Where are the deep sighs? Where are those downright looks where it's like, how did I get myself involved in this? I mean, not only that she was participating in it, but now she's involved in it still here, and she got caught. If we look at her eyebrows, okay, you have curved eyebrows. Okay, there's something called physiognomy. Physiognomy is about the shape of our face, our nose, our jaw. So you have curved eyebrows. People with curved eyebrows like you, Katie, are people who think, when I'm sharing information, how does this impact the people around me? This information I'm giving you, how can this impact my team, my family, my boyfriend, the people around me, my dog? How does this affect the people around me? We see with Juliana, she has straight eyebrows on both her right and left side of her face. Our left side is, imagine your wedding ring here, is your personal side of your face. Your right side is your business side. So you could have a different eyebrow on each one. You don't, you have curved. So both at work, you care. And by the way, you were here with another on-air host and small talking about her daughter, and I already witnessed this with you. I also have curved eyebrows. Straight eyebrow people, you can even see them above Juliana's glasses. They want to get straight to the point. Facts, figures, what do I need to know? It makes sense that she could get pulled into this situation. Okay, how are we going to kill him? How are we going to do it? How are we going to do that? What are we going to say? Facts and figures, instead of how does this impact the mother of this little girl that I've been watching? How does this impact my future? How does this impact the family, the people who are watching? We don't see emotions. Now, I'm not saying people with straight eyebrows don't have any emotions, but I'm saying when they receive information, they process through facts, figures, get to the point. If I was selling to someone in sales with straight eyebrows, I'm going to say, here's the price, here's when you can get it, here's the deliverable date. This woman is not showing not only emotions, she's not showing us how this impacts her life and the people around her. It's missing. It's missing. She's just simply reading statements. Even reading a statement, I could read a statement, I could read a poem and get choked up at the end of a poem.
Yeah, and this is a statement with a lot of information in it, a lot of information that's crucial to this case. Do have another viewer question for you. They wanted to know, what did you think of the au pair's body language when she was being questioned by the defense lawyer? You kind of answered that already, but anything to add on that?
Well, I do find it is interesting to me that we're not seeing hand gestures in the courtroom, and this is why it's interesting, because when we saw that undercover footage of the footage on the police camera, right, the body camera in the driveway, what did we see? We saw a very dynamic woman, right? We saw hands on her head, hands on her hip in the half Superman pose, right, talking a lot with her hands. When our palms face ourselves, this is where the lies are. I'm withholding information. A lot of liars will tell the truth, and when they're telling the truth, they're doing this. It's smoke screening. And I was here, and he had a knife in his hand. Okay, when someone shows us their palms, this is where the truth is. When the palms come in, these are where the lies are. So pay attention. I was on a show once called The Big Idea with Donnie Deutsch, and he told me 3 stories. One was a lie, 2 were the truth. The 2 truthful ones, blah, 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 people who are late and people who are cheap drive me nuts. And the first time I lived away from home was sleepaway camp. And the nicest thing my father ever said to me is, I remind him of his father. I said, that's the lie. And that was the only tell. And he said, how did you know that? I go, this is what I do, Donnie. So paying attention, because when people lie, this is what's important for us to remember, Katie, and you at home. It doesn't mean everything they're saying is a lie. They'll stack the deck. Oftentimes liars will stack the deck up front. We even heard it with Brendan when he called 911. This is my house. My name is Brendan. My name is Brendan. This is my house. I live here. They'll stack the deck up front with things that are truthful before they tell the lie. And here's what's important. A truthful statement has the pre-story. But guess what? 50 to 60% of the trauma of the incident should be the story. So 50 to 60%, the killing, the shooting, and most liars forget the 10% afterwards. So we want a little setup, 50 to 60% the actual incident. So if we look at all the sentences, even at a 911 call, and you add up the amount of words, very easily, do the math, figure out how many words was the beginning, the smoke screen up front, the truthful things always tend to come up front. Now the actual incident, my wife is dead, my wife has been shot, this man has been shot. Yeah, if that is shorter than the intro, you have a disconnect here. It's likely there's some deception happening here. And then what is the after story? So there's a lot happening here verbally and non-verbally, and I'm thrilled to be able to share this with people, because you can take it from this case to your everyday life. And I think the biggest thing is ask lots of questions. Ask lots of questions. When a hotspot doesn't mean someone's lying, but it definitely means they're holding something back. It's asking those additional questions.
I do have one more clip that I want to play for you, because I think this is where I really started to see her completely change change. She gets incredibly frustrated. I would love to play that clip for you when she's talking to the defense attorney and she says, with all due respect, and that's when things kind of change. So let's take a listen.
Sir, with all due respect here, I said those things are all very familiar words. We used with all the people we communicated. So if you want me to be specific, again, I might say it's me, or I might say it's Brendan, and if I'm not sure, what am I doing? I'm guessing, and I'm not doing this.
So you're not going to answer my questions about specific pieces of evidence that I'm showing you?
Objection, she answered, objection asked and answered, objection argumentative.
I think she says she's not going to do this.
You want to approach this?
This is a hotspot in the detecting deception world, and here's why. We're assuming that it's respectful every step of the way. So like if you went through customs from Canada to the United States and I said, what are you coming into the United States for? You go, I'm going to my sister's wedding. Great. And do you have anything in the trunk of your car? No, ma'am. Why did you all of a sudden, ma'am, me at that particular part and not in the beginning? So when someone gets overly respectful, sir, with all due respect here, this is where we should be on high alert, because I'm assuming, it's like when someone says, hey, to tell you the truth, well, I'm assuming that everything you're telling me is truthful. And now all of a sudden so is what you said up to now not truthful, or now are you overcompensating? Truthful people convey, Katie, and liars try to convince. So this is a hot spot here. And quite frankly, I found her to be a little smug and arrogant in this particular clip. She doesn't come across as likable, and you can feel that little bit of a snarkiness there, that bite, and I think that overrides this I'm an innocent, naive person when you hear that. With all due respect, I want to, listen, if someone I was dating talked to me this way, I would not be happy. So it's saying the word respect, but it's actually disrespectful the way she's saying it. Did you get that?
Definitely. And you know, at various points when we were watching these different clips, at one point she's wearing her glasses, at one point she's not. She had her glasses on the entire time the prosecution was asking her questions. But as we started to see her get frustrated with the defense's line of questioning, and keep in mind, she was up on the stand for hours. He had her up there for a while. He was asking a lot of the same questions in different ways, so he was trying to clearly get under her skin. But we see her take her glasses off and just look at him and stare at him. What is that all about? Why would somebody remove their glasses if they had them on the whole time? I guess two questions for you. Why would someone wear glasses? You know, we don't know her eye vision situation, but is there a connection there to body language?
Well, it's very interesting because, and I don't know the story behind her glasses, but I once dated a guy that his whole shtick was wearing glasses, right? In every picture, every video, you'd see this guy in these glasses, these circle black glasses. And I was shocked when I started dating because he left them behind once at a hotel. And he's like, oh, it's not a big deal. They're from the Dollar Tree store. I go, what do you mean? And they were readers from the Dollar Tree store. But he would wear them every time he'd be in a video, he'd be in a podcast. He's not reading anything, but he was reading them. So glasses tend to make us look more intelligent. And so some people use it as part of their shtick. So maybe in that moment where she took the glasses off, she's like, now I'm looking at who you really are. And maybe it was just instinctual and she didn't even realize that she did it. Maybe it's, hey, I want you to take me seriously here. Maybe she was just like, lets her guard down in that moment. Here's the thing about body language. We never know what the catalyst is. We can notice the behavior. We can say there's definitely a change in behavior, which is suspicious. That's a hot spot. Anytime someone's behavior suddenly changes, it's a hot spot. It says, I need to pay attention here. So if I'd seen that, I would rewind. And I like to watch the video without sound first and say something weird just happened here. Rewind what was happening, what was being said in that moment. And it could be her way of trying to intimidate somebody. But it's interesting because it makes me wonder, is it a costume? Are the glasses a costume to make her look intelligent?
Right. And we're actually playing that clip again. I would love to get your take on it as we watch it, but then also your reaction to Brendan's reaction to her.
Okay.
So you see she's fidgeting with her glasses there.
Yeah.
And you know, your reaction to watching all of this. And then you'll see Brendan in a minute as it zooms in. So see this moment here where we're going to get a little closer to Brendan and
Yes.
we see his body language change a little bit. Just your thoughts on
Okay.
that part. What are your thoughts on that?
All right, so he's actually first touching and rubbing his chin, but now he's covering his whole entire mouth here, which is when people cover their mouth, it's I'm keeping my mouth shut here. Look at that. I mean, put your hand up like that and try it out. Literally put your hand over your mouth and feel what that feels like, and you can feel I'm withholding my information. Now he's closing his eyes, looking down. This is emotion. So he's processing through emotions and he's thinking. What's really interesting, a second ago when we replayed it, thanks for replaying it, Katie and the producers here, is that in that moment, she said, I'm not answering it. Her chin went up. When someone's chin suddenly goes up, it's like I'm looking down my nose at you. We don't want to be in a courtroom when you're talking to an attorney with your chin up like this. It's again a sign of arrogance here. Right. So she comes across as arrogant. I'm not going to answer that, and her chin goes up. If you are interacting with someone and their chin goes up, it's as if they're looking down their nose at you.
All right, I'd like to actually, if we can, go to some video we have of Juliana crying in the courtroom at various points we saw. And I'm curious to see if you also find these to be not authentic, as we saw you found with Brendan. Are we able to show that clip and we can kind of talk about it? There you go.
Oh, she's biting her lip right here.
Yeah. So this is just video clips of her as she's being questioned.
Okay, so this is, look at, 3 things just happened. She bit her lip, then she pushed her tongue inside the bottom of her lip, and now her hand is covering her mouth right here. Do you feel this? Try those things out at home. Now, like she's doing this with her face. Look, her tongue was inside her lips again. She's holding her breath right there. That was holding her breath. These are all pacifying movements. This means a spike in stress and anxiety. This does not mean sadness. We don't see sadness, Katie, because there's no inner eyebrows pulling together or not. So what people might be saying is this sadness, the answer is no. Let me think about it. No, this is high stress, biting her lip, high level pacifiers. The tongue inside your mouth, pushing on your lip or your cheek, high stress, massive stress, biting her lip right here.
Yeah.
I mean, think about it. This is the kid that just got caught with their hand in the cookie jar saying, Mom, it wasn't me, it was this one. These are high stress moments. They're high level pacifiers. And we saw, I don't even know, about 12 to 16 of them in less than a 60-minute clip. This says to me, her brain is really hyperactive right now. And what's still missing? No emotions. She's not going down right. She's not getting emotional here. This was not sadness. This is high stress right in these moments.
I am curious what you think, because right there towards the end, we did see her kind of go like that a little bit. Did you notice that at all?
I missed it. I must have been taking
a
quick note.
For you? I'd love to get just another reaction to it. I'm just curious if that was a moment of sadness, because we're watching this and we're thinking, oh, she's crying. We see her wipe her tear, or what we thought were tears, away.
Yeah. So what you're seeing there in that part that you just clipped, had them play over, is you're seeing dimpling in her chin. So dimpling in the chin, and this is why I think we're looking at it and saying sadness definitely happens with sadness. So the dimpling in the chin, we see dimpling in the chin right here as if someone is holding back sadness. So is it a spike in stress and maybe a little sadness sneaking out here? Yes, but here's the deal. This is not dramatic sadness. This is not a woman I cared about was just murdered and I was in the home when this was happening. This is not that. How do I know that? Because the inner eyebrows, the forehead is not getting involved. This small sadness is what's called a subtle expression of sadness or leakage, emotional leakage. It could indicate, how did I get myself into this situation? It could indicate, I can't wait till this is over. We don't know what the catalyst is. But this is not authentic sadness. The quickest of all emotions, Katie and you at home, is surprise. Surprise happens in less than 2 seconds. So if I throw you a surprise party, or my boyfriend Craig, I say, surprise party, his birthday's in September, and he comes in, he's like,
that's the initial.
Someone told him there was a surprise party, because surprise only happens for 2 seconds. And surprise is always a catalyst to another emotion. I come at you with a knife, surprise to fear. A surprise party, surprise to happiness or sadness. But sadness sticks around. Sadness isn't a 2-second emotion. Sadness slowly erupts. Our inner eyebrows pull together and it stays there in anguish. Our face might have that jaw dimpling and then the forehead is engaged. I'm faking the engagement, even with my forehead. We have no forehead activity. And I highly doubt this young woman is getting Botox, right? So this is incongruent with someone who is devastated about the killing. Maybe a little bit of sadness you're picking up on the dimpling of the chin about being in this situation.
Yeah, and I want to be clear, we know sadness, we don't know what the sadness is. She has been up on the stand and being interrogated. Is it sadness because she's uncomfortable
Yes.
that kind of sadness. So I'm so intrigued by all of this. I would like to play you one more clip if we can. It's when the prosecution steps up. It is a defense clip, but it's from when the prosecutor steps up to ask that final question. And this is after the defense has been, you know, peppering her with question after question. You then see the prosecutor come back up to try to ease her back down. Are we able to play that clip for you?
Everything that you talked to me about yesterday,
Yes.
was that all the truth? Is that the truth?
It is.
Judge, I don't have any further questions.
All right.
Okay, so that was after the defense had just been question after question for hours all day.
I don't think you need me on this. What do you think?
It's not about what I think.
Well, we see that
Yeah.
tongue protrusion. And not only do we see the tongue protrusion, Katie, and you at home, but she went to the corner of her mouth, right? Which is deep thought, because it's like, what am I gonna say here? And then she said, yes, it is. So at first we didn't hear her, so she had to repeat it. When people are being deceptive, the voice often goes down. 85% of the time when someone's lying, you'll have a tone of change, either up or down. Majority though, is that tone of voice going down. Granted, English is a second language, but when she answered, it wasn't a strong yes, so we had to hear, excuse me, what was that? And then she said yes again. So that lower tone of the pitch, the tongue protrusion, again, indicates to me there's more to the story here.
Now, you know, we're talking about how she is from Brazil as well. Are there any cultural things that could be happening here that we're not picking up on because of cultural differences?
Absolutely. I don't see some here. There's a great book out there if you are interested in cultural exchanges and differences. It's called Kiss, Bow, or Hold Hands, and it's written by a couple different people. They update it every couple of years, and it's the difference both someone from China who's 24 versus someone from China who's 84. So with regard to Brazil, by the way, I've had au pairs. I've had 22 au pairs.
Wow.
My oldest son is 20, so I've had au pairs since my oldest was 1 year old. I have two littles, 11 and 12, Charlie and Jack. So I've had two Brazilian au pairs. So I've had au pairs from Brazil living in my house. There are definitely cultural differences from the United States versus in Brazil. With regard to testimony here and body language, there is no cultural shift that we would see with what we're noticing here today. There's nothing out of the norm, other than that change, because a lot of Brazilians use this big body language, which is what we saw with the camera on the body cam. I keep forgetting that word. Thank you. Thank God you're here, Katie.
No.
We saw that. That's very indicative of someone from Brazil. We would see this big body language. No hand gestures in the courtroom says to me, why is she not showing us her baseline? What is happening here? Where are the hands disappearing? But even the face is revealing, like that chin up is saying more than she might think. People think it's all about the hands, but the face says more than you might think too.
Now, I want to talk to you about another clip that we unfortunately don't have today, but I'm going to try to describe it to you, and I think you've gotten a pretty good idea of what Brendan's facial expressions are. But there's a moment after Juliana testifies, and she's walking out of the courtroom, and we see him follow her with his eyes. Is it common, from what you've witnessed in the past, for the person who's on trial to watch the person? What is the message that's being sent by watching someone so intently as they walk out?
Well, again, we don't know what the catalyst is for that, but it's interesting because in this same courtroom with the Johnny Depp trial, Johnny Depp never watched Amber Heard coming and going. He had no use for her. She was dead to him. But Amber Heard watched Johnny Depp. I was in the courtroom a couple times. She watched him like a hawk when he would come in, when he would leave, and she would keep an eye on Johnny all the time. So if you think about it in that regard, maybe he still has a crush on her. Maybe he is saying, I can't believe you betrayed me like this. I did this for you. I did this to be with you.
Yeah, and it actually looks like he's walking back into the courtroom right now. I would love to just hear your thoughts as he's entering the courtroom. Are we able to show this while we still talk about it, just to explain kind of the conversation that's likely happening there? It does look like they're about to start court back up, so we'll be going back into that if they cut back to him. Otherwise, thank you so much, Janine Driver, for being with us. And if people have questions, they can still text them in, and we'll get them to her, 202-895-5599. But for now, let's get you back in the courtroom.
Your next question?
Thank you, Your Honor. Your Honor, the picture that's on the screen, may I just ask you what you have as that number?
I have that as 170.
Okay, that's what I have as well.
Okay.
I just want to make sure.
And it's already in evidence?
Yes.
Okay.
Can it be published too?
Okay. I didn't know if you wanted to take it back to presentation mode.
Oh, sorry. I do want that. Thank you.
It's still,
You gotta click it. You wanna click it? It's not in presentation mode yet. You're on it, you just have to click it. You're there. Just.
Judge, may I use Mr. Wodlicki's expertise?
Okay, sure. All right. So now we're back to 170. Okay, it's published.
Yes, thank you, Judge. Thank you. Sir, looking at the slide that's on the screen there, I think we've spoken about it, but just since we had a break, can you just explain what this slide and what the significance is relating to your digital forensic analysis?
These are 3 FetLife messages that were sent outbound from the account purporting to be Christine's, and they occurred still on February 20th in the evening. So in the window we've been discussing between 10 and midnight or 11 and midnight.
Your Honor, I'm going to move to the next slide.
170 is already in evidence. I mean,
170 in evidence?
The 170 is in evidence.
Yes.
Okay. So what'd you ask?
Oh, 171.
171,
Identify
okay.
as 171.
All right.
I just said I was going to move to the
Okay.
next slide.
Gotcha. Thank you.
Sir, can you identify this slide?
Yes, I can.
Okay, and what is it?
These are additional Telegram exchanges, sort of an extension of what we looked at earlier with the green and blue chat bubbles.
Okay, and this is a portion of what has already been moved in the Commonwealth's case?
That is my understanding, yes.
Okay, and what's the significance of these messages and what specifically in those messages?
Well, so From a significance perspective, obviously it's communication between, the two primary involved people or accounts. This evening is significant, as we discussed, because this is when Telegram really ramped up, and this is the evening of the phone call. There were the Telegram call between two parties, and this is an extension of the activity that we were visualizing when we started this. So it's again, we're for me, significance is looking for continuity or a break.
Okay. Your Honor, I'm going to move to the next slide.
172.
172. And what is this artifact, and what's the significance of this in terms of your digital forensic analysis?
So this is an artifact from Christine's cell phone, her mobile device. It's again on the evening of the 20th, and it's just a continuation. This is now 11:52 p.m. I'd have to see the last slide to see where we left off in the chronology. But again, I'm always looking at multiple devices. I'm trying to get as much data about what all of the involved parties are doing on what devices all at the same time.
Your Honor, may I move to admit this to evidence in number 172?
Judge, I am going to object. I'm not sure that we have enough foundation to support the conclusion that this came from the cell phone.
All right, you can lay foundation.
Okay. Mr. Litsky, this artifact, when you collected this artifact, what device did you get it from?
The portable case of Christine's from her cell phone.
And what, if anything, did you do in order to isolate this particular artifact?
I just did a screen grab of the artifact as it displays on my end.
Your Honor, move this in as one.
I mean, Judge, again, I would ask how he knows that this is from, what on this document tells this witness that this is from the phone?
Okay. I want to ask him that question.
What on this document tells you that it's on the phone?
I remember it. I remember doing it. Nothing here provides device attribution, but I know it from my review and analysis.
All right. Okay. All right. 172 in evidence.
And so, and you just mentioned something about looking back at the timeline because we just had that break. Is that necessary for you to be able to explain to the ladies and gentlemen of the jury what this is?
Well, sure. I mean, the content, as we can see here, I think would agree is, at least I assume, I take this to be unrelated to the scheme, but it is activity on a device that is occurring contemporaneous to activity related to the investigation, related to this case. So for me, this is important. If I can assign device attribution for this particular time, then I can draw inferences from that somebody is awake, that somebody is, in this particular case, researching office ideas. That might give rise to pursuit of another investigative channel to see if there's other corroborating or refuting information elsewhere.
Is the slide that you were comparing to was the one immediately before?
Well, these, I believe, are chronological. So the one immediately before would be either just before it or even contemporaneous.
Okay, and is that something you want to reference?
We could look at the time. I see this one's 11:52. I didn't take note of the last message.
Your Honor, may I move back to 171?
Yeah, you can move back.
Does that give you any indication?
It does, yes.
And this has previously been entered into evidence, Your Honor?
No.
Your Honor, move this into evidence as number 171.
Any objection?
Yes. No, Judge, this was from our previously admitted.
Okay,
so no
171 in evidence.
I neglected to move that in, so the jury didn't hear about that. So perhaps you could explain what you were just explaining with actually a slide in front of them.
Sure. I think I mentioned before lunch, there was a lot of activity this evening. There was Telegram. I thought FetLife as well, and now that's been confirmed. So this is a continuation of Telegram chats that were ongoing in this relevant period of time. So the beginning at 11:21 p.m. on the 20th with the first message and ending, at least for this screen, for this point in the conversation, at 11:47 p.m. on the 20th in the lower left.
And these are in UTC time, correct?
These are in UTC time. That's just the way they were extracted from the device, which is default, so that's normal.
Okay. Sorry, go ahead.
No, go ahead.
And would that require, as you said, math?
Yeah, so we're doing a bit of math. So so even though the date reflects 2:21 at 4:45 in the morning, it's actually 2:20 at 11:45 p.m.
Thank you. Your Honor, I'm going to move to the next slide.
All right.
173, Your Honor, identify it. Sir, have you taken a look at this slide?
I have.
And do you recognize it?
I do.
And what did you retrieve this information from?
Also from Ms. Banfield's mobile device or cell phone.
And is there any significance with regard to the times on these messages?
This is just before and straddling midnight, again on the 20th, and of course, immediately into the 21st.
And Your Honor, I'd move this in as Defense Exhibit 173.
No objection.
All right, 173 in evidence.
Explain to the ladies and gentlemen of the jury what the significance of this is in relation to your previous slides that you created.
It's a conversation between the Banfields. It's Facebook messaging initiated by Mrs. Banfield.
Judge, I'm going to object. Calls for speculation. Again, we don't know who's behind the device.
I'll sustain the objection.
Okay. In the context of the devices, what can you?
Between accounts purporting to be from Mrs. Banfield to Mr. Banfield, it's a brief exchange about domestic logistics.
Okay. I'm sorry, and Your Honor, we've already moved that in, correct?
Yes.
Okay. I'm going to move to the next slide.
All right.
And this would be identified as Defense Exhibit 174. Sir, do you see that exhibit?
I do.
And what, if anything, does that exhibit tell you about the investigation into the digital forensics that you've done in this case on this particular day?
This is an artifact from Mr. Banfield's laptop, her Lenovo laptop. It indicates that Telegram was started and in use between midnight and 12:42 a.m. On the morning of the 21st.
Okay, and Telegram, the three accounts that we're talking about, what are they?
There's the suspect Gmail account, the CBRN 920. There's the FetLife account, and there's the Telegram account.
Okay, and how do they link back up now that the Telegram account is involved?
Well, again, it's how they were used, that they sort of, one led to the other, which led to the other. So the way Telegram links up is it was sort of referred, like, let's move this conversation on FetLife over to Telegram. So it's an extension of what was going on in FetLife. It doesn't really stand alone to my, from what I investigated. And FetLife, of course, ties back to the Gmail account. So they're all just linked in that manner.
Your Honor, I'd move this in as Defense Exhibit 174.
Any objection?
No objection.
174.
Mr. Litsky, the jury's going to see that now. Is there any additional explanation that you need to point out for them now that the exhibit's in front of them?
No, you might see the activity type, app use focus. That's just Windows' way of reporting which app is brought to the front when you're using a computer. So you can have multiple programs open or multiple windows open, and Windows records which one is where.
And so the duration that you're talking about, is that known based upon this artifact?
It is. So this was a 42-minute use episode of Telegram.
Your Honor, I'm going to go to the next slide, which would be Exhibit 175.
Okay.
And sir, have you seen this exhibit?
I have.
And in fact, is this data that you've compiled?
It is.
And Your Honor, I move this in as Defense Exhibit 175.
Judge, I am going to object. This lacks foundation. It appears all of the column headers have been removed, so I don't know what information has been filtered.
Sustain as a foundation.
Okay. Sir, in compiling this exhibit, what is it that you did and where did you get it from?
This is from Mrs. Banfield's mobile device, and this is her Google Chrome, which is a web browser, Google's web browser, web activity. So site visitation, website visits between 12:09 a.m. and 12:27 a.m. on the early morning of the 21st of February.
Okay, and so Ms. Sands mentioned that she doesn't know what the columns are. Can you provide guidance as to what those columns are as to this document?
Sure, from left to right. It's the website, visited, date, time, sort of the title of the website. Web pages actually have a title of what they are. I think visit count, how it was reached, whether it was typed or clicked on a link is what I mean by that. Whether it was native to the device or synced, and just talking about which what data point this came from at the end.
Your Honor, I move that in as Commonwealth's Defense Exhibit 176.
175.
Oh, 175.
Judge, I do still have a foundation objection with regard to the date and time. I believe we're missing columns that typically appear in this view in the native software.
It's date and time foundation.
Is there any modification of date and time to this column different than what you received?
No, this is in local time. It's down to the second. That's all I can say.
I'd renew my motion.
And I'm sorry if I can clarify, it's not a modification of the data within the column, it's that there are missing columns for additional in-out activity, the additional columns of date and time of the cessation of the interaction.
Is it start time, end time?
This just represents when the website was visited, first visited, if that helps clarify.
No objection, Judge.
All right, 175 in evidence.
And sir, if you could, for the ladies and gentlemen of the jury, explain what this is.
This is from Mrs. Banfield's mobile device. This is website visitation from, as reported by Chrome, within the device. That occurred between 12:09 a.m. and 12:27 a.m. on the morning of February 21st, 2023. It's what I would call benign as to substance. I didn't see anything in here related to the case per se. It's more for awareness if there was some human using this device at that time, and these were the websites that they were browsing to.
Your Honor, I'm going to move to the next slide. That would be Exhibit 176. Sir, can you see that
I can.
slide?
Yes.
And what, if anything, is it showing, and what's it from?
So this is from Mrs. Banfield's Windows laptop, her Lenovo laptop. And this is also a website visitation record. It's from 12:24 a.m. on the 21st. This correlates to one that was on her phone as well, identically with substance and time. And for me, that's informative.
And does this align with your pattern analysis as to her devices?
In terms of?
In terms of time.
Usage? Well,
usage.
Yes, this device has been in use for the entirety of this event so far since we began.
I'm sorry, I didn't ask the question properly. I think you testified before that you did a time analysis as to when she would use this device throughout the year.
And again, I'll withdraw.
That's what I was aiming for.
Yes.
You can tell the ladies and gentlemen of the jury.
With the historical pattern of life analysis that I performed on all of the devices, not just Mrs. Banfield's, this would be one of those informative artifacts. It's in the window of time that I observed sustained over an extended period of months.
Your Honor, I'm going to move to the next slide, which would be 177.
All right.
Sir, can you look at the slide that's before you and tell me if you recognize it?
I do.
And where did you get this message from?
This is part of the Telegram production from discovery in this investigation.
Okay, and is this a portion of the exhibit that the Commonwealth has already moved in?
It is. I should restate just for confusion. Telegram doesn't produce any records. This was obtained by Detective Miller as part of his device analysis.
Your Honor, I'd move this in as Defense Exhibit 177.
Any objection?
No objection.
177.
So if you can, once the ladies and gentlemen of the jury see it, what's the significance of this message chain in the context of the date that we're talking about?
So this is a continuation of the exchanges we saw earlier. The message on the top left, and if you recall the details of the conversations we saw earlier, there was discussion about being nervous in anticipation of a call, the voice call. So the first two messages are, just leading up to the call, and the third on the lower left reflects the call itself. It was an incoming call because this is from the perspective of Mr. Ryan's device, which was the origination of this material. So it was incoming from his perspective. And you can see the duration there is just shy of 42 minutes. And all of these are UTC as stated.
So we need to do some math.
5 hours. One of them's easy.
Your Honor, I'm going to move to the next slide, which would be Defense Exhibit 178. Sir, what's the significance of this relating to your digital forensics analysis?
So this is Telegram app usage, again, from Mrs. Banfield's laptop computer.
And Your Honor, I move this in as Defense Exhibit 178.
Any objection?
No objection.
178.
Sir, can you point out the significant portions of this that made it your slide today?
Well, obviously Telegram is one of the three accounts that were instrumental in this investigation. any usage of Telegram on Ms. Banfield's device or any of the devices is significant. This one happens to kick off again just after the phone call or the Telegram voice call. So we saw that kicking off almost at midnight on the nose, lasting for 42 minutes, just short, 42 minutes. This one activates or kicks off, the usage of Telegram again kicks off at 12:42 a.m. on the 21st, and it only lasts for under 3 minutes, or under 3 minutes. It's a very brief usage of Telegram.
Your Honor, I'm going to move to the next slide. And I believe that's Defense Exhibit 179. Sir, do you recognize that slide?
I do.
And what is the slide? What does this represent?
This is a continuation of the Telegram exchange.
Your Honor, I move this in as Defense Exhibit 179.
Any objection?
No objection.
179,
And what are the significant portions of this message relating to your forensic analysis of this day?
For me, the most significant aspect of this is the time and what it corroborates. So a moment ago, and this has been true about what we've seen with Telegram usage on the laptop corresponding with a conversation from another device. So on the slide previous, we saw Telegram.
Judge, I would object to the categorization of another device. There's been no foundation laid to suggest that this is coming from a separate device than the one that had the message indicating that Telegram had been interacted with.
I will sustain the objection.
Sir, what are the devices that you've analyzed as part
Judge
of
asked and answered. We know how many devices there are.
I'll sustain the objection.
I'm sorry, I thought that the foundation was for devices.
He was talking about another device, so that's the question.
Okay. In your digital forensic analysis, what were the devices that you relied upon in order to?
Same objection.
Sustain.
What device is it that you're talking about?
The other device I referenced was from Mr. Ryan's cell phone, which I believe to be the source of these extracted messages that performed by Detective Miller.
And, Your Honor, may we approach?
Okay, sure.
Sir, based on the device that you just spoke about, is that part of this digital forensic analysis relating to this slide?
Yes, my understanding is this data was contained in that device.
Okay. Now, we've gone through a series of slides. Your Honor, I move this in as...
It's already in evidence.
Is it in evidence? Okay, sorry. In terms of the Telegram discussion and the time frames leading up to it, based upon your digital forensic analysis, did you reach any sort of conclusion? as to what was the communications during this evening?
I reached a few potential conclusions, yes.
Okay. And was it based upon your analysis of the digital forensics that you've analyzed to create this evidence?
Yes, it wasn't exclusive to Telegram, however.
Okay. Can you opine about what your conclusions are?
I can. Is it possible to go back to the fourth slide?
Absolutely.
It might help for contextually.
I'm going to just go back, sir, and just tell me where to stop.
Judge, can we identify an exhibit number, please?
I don't know which one it is yet until the rolling slides stop.
Is that the slide?
If you could go back one or two more, please.
Back, same direction? Or
Yeah.
The other way?
Towards the start. Okay.
Is this the slide you're talking about?
This one and the one immediately after this.
What exhibit number is this?
Your Honor, I believe this would be 162.
No, Judge, this is 160.
160.
I'm sorry, say it again.
160.
160.
Sir, you're referencing a defense exhibit number 160?
Yes.
And what's the significance of that toward your conclusions?
So for this and the next 3 or 4 slides, the respective devices, I can't speak to the people holding them, but for a time at the beginning of this event window, the main devices of the 3 involved parties were in 3 different places, is one of the inferences I draw from the data that I analyzed. That is important if you advance, maybe one slide, please.
$161.
Yes, thank you. So that's important because at this particular time here with this slide at 10:58 and 24 seconds, Ms. Banfield's computer is logging in to her email, an email account associated with Mrs. Banfield. So at this time, neither Mr. Banfield's nor Ms. Magalhães' devices are present in the house. So the conclusion I draw from that is that there was only one related party to this investigation at home at the time. So the laptop
Judge,
is...
objection, calls for speculation.
Sustained.
We'll just leave it at that.
Okay.
Is there another, do you wish for me to show the other slides?
You can move forward 1, 2, sorry.
2.
Yeah, if you can go 1.
That would be
sorry.
164, I believe,
Well,
Judge.
one more, my apologies.
One more back?
No, keep going forward.
Okay. 165?
No, one more.
That's 164.
Is that one, I'm sorry, Judge.
That's 164.
Okay, so 165.
I'm sorry. I'll let you know when we're there. There. If you go back to the blue screen, please.
Yes,
So-
sir.
166. That's 166.
Yes.
Okay.
Is that what you?
Yes, thank
Okay,
you.
166, thank you.
Sorry for the journey. So again, bless you, this tells me that we have, what I see is Ms. Banfield's laptop is in use with a remote access to a website associated with her work. The activity on this device began while other devices weren't in the house.
Judge, I'm going to object. That calls for speculation.
Sustained, we need to stick to devices.
Okay.
I thought I said devices.
You said other people in the house.
I thought I said other devices in the house. My apologies.
Well, let's just say what you meant to say, and then we'll.
So this is a current time when other relevant devices are not in the house. And the
And Judge, I'm going to object as to foundation. This slide indicates that the website is a Chrome last tab. The witness is assuming that it's being interacted with, but that is inaccurate from the information on the screen. I do not believe he's laid any foundation to suggest that there is an actual interaction with this website occurring at 11:07.
Foundation is
Okay. Sir, what was the basis for, this is already in evidence, correct, Karen?
It is.
Yes.
What is your basis for your assertion that this was a login and access?
It's a fair point. I can't tell what happened past this. I cannot tell if a user went forward with accessing the site beyond just visiting, just getting to the page.
Okay. And I'm sorry, so continue your.
Yeah, so the last inference that I drew from this evening is, again, this particular device, the laptop, activity began on it at a time when other relevant devices were not present in the house. That activity continued on through.
Judge, I'm going to object to his mischaracterization of the evidence. His previous testimony was that the phone belonging to Juliana Peres Magalhães connected to the home network at 11:06, which would be 1 minute before this interaction. So other devices were in the home.
Sustain the objection, if you want to clarify.
What time did the phone, Juliana Peres Magalhães' phone connect?
If you want to back up one slide, I think we'll see that at just shy of 11:07. And if you want to back up just one more, please.
It's 165, and now we're looking at 164.
Sorry.
Too far.
Back one more. There.
Sorry. Is that right?
Yes.
Okay.
What exhibit number is that for the
That
record?
would be exhibit number 160.
161. 161.
161.
161.
So the activity, not particular to that website visit, but the activity, the laptop was in use prior to the arrival of other relevant devices. So a human was using this laptop while other humans' devices were not, while other devices were not present. So I see the session, the use session, as an extension. So from where it begins to where it ends, what I'm looking for in this particular investigation.
And Judge, I'm going to object to the testimony. I don't believe that it calls for speculation. I don't believe that he can identify when the use ends.
All right, I'll sustain as a speculation. Next question.
How can you determine when a session ends?
Well, for the period of activity that I analyzed, perhaps it's when I ended it or I stopped noting it versus when it actually ended. But we just look at, cessation of user-driven activity.
And is that what you relied upon in arriving at your opinion?
It is. I don't believe I marked in this demonstrative when that, I can't say for certain the last activity that I put into this demonstrative corresponds with the actual last user activity.
And so in this demonstrative, it says 10:58:24.
Well, this is on the front end of the session. And I guess just to get to the point, if I can, the activity begins, we have device separation. activity beginning, activity continuing, without what I would consider a break.
And objection calls for foundation.
Sustain as to foundation.
What do you look at when you're determining whether there's a break in communication on the device?
A period of inactivity, and that's, you know, that's subjective, as I said earlier, right? 10 or 15 minutes could be you know, significant enough for what we're talking about. But if you scroll forward, and I apologize, I'm just gonna have to stop you when you get there. There.
Okay.
What exhibit number is that?
Your Honor, I believe this is 169, 168.
I have 168. Okay.
168.
Okay.
Yes, sir. This is the slide that you wanted to go to?
Yes.
Okay. And what's the significance of this slide?
So we can see the start and end times here. This instance of telegram began at 11:09 p.m. and ran right through up until midnight, which is the time where the voice call occurred and a different session was engaged. So this I see as a period of sustained activity.
Again, objection, foundation, Judge. You can't say who was interacting. The message was received. Thank you.
How can you arrive at that conclusion? What did you review and what do you base your opinion on?
Well, we saw from the telegram conversation snippets that they occurred within this window. So that is the activity I was referring to.
And those are the items that were introduced into evidence?
They were.
The green and blue slides that have been introduced into evidence?
Correct.
Do you need to reference those?
I don't. If we want to confirm they were within this window of activity, that's fine, but I believe they were.
Okay, let's move to 169. Is that one of the conversations?
It is.
Move to 170. Is that one of the conversations?
Yes.
And can you see the timing there? Does that fit within what you've been testifying to?
It does. These are all between 11:09 and midnight after the math.
You're identifying 177? Is that one of the conversations?
This, there it is. This is as well one of the conversations. The top left conversation is at 11:52 and 56 seconds, 11:53 p.m. So it's in that window of 11:09 to midnight that I referenced. The second two are in different instances of telegrams activation on the laptop. And I think they're either right before or right after this slide. I think before. Right, so
You're referencing 179? Is this one of the conversations?
It is.
And Your Honor, has this been moved into evidence?
Yes, 179 is in
Okay.
evidence.
And sir, would you like me to show the other conversations?
Well, just that for the corroboration effect, we can see the blue conversation bubble occurred at essentially midnight, 12:44 a.m. on the 21st. If you go back one slide, you'll see the associated Telegram activity when the Telegram app was open on the laptop.
Okay. And that's what you've just described on this particular exhibit is in UTC time?
Correct. So it's just corroboration. We have Telegram activity on the laptop, and we have a Telegram conversation occurring contemporaneous to each of the instances of activation of Telegram use.
And I can go back to the other slide that you were referencing.
If you think it would be helpful, I'm fine.
Sir, what were your conclusions based upon your digital forensic analysis of February 20th, 2023?
I didn't see anything here to suggest device takeover. I didn't see anything here to suggest misattribution.
Thank you, sir.
So with no further ado, let's hear from our elected officials. Mr. County Executive.
Hey, thank you, and thank you all for being here. My views on snow have really drastically changed with age, and particularly with job responsibility.
actually strike that question. Is there anything else that differentiated the two phones for purposes of your analysis?
Their usability is highly different. They're both phones, but again, the government phone, the IRS phone in this case, was restricted to certain apps and permitted usage.
And how do you know that?
From records provided by the IRS.
And in those records, did they give you any detail as to how it was restricted?
I remember seeing a list of both permitted apps and installed apps.
And was that as to this phone or just IRS?
That only applied to the IRS phone, not to Mrs. Banfield's phone.
Okay. You're going to move to the next slide. That would be 118.
I think it is 118, yes, 118, okay?
Sir?
It's already in evidence.
Yes. Have you had an opportunity to see this before?
I have.
And you were here when Detective Miller testified relating to this?
I was.
Okay, so what is the significance of this relating to your analysis?
This is just a continuation of the login activity from the prior slide. I believe this is the complete universe of logins from January 9th to the last one on February 23rd. Aside from the first one, which was from a mobile device, the rest of these are from a computer, a Windows computer. And all of them on the previous slide and this were from the Banfield's home IP address.
You're going to move to the next slide, which would be 119.
119, which is in evidence under seal.
Sir, can you describe for the ladies and gentlemen of the jury what this is?
So this is I believe it's a partial.
If you'd like, I can enlarge it and then move it around.
No, it's fine as it is. This is a partial visualization of the message activity that occurred within the account. Aside from or it's inclusive of the 3 messages we saw on the first slide, this is close to 290 messages that were received by the suspect alleged account, or the alleged suspect account, and these are varying in dates and times. I believe these were all recovered from the deleted box of the Gmail account.
And these are items that you recovered?
These were provided by Google in response to the Fairfax County Police Department search warrant.
And in terms of the deletion box, would you consider that account maintenance?
I would consider that maintaining the account, cleaning it.
And to arrive in this form, what would one have to do from the inbox?
Log in and select messages for deleted. I don't recall if these were read or unread, but it would require, generally it requires logging in, selecting messages, and deleting them.
Okay, thank you. Your Honor, I'm going to, so that was a portion of what we showed to Detective Miller.
Okay.
So I'm going to have to jump to the
Whatever.
the other numbers.
Whatever, 180 now?
We're at 180.
Right.
And I'm just going to move 2 slides. 3 slides. this would be identified as Defense Exhibit 180. Sir, what is that?
These are two login events from a Windows computer to the alleged suspect Gmail account on February 17th, about 4 minutes apart. The first at 11:19 p.m., 11:20 p.m., the second at 11:23 p.m.
Your Honor, move that in as Exhibit 180.
Any objection?
No objection.
180?
And I'm sorry, could you please repeat that for the ladies and gentlemen of the jury?
Judge, I don't know why it bears repeating. Objection asked and answered.
Sustained.
I'm sorry.
Asked and answered. I'll sustain the objection.
Okay. What if any significance to this slide to your investigation for digital forensics for this case?
Well, obviously, the Gmail account has significant relevance to this particular case. The use of the case, as discussed earlier, requires awareness that the Gmail account exists and knowledge of the password. So to log into an account, a Google account or a Gmail account, you have to first know to go find it, to go look for it, and have the password to log into it.
And how important are these kind of details as to trying to attribute device behavior?
Well, knowing where and when.
Judge, I have to object asked and answered. I think we've been over why this is relevant. If we can move on.
Asked and answered, sustained.
Okay. I'll move on to the next slide.
Next slide.
Sir, have you seen this slide?
I
This
have.
would be identified as Exhibit 181.
I have.
And what, if anything, stands out in making this slide?
The timing, it's also on February 17th at 11:24 and 11:29 respectively, PM. And these are two outbound messages from the account purporting to be Christine Banfield.
Your Honor, I'd move this in as Exhibit 181.
Any objection?
No, again, if we can,
Party.
right.
181?
And so the timing significant in this situation?
Yes, this is FetLife activity contemporaneous to the Gmail account activity we saw on the prior slide. Looks like within a minute or two. So overlapping basically at the same time.
Your Honor, I'm going to move on to slide 182.
Okay.
What do we have here, sir?
So this is a snippet from the Google geofence warrant return. It's provided to indicate the location of a target device. In this case, it was Mr. Banfield's device.
And Your Honor, I'd move this in as Exhibit 182.
Any objection?
Yes, Judge Foundation, there are no identifiers on this document.
Foundation?
Explain how you created this slide and what specifically those items are.
So the responsive documents for this particular set of records is a spreadsheet with maybe tens of thousands of rows. The data that in this case Google collects is recurring. It can be every minute or two, and it's over a period of months in this particular instance. So all I did was take a screen grab of relevant rows pertaining to this date and time from that spreadsheet.
And what date and time are you referring to?
So again, this is provided in Zulu time, so the relevant period is February 17th, 2023, around these particular records begin at 11:19, have 11:21, 11:27, and 11:29, which correspond back a few slides to the login to the Gmail account and the FetLife activity we just observed.
And, Your Honor, I renew my motion to enter this into evidence.
Judge, still, if we're to rely upon this document, it is absent on its face of any connection to the source device.
Sustain the objection.
Sir, can you describe the first column there, what that contains?
Judge, I'm going to object the witness reading the denied exhibit into evidence.
I think he's just going to identify the column.
Yes.
That's fine. Overruled.
The first column?
Sure, date and time for the starting of the logged data session or logged activity.
Okay. And that's for all of, for each of those 4 times, that column is related to the date of the start, the time of the start?
Yes.
Okay. The second column, what is that related to?
The end of that particular data capture or data logged event.
The third column, what is that for?
It's the latitude. It's the geographical position in latitude.
And the fourth column?
Is the longitude.
And what does the fifth column indicate?
That's an accuracy measurement in meters, and depending on how the data was sent to Google will vary and depend on how accurate they are. If it's coming from Wi-Fi, it can be very accurate. If it's coming from cell, it's usually less. GPS can be dependent.
And is that the final column there as to what the source was?
It is.
Okay. Is there anything different about, well, Your Honor, I'd move this in as 182.
Judge, same objection. If we're to rely upon this evidence, it needs to have clear indication as to where it's from.
I'm going to sustain the objection at this point.
Do you have the entire, access to the entire document that you grabbed this from?
I do.
Where do you have that?
It's probably on my laptop. It's certainly on hard drives.
Okay. Your Honor, we'll hold off on moving that in, and I guess we'll produce a massive document for Ms. Sands.
Thank you.
Sir, do you see the picture on the screen there?
I do.
And does that relate to the previous document?
It will.
Okay. We'll identify that as number 183.
All right.
And when we can produce that document, we'll move that into evidence, Judge.
I mean, do you have any objection to 183 at this point?
No, just to the map itself,
I think
no.
we can move
Okay.
183 in.
Okay, let's move 183 in.
All right.
Sir, can you identify what is contained in this slide 183?
Yes. This is just a map image of the Reston-Herndon, southern Reston-Herndon area. You can see Dulles Airport to the far left. The Banfield's residence on Stablebrook Way is approximated by the picture, the icon of the blue house towards the middle lower left. On the far right.
Objection, foundation. Judge, may we approach?
Okay.
Sir, we're going to need that other document before we go with this slide.
Fair enough.
This next slide, is that related to the two previous? That would be Exhibit 184, Judge?
I'm still on a sort of a continuation of the map.
Okay, of the map from the previous slide?
It's,
Judge, it will draw the same objection.
No, sorry, I said I need it as 184.
Yes.
Okay.
Sir, let's move on to February 13th. Is this this would be 185, I believe, Judge, identified as Exhibit 185. What, if anything, does this indicate relating to your investigation of the digital forensics on this day?
this is another 2 logins to the Google, the alleged suspect email account, the Gmail account, CBRN 920. These took place on the morning of February 13th. Both, one at 7:33 and one at 7:48, 7:49 a.m. It was a bit anomalous because most of the activity that I observed in my analysis of this account took place at night, frequently late at night. Both of these came from the Banfield residence, both of these events from a Windows computer.
And what are the relevant times there? And what's the significance of that?
7:33 a.m. and 7:49 a.m. And they were, anomalous from most of the other activity that I observed.
Sorry, I'd like to move that in as Defense Exhibit 185.
Any objection?
No objection.
185?
Before you start explaining, I wanted to make sure the jury saw it. So can you explain to the jury what the significance of these 2 artifacts are relating to February 13th?
Judge asked and answered.
Overruled at this point.
Yeah, so here are the 2 logins I just described. They are, bless you, they are from the home IP address. We can see that at the top of both. Their logins to the alleged suspect Gmail account. We can see that towards the bottom of each in the highlighted section. The date and time, they're both in the morning of February 13th, 2023. The first at 7:33 and 12 seconds a.m., the second at 7:48 and 41 seconds a.m. From the details, we can see the nomenclature of the device-ish. We can tell from this case that it was a Windows-operated computer, not a mobile device.
Your Honor, I'm going to move to the next slide. Sir, can you see this slide?
I can.
Okay. And is this something that you created?
No.
Is this something that you found through your digital forensics?
This is just a screenshot, a portion of the FetLife records.
Okay, and those are the records that have been moved into evidence?
They are, and these particular ones correspond to this date and this time frame on the morning of the 13th.
Now, Your Honor, I move that in as Commonwealth's Exhibit 186.
Any objection?
Nothing.
I'm sorry, Defense Exhibit 186. I keep saying that.
186, yes. Defense 186.
Sir, what's the significance of these messages as it relates to the investigation of February 13th, 2023?
Just the timing, that it was contemporaneous or basically at the same time that the Gmail account activity was occurring.
Your Honor, I'm going to move on to the next slide. Do you know what this is?
I do.
Okay. And what, if anything, what's the significance of this in terms of your investigation of February 13th?
So this is a demonstrative I created to show Mr. Banfield's device's relative position to the activity we just discussed at the residence.
That would be identified as 187. All right, I'd move to admit that into evidence.
Any objection?
There's more to this. It's got,
So perhaps maybe we move through to the completed item, because at this point, it's just a map, so I'm not sure how it's relevant.
All right. Do you object to the map coming into evidence, though?
No.
All right, 187 in evidence. Let's keep going.
Your Honor, I'm going to move to what will be identified as Defense 188.
All right.
Sir, what do we have here?
these are the times of the FetLife communications, the outbound FetLife communications from whomever was using the account purporting to be Mrs. Banfield, with an arrow pointing to the approximate location of the Banfield residence in Herndon.
Your Honor, I'm going to move on to Defense Exhibit 189.
I'm sorry, was this being offered in evidence, or we're just moving on?
Oh, I'm sorry. Your Honor, I move Defense Exhibit 188 into evidence.
And Judge, we would object as an improper exhibit and foundation for the same reason that Ms. Graff's
All right, I'll sustain it.
demonstratives didn't come in.
Sir, do you see the exhibit on the screen identified as Defense Exhibit 190?
189.
189, I'm sorry.
I do.
What are the reference points? Your Honor, may we approach before I ask the question? Your Honor, I'm going to move on to January 23rd, 2023. Mr. Litsky, have you had an opportunity to look at this slide?
I have.
And this is identified as Defense 190. And explain what this shows and how you came about this in your investigation.
This is another login to the alleged suspect Gmail account, the CBRN 920. account occurring on January 23rd, 2023 at 11:22 p.m.
Your Honor, move this in as Exhibit 190.
Any objection?
No objection.
190?
And what are the significant portions of this other than the date of 123?
The date and time, the home login address, but we saw from the slides prior that all of the logins occurred from the residence. It was from a Windows computer, which we've seen before.
And this was an artifact that was obtained through a warrant return to Google?
It was.
Your Honor, I'm going to move to what will be Defense Exhibit 191. Do you recognize this?
I do.
And is this something that you received in your investigation into digital forensics?
It is. These are part of the FetLife responsive records. These are outbound communications from the account purporting to be that of Mrs. Banfield's, occurring on January 23rd, 2023, about the same time as the Gmail logins we just discussed.
Your Honor, I would move this in as Exhibit 191, and I think it just should be sent to the
191.
to the jury.
Sealed.
As I guess Judge has a sealed document.
Didn't tell me that before. Is this a sealed I don't think it's a sealed document.
Judge, the entirety of the record is in evidence, not sealed.
Okay. I just was trying to. And sir, what exactly is, tell us about this artifact for the ladies and gentlemen of the jury.
Yes, so as stated, these are two outbound communications from the account purporting to be that of Mrs. Banfield's, both on January 23rd, 2023, the first at 11:28 p.m., the second at 11:35 p.m.
And Your Honor, that's been moved into evidence, correct?
Yes.
Okay. I'm going to move to the next slide. This will be identified as Defense Exhibit 192. Is that right? Sir, can you identify this?
Yes, I can. This is more Google geolocation records associated with Mr. Banfield's mobile device.
Okay. Is this part of the document that you clipped out of?
It is the same spreadsheet.
I'll hold off on amending it, Judge.
Why don't we go ahead and take our afternoon recess, and then maybe you can get that document for me.
May I speak to him about the document?
Yes, you can speak
Okay.
about the document. Any objection to that?
No,
Just
Your
so
Honor,
you get the-
specifically, he's not asking about this document. He's asking to retrieve the base document for this
Right,
data.
he says he has the base document for all of
Understood.
these.
No
so
objection to
If he
that.
could talk to him about that so he can get that.
Yes, ma'am.
Okay, perfect.
Thank you.
All right, let's take our 15-minute recess. Not talk to anybody and don't do the outside research. We'll see you back at 3:45.
Of course. Thank you, Judge.
All right, you have been watching the Brendan Banfield murder trial here on WUSA 9+. Thank you so much for staying with us. We've been watching the same person testify for quite a while now. He's been up there on the stand all day long. That's Harry Litsky. He's a private investigator, and the defense has just been questioning him. Joining me right now is Frank Salvedo, our legal expert analyst. Can you kind of explain what we have been watching? It feels like this has been going on forever at this point.
This has been some painstaking testimony, very technical. This expert is going through all the forensics to try to show that Christine Banfield was the one that actually placed the ad. What I really think is going on is that the defense attorney is kind of walking this out to the end of the day to make a decision on whether his client should actually take the stand or not.
Yeah, and some context here, we were told this morning that Brendan Banfield was expected to take the stand to testify. He is on trial. He's facing a number of charges, but he's accused of killing his own wife, Christine Banfield, and another man named Joseph Ryan. We saw Juliana Peres Magalhães, the family's au pair, a woman that investigators say he was having an affair with. She took the stand. She has testified against him. That was part of her plea agreement that she took with the prosecution. You know, Brendan Banfield taking the stand, that is something that continues to come up. We continue to hear questions. Do you think he's going to take the stand? Do you think he's actually going to take the stand? We're hearing that he is going to be up there, and I know you've previously told me it's not the best move by the defense.
Yeah. If it's me, considering how well this case has gone for the defense, I probably would not call him to the stand. Again, the Commonwealth has to prove beyond a reasonable doubt. And given the au pair's difficulties under cross-examination, it seems like they've done a decent job of lodging reasonable doubt in this case. But like we've talked about before, it is his decision. And that is one of the decisions. It's not the attorney's decision. It is only his decision. He seems like a client who's going to push his own decision in this regard. And I think that's probably what's happening. Again, who knows whether he'll actually take the stand or not. If he does, it is high risk, high reward.
Let's unpack that a little bit more. You said that to me earlier. What are the high risk elements here?
Right now, everybody is focused on Ms. Magalhães' testimony. And in fact, all of this painstaking testimony really points to the fact that but for her, there's no case. That's been the impetus of the defense in this case. However, if Mr. Banfield takes the stand, all of a sudden the jury's focus goes primarily on him. Right now, if I'm the defense attorney, I'm happy that the focus is on her. But if my client takes the stand, all the focus is on him. Every movement that he makes, every body language movement that he makes, every word that he says, everything is focused on Mr. Banfield. That is a huge risk. If he does well, great reward. If he does poorly, one misstep, terrible. He could be convicted and spend the rest of his life in prison.
Yeah, and you know, I think we're seeing things really slow down, right? We saw fast. It has slowed down dramatically. For context, the judge last night, she did tell both attorneys that she hopes to have this case wrapped up by today in terms of having the last witness called, having all the evidence in. She wants to give jurors the weekend and likely what is expected to be Monday and Tuesday possibly off if this snowstorm turns out to be as bad as it is expected to be. She wanted to get everything done that way when the jurors come back, we would go to closing arguments, and then they would go into deliberation. She even had both attorneys come in this morning with their jury instructions, and she said, I really want to get this done, even if we have to stay late. John Carroll said that he had 2 witnesses to call. We have seen 1 witness up there on the stand, other than Detective Brendan Miller, who was there for a little bit. But he had said, I have 2 more witnesses to call. We have only seen 1 up there, and it is going so incredibly slow. We even heard the prosecution trying to move things along. She said last night, I'm ready to end this case tomorrow. We were ready to end this case today. Why is it in his best interest to slow things down to this?
If his client's going to testify, what Mr. Carroll doesn't want to do is to call his client, start the questioning, and then give the prosecution the entire weekend and maybe a day or 2 of snow days to get ready for the cross-examination. If, on the other hand, he slows things down, walks this witness to the end of the day, and then keeps it a mystery about whether his client is going to testify, that helps. First of all, the prosecution doesn't have all that time to get ready for a cross-examination. And second of all, he could stand up on Tuesday or Wednesday or whenever court is back in session to say, you know what, I've decided not to call my client to the stand. I'm ready for closing statements. And now maybe the prosecutor has been focused on cross-examination versus getting ready for a closing statement. Either way, some of this testimony is completely strategic. It is a little bit boring. It's a little bit tedious, but overall, it's very strategic.
I'm seeing a lot of comments popping up on our YouTube channel, and I know we're getting texts about this too. People saying this is so boring. What is the defense attorney doing? Why is he talking so slow? He's just dragging on. And I know, speaking with Matthew Torres, who's been in the courtroom for us, he mentioned to me a couple of the jurors, he saw them yawning. He saw one juror roll their eyes. Another juror smiled when we heard the prosecutor, Jenna Sands, making a comment about a particular objection. And he said that Christine's family has been in the room, and they've only been really looking up at the screen for some of the graphic images that have been up there, but they were paying attention when some of the photos of Christine in a bathing suit were shown on the screen. A lot of what we've been hearing today is focused around the forensics, the data, and I keep hearing them go back to that conversation of, you know, there's this forensics data and it can't assign a person to a device. Can you explain that a little bit, what we're kind of seeing happen here a little?
What we're seeing happen here is that Mr. Carroll is going through the forensic analysis, and he's going through it in painstaking detail to show what they initially thought was that Ms. Banfield placed the ultimate ad in this case and that she created the profile. So he's going through it in painstaking detail, and then he's going to say, well, listen, the only thing that has changed is the au pair's testimony. Everything comes down to the au pair. Everything surrounds Ms. Magalhães, and there's reasonable doubt in that regard.
Do you think that his plan has been effective at this point?
The jury is bored. Everybody's thinking about, wow, there's a snowstorm coming. The judge said we might be done today. But ultimately, even though the jury might be bored at this point, yawning, or just frustrated, it's a good strategy because it's all about winning the case. And even if the jury's a little bit bored, if you put yourself in a better position to win the case, it's worth that couple hours of boredom.
All right, I do want to get to one question that we do have from someone, and it goes back to the question that you have answered multiple times now, but let's ask it again. Juliana, she took this plea agreement, she agreed to testify, she did testify. Is there a world where the judge says, no, we're not going to go with what your plea agreement says, that you get time served, we are instead going to give you the 8 years left in your sentence?
This is a great question for the defense. All the focus, even from that viewer question, and perhaps with the jury, is on Ms. Magalhães and her deal. And it seems like the inference from that question is, wow, she got a great deal. And that's exactly what you want as the defense attorney. It is very unlikely that the terms of her agreement between her attorneys and the Commonwealth will change, or that the judge will not follow that agreement. We haven't seen the exact language, but I would be surprised if there was any wiggle room where the judge could say, you know what, I'm not going to follow what the parties have agreed to. I'm going to give her a larger sentence. But the idea in that question is that she should receive a larger sentence. She was more involved than what she's saying. Perhaps she's not credible. That's the inference in that question. That is all good for the defense because that shows she is the centerpiece of the prosecution's case.
Do you think these viewer questions that we're hearing are similar to what the jurors are likely thinking?
Absolutely. Your viewers are no different than regular people that are on the jury. They're bright, they're intuitive, and they're seeing right through any smokescreen that either defense or prosecution are putting up. As we've talked about before, sometimes the lawyers think they're the smartest ones in the room. Usually the judge is the smartest one in the room, but oftentimes it's really the jurors and the viewers that are the smartest ones as they're observing things.
You bring up the attorneys, and you also told me at one point that the jurors usually like the attorneys. Do the jurors like the attorneys right now? Because we're hearing that the jurors look bored. Is there a line you're walking as an attorney between annoying the jurors and just extending?
There is a line. They may be frustrated right now, but I think the vast majority of the jurors understand that he's doing his job. And I think if it was me, and I know I've frustrated them or bored them in a way, in closing statement, I get up and say, you know what, ladies and gentlemen, if I've done anything to offend your sense of timing, if I've taken you away from your family for too long, if I've done anything at all that has been an affront to your privacy or your time, please forgive me, because I have only done that in the defense of an innocent man here. And usually if you apologize to the jury in that way, demonstrate your responsibility and take ownership of it, it's usually forgiven.
Okay, so he's hoping for the forgiveness later.
Might as well ask for forgiveness versus permission.
That's fair. I love that statement. You know, the judge has been very clear that she wants respect and she will demand respect in every situation. She made it very clear she wanted things to wrap up today and she was willing to do what it took to make things wrap up. Is he going to annoy her?
There is some leeway. The short answer is yes. But again, she realizes that he's doing his job. There is a lot of leeway in determining whether your client should take the stand. It wouldn't surprise me at the end of the day where Mr. Carroll says, Judge, we've kind of reached the end here. I need the weekend to make a determination with my client in the privacy of our own consultation about whether my client should take the stand. So yes, she will be slightly frustrated. We have an unusual situation because we could have a major storm coming. She's cognizant of that. But I think if I was the attorney here, I would remind her that things have moved along a lot faster than originally planned, so they're still ahead of schedule. She'll be frustrated, but she'll forgive him.
A lot of forgiveness happening. You know, we know that the conversation about Brendan testifying, it happened during the jury instructions period where the jury wasn't in the room. So they likely don't know that Brendan would be called. Do they know in advance who's going to be called to the stand?
They won't know.
Okay.
The judge might say we might have one witness who might be a lengthy witness, but the judge has to be really careful. She's gone through a couple weeks now. She does not want a mistrial. She is praying that there's no mistrial. If anyone comments on whether he's going to take the stand or not, that can be grounds for a mistrial. So she's not going to give the jury any indication that he's going to testify and then he doesn't, because now she's kind of commented on his right to remain silent, his right against self-incrimination. So nobody will really touch that subject. In fact, if he doesn't testify, it would be an automatic mistrial if the Commonwealth stands up in closing and says, well, you haven't heard from Mr. Banfield. That would be an automatic mistrial. So nobody wants to even step into that pool of commenting on his right to stay silent.
Let me ask you this, you know, if Brendan does get up there, what do you think the reaction will be from the jurors? Do you think they'll be surprised?
I think they will be surprised. I think they will be laser focused. His direct testimony will be important, but every juror that I've ever dealt with, when the defendant, the accused, takes the stand, what they're really interested in is the cross-examination. They know what he's going to say on direct. I didn't place the ad, I walked in, I had to shoot him, he stabbed my wife. They know that. They know exactly what he's going to say. He has some things to explain, but what they're really looking for is the prosecutor to try to tear him apart. That may or may not happen. If the prosecutor is not able to really land some fair but serious blows on Mr. Banfield, that's really indicative of a difficult situation for them. The jury is expecting him to be torn down on cross-examination.
I know we've been talking a lot about the potential for a mistrial, a hung jury. Can you kind of explain for people that don't know what those two terms mean?
Sure. A mistrial is something that happens during the trial that's so egregious, the judge says, you know what, this trial isn't fair anymore. We're going to have to stop this. We're going to have to do this whole thing over with a new jury, etc. A hung jury is when the case actually goes to the jury, but the jury is not able to reach a unanimous decision. Let's say it's 10 for conviction, 2 for acquittal. They will usually give instructions to say, hey, keep working it out, keep trying. If ultimately they are hopelessly deadlocked, then that is a hung jury. What that means is the entire trial has to be redone with a different jury selection, probably another 6 or so months down the road, and it's really a redo, and they do the whole thing over again.
Versus a mistrial where it's a done deal.
A mistrial, if it's the government's fault, then perhaps it's a done deal and it can't go forward. But if it's a mistrial because, let's say, a juror looked at some publicity or something like that, then the trial can happen all again.
Okay. Do you think, just your final thoughts before we go back in the courtroom, do you think we will see Brendan Banfield on the stand today?
I don't think we'll see him on the stand today. It's possible that he's jammed on there at the end, given the court's inclination to keep this thing moving, so to speak. It's possible, but it seems like Mr. Carroll is walking this out a little bit.
All right, we see him sitting there. Let's take you back inside the courtroom and see what happens next.
Well, here's the, gotcha. I don't know where his mouse is. I mean, there's the folder
Okay.
from the return, but if you
Can
need
you,
more.
can you clip it with the headers included so that it tracks?
Understand what they're doing. I don't need narrative, Mr. Carroll?
Not in the remaining.
Okay. So if you could get back to the stand, that's fine. Are you satisfied with what you're still missing some information? Okay. Mr. Carroll, how much more do you have with this witness? Because you have a remote witness that has been sitting there all day waiting to testify, and if I have to take him out of turn.
I just talked to him, Judge. And I told him we may not be done.
But I would like to do that witness.
Would you?
Even if
Okay.
we have to take him out of turn. I assume your cross-examination is not going to be long. I just need to get you through your direct.
Okay.
So.
Have you already notified him?
No, we haven't notified him.
Yeah,
But
that's fine. I'm fine
I
with
just
that.
want, I mean, he's been sitting there all day, and I'd rather get him done. He's worried about, I think, losing electricity next week. I mean, there's just issues that
Right.
I don't want to
Okay.
stress your witness out and try to get them done today.
That's fine, Judge. I literally just talked to him and said, I'm not sure yet. So that's fine.
Okay.
I'm happy to do that.
How much more, how many more questions? Or how many?
Well, we have a couple of days to go through, Judge, so we're probably maybe hour and a half, 2 hours for him.
Well, then we need to stop with him and do your remote witness. If
Okay.
that's okay with everybody? All right, you can have a seat. Let's go ahead and get the remote witness.
And-
IT as well. Let's go ahead and get him up before we bring the jury back in, and we'll just tell him we're taking him out of turn. And that way, by whenever we come back after the snow, maybe you'll have all your exhibits in line, streamlined, and you'll have all the geo-tracking information that's needed for that
And
foundation.
he'll be able to work on that.
Okay, so we can do that, so he can finish after that. I assume this witness we can get done before 5?
I believe we can.
Okay. Do you have any objection to that?
No.
Ms. Sands?
Thank
Okay. I'd rather just do that because this remote witness is,
Yes.
there might be a lot of ice in their area, and so they don't know if they'll have electricity, so. Okay. And I'll just explain it to the jury once, or do you have any exhibits to show this witness online? Well, I'm just asking if you have if you have exhibits. Okay, we'll just get somebody from IT here to help you do that, so your witness can see does your witness have a copy of your exhibits? Have you emailed?
Yeah, they were what he
So he would already know which ones you're referring to, correct?
yes. Yes.
All right, can you pull the screen up, please? This one? Yeah. No, it's over here. I think. Which one switches?
Numbered, so I don't know that it matters.
Okay. stay on the call. What's your witness's name, Mr. Carroll?
Here, I can show you.
Barrero?
B-A-R-R-I-E-R-O.
Mr. Barrero, can you hear me, sir?
Yes, Your Honor.
Okay, all right. We're just gonna wait for the jury to come in, and then I'll swear you in, sir, okay? And once I swear you in, we'll change the position of the monitor so you'll be able to see Mr. Carroll, okay?
Okay.
All right. All right, you want to bring the jury back in? We ready for the jury?
Yes, Your Honor.
Okay. All right. Afternoon, ladies and gentlemen. What we're going to do is we're going to, sometimes things happen in trials. We need to switch things up a little bit and take things out of turn. So what we're going to do now is we're going to come back to the last expert that you had the next time we meet, okay? And we'll come back to his direct testimony and we'll go through the rest of his testimony at that time. What we have now is a remote witness that has been waiting all day, and he's in an area that is going to be impacted out of state with the weather. So I wanted to make sure we got him today. Not that I'm hoping he doesn't lose electricity anytime in the next few days, but we just want to make sure we got him in for you. So we're just going to take him out of turn, okay? All right, so you want to call your next witness?
Yes, Your Honor. I'd call Nick Barrero.
All right, Mr. Barrero, if you could raise your right hand for me. Do you swear or affirm to tell the truth under penalty of law?
I do.
Mr. Barrero, can you hear me? This is John Carroll.
Yes, sir, I can.
Okay. Sir, can you state your name, spelling it for the court reporter that we have here?
Yeah, sure. It's Nick Barrero, N-I-C-K. Last is B-A-R-R-E-I-R-O.
And sir, what is your area of discipline as an expert?
I'm an audio-video forensic analyst.
And can you give the ladies and gentlemen, the jury, an idea of your background that allows you to become an audio-visual analyst?
Sure. I spent 15 years in law enforcement in California before founding my own media forensics firm, and I've been doing this type of work full-time for the past a little over 5 years now.
And do you have any training, specific training that allows you to be an expert in this area?
I do. I've attended a lot of specialized trainings. I received my certification as a certified audio-video forensic analyst through the Electronic Technicians Association. I've also done training with the FBI. I'm a member of the Digital Imaging and Video Recovery Team through the FBI. I've done training specifically on all of the software that I use in my work, both for enhancement and analysis of any sort of recorded evidence. I've taken a lot of classes through the University of Colorado at Denver, which is kind of the gold standard for media forensics training, and lots of other vendors. I've done a lot of specialized training.
And how long, and let me ask you this, are you part of, I think you mentioned an organization that you're part of? Are there any other organizations that you're involved with related to your specialty?
Yes, I'm an active member of the International Association for Identification. I'm an active member of the Audio Engineering Society and the Electronic Technicians Association International, who provided the certification for the audio video forensic analyst certification.
Now, do you, with that experience, do you train other people that are in your discipline?
I have trained law enforcement professionals in the proper way of handling and analyzing digital evidence. I've trained security professionals. I haven't trained anybody specifically that does exactly what I do. Like, I haven't trained any of my competition, if you will, but I've trained a lot of other related individuals.
Okay, and have you testified in court relating to your findings and analysis?
I have.
And
I've
how many
testified
times would you estimate?
I've testified in court since I left law enforcement. I testified many times while I was a police officer and a detective, but since I left law enforcement and I've been doing this full time, I've testified about 30 times. About half of those were in depositions, and about half of those were in trials like this one or other sort of court hearings.
And have you been qualified as an expert in those courts that you've testified?
I have.
And how many times have you been qualified in the courts that you've attended?
All of them. I've never not been qualified as an expert.
And what states have you been qualified in?
Ooh, I wouldn't be able to give you an exhaustive list off the top of my head, but a lot of states.
Okay, have you ever been qualified? Well, you're in Tennessee, correct?
I am.
Have you ever been qualified in Tennessee?
I have been, yes.
Have you ever been qualified in Virginia?
I believe so, but don't quote me on that. Again,
Okay.
I don't recall. A lot of my testimony
Judge, if I
is
may.
remote like this.
We'll stipulate to his qualifications
Okay.
as an
All
expert.
right. Do you want to move him in as an expert in
Yes.
audio video analysis?
Yes, Your Honor.
All right.
I'd move Mr. Barrero in as an expert in audio video analysis for the record.
All right, so moved.
Mr. Barrero, calling your attention to the case that you worked on for, or the Banfield case. What specific
Yes, sir.
digital evidence did you receive for your examination?
I received 2 digital files. One was a 911 recording. It was just a short recording, an audio recording of a 911 call. And then I also received a longer recording. It was an exemplar recording titled Lily 3 Original, and it contained sounds of a dog barking, whining, that sort of stuff.
And can you explain to the court what an exemplar is?
Sure.
And the
So
ladies and gentlemen of the jury.
Yeah, absolutely. So in forensic analysis, often we are using exemplars as a comparison. So a known sample, such as this Lily recording, is an exemplar because it's a known recording of this dog named Lily.
Judge, at this time,
That is now.
excuse me, sir, I'm sorry. I would object to the testimony of a known recording. I don't believe he's laid any foundation to show that he knows anything about the recording.
All right, I'll sustain the objection.
Okay. Did you hear that, sir?
I did.
So what I was just asking you is what an exemplar was. And
Yes. So
go ahead.
Sorry, yes. In general, an exemplar recording is a known recording of known origin that can then be used as a point of comparison against an unknown or a questioned recording.
Can you briefly explain what a hash value is and why it's important for forensic integrity?
Yes, a hash value is like a digital fingerprint for a digital file. It's a unique value that is calculated on the file. It's not part of the file itself. It's calculated using every bit of data that's in the file. So because it's a really complicated mathematical algorithm that is done to the file, if any one single bit of data is changed within the file, the hash value changes. So hash values are what we use to uniquely identify digital evidence like this, and I calculated the hash values for the recordings in this case so that we can just verify that I used the exact unaltered copies of the original evidence that you have there in court.
Okay, thank you. If I could just ask you a little bit about your methodology.
Yes, sir.
What are the terms critical listening, waveform, and spectrographic analysis? Can you explain those terms to us?
Sure. Critical listening is it's a very detailed, repeated review of the audio data using high quality professional headphones and on a professional forensic workstation. And that's done usually it's done in conjunction, kind of hand in hand with waveform and spectrographic analysis. And waveform and spectrographic analysis it's a way to visualize the audio data that you're actually hearing in the headphones. So the waveform, I think most people are familiar with what the waveform looks like. It's a squiggly line going from left to right across the screen, and it represents the volume or the amplitude of an audio signal over time, whereas the spectrogram does the same from left to right. It represents the same sort of a timeline, but it also adds a third component, which is the frequency or the pitch that is present in the recording.
And sir, what does a spectrogram show us that our ears might miss?
So the spectrogram visually separates the sound that your ear hears as just one continuous sound. The spectrogram visually separates that sound into its frequency components. So higher frequencies are at the top of the spectrogram, lower frequencies are at the bottom of the spectrogram. And it allows us to kind of see past the noise or overlapping sounds in a recording. You can look at it like the difference between taking a bite of cake and you taste cake. You know, most people know what cake tastes like. But this allows us to not only taste the cake, but it allows us to separate that into its individual components, right? The flour, the butter, the sugar, all the ingredients. That's kind of what the spectrogram does, is it separates out the audio signal into its component frequencies.
And in preparing your report, did you create figure or examples of this?
I did. Okay. Spectrograms for both the exemplar recording and for the 911 recording.
And do you have your report?
I do.
Okay. Is that possible to share your screen? I don't know how.
No. Do you have his report?
I do.
Then you can share your screen.
Okay. Sir, I'm going to open up your analysis and report.
Okay.
Judge, just to move things along, we are going to object to the witness's report being offered into evidence. If there are specific photographs or diagrams he wishes to reference, those would be fine. The report, no.
That's what I'm referring to now, Judge.
I know you're referring to the report, but I guess the question is, what are you going to glean from referring to the report? Because she's saying that she's going to object to it coming into evidence.
Well, there are examples of what he's speaking about that would be instructive.
Well, I'm sure he remembers his report, and if he doesn't, he can refresh his memory by looking at it.
I was just, okay. Mr. Barrero, what is fundamental frequency?
If you could turn your laptop off, or just so we can. So then that'll go off.
Turn it off?
That's okay. That's fine. Go ahead. We're good. Go ahead. Go ahead, ask your question.
Are you there, Mr.
Yeah, I'm sorry,
Barrera?
go ahead. Yes.
What is fundamental frequency?
And I'm sorry, I missed it. Are we able to show any diagram or any of
No.
the images?
No,
We're not
we're
able to
gonna
show the images?
We're
Okay.
going to rely upon your recollection.
Okay. So if you were able to see the spectrogram, again, you have the higher frequencies at the top of the screen, lower frequencies at the bottom of the screen. The fundamental frequency is basically the lowest line in that spectrogram, and it represents the kind of the baseline pitch of any sound. So I don't know them off the top of my head, but every musical note on the scale has a specific pitch that is the definition of that note, and that is the fundamental frequency of that note, and that's symbolized as F0 in diagrams that you'll see of a spectrogram. F0 is the fundamental frequency.
Okay, sir, have you listened to the items of evidence that you received for examination recently?
I have.
Okay, and would you, if I play them, would you recognize those?
Yes, I would.
Okay. I think you had referenced the Lily 3 as an exemplar recording.
Yes, sir.
Okay, I'm going to play that for you now.
Is that already in evidence?
No, it is not, Judge, and we would object.
Okay, so let's mark it. And what's the objection?
Foundation.
All right, we're going to mark it. There's an objection to foundation.
Yes, Your Honor.
What's next? 193. 183. I was going to, I'm sorry? 193. 193. Okay, I'll mark it as 193. But the objection is foundation.
Yes, Your Honor. Sir, did you hear the exemplar 911 call?
Sir, you can't play it. Sir, you want to approach Mr.? Mr. Carroll, if we can continue, I have a juror that needs to leave at 5, please. So can we continue? Okay.
Sir, are you familiar with the exemplar 911 concatenated wave?
I am. Yes, I created that file.
Okay. And did you create that off of the 911 call that was provided to you for examination?
Yes, it's a concatenation. It's a combination of the 911 call and the exemplar.
Sir, we're gonna play the first exemplar of the first 911 call, or the only 911 call that you received.
Is this Exhibit 1?
This would be,
Or Exhibit?
it would be Exhibit 193.
No, I mean.
194.
I thought we were playing the 911 tape that was already in evidence, Exhibit
Oh,
1.
it is the same
So
one.
all right, then we can play Commonwealth's 1.
If we can be completely clear, the witness just testified that he made a concatenated recording. That's the overlay of the
Okay.
not admitted exhibit on top of the 911 call. If counsel's asking to play Commonwealth's Exhibit 1, the admitted 911 call, no objection.
Okay. Are you going to play the Exhibit 1?
I'm going to
911
play
call?
the first 911 call.
Not something that he created, but.
Not
the
something he
original-
created.
The original
something-
911 call.
Something that was provided to him from our discovery.
And that's what you're going to play now, is
Yes.
just that one?
Yes.
Any objection?
As long as the one that he provided to his witness is the same as was admitted in evidence, no objection.
Well, I'm happy to play the one that's admitted in evidence, but this is the one that I received from discovery, so.
So
I
it
would
should be the
assume-
same one then?
Should be the
Okay,
same.
so Commonwealth's 1. Let's play Commonwealth's 1.
Sir, can you hear this?
If we can't hear it, he can't hear it. Okay. We shouldn't have to see it. Oh, it's the audio. I've got it too. Thank you, Gerald. In the corner now. Yes, please. Thank you, sir.
So I'm trying to play this file. He's on there.
I can just play it.
I mean, I have IT here to help him as well.
Fairfax County 911, where's your emergency? Hello, Fairfax County 911.
February 24, 2023, 7:47, 39.
Sir, were you able to hear that?
I was.
Now, that 911 call was the comparison to Lily 3 that you had received, correct?
Correct.
And what, if anything, did you do with just the 911 call?
So the 911 call can be broken up into 3 separate parts. The beginning is the dispatch, well, it's an automated voice talking about the date and time, and then it's the dispatcher's voice answering the call. And there's a little bit of background noise during that when the dispatcher's answering. And then there's this brief, it's about 1.5 seconds. I think it's 1.4 seconds of what could be a groaning sound. And that is really the only portion of the recording that I did anything with. So I ignored the automated voice at the beginning and the dispatcher answering the call. I used the 1.4 seconds after that before the end of the call, which is the dispatcher asking again if there's somebody on the line, and then the automated voice again, and it ends. So it's really just that 1.4 seconds in the middle of the call where that apparent groaning sound is that I focused on in that recording.
Okay. There's been a foundation objection
Can
relating
you move your
to...
microphone back up? Move your microphone. Thank you.
There's been a foundation objection relating to the Lily 3 file that you've received. So we're going to have to get evidence as to the foundation before we can continue on with your examination.
Okay.
I'm not certain when that will be, but are you willing to get back on at the appropriate time?
Yes, sir.
All right, is there any cross-examination based on?
Not at this time.
All right.
Your Honor, I would, at this time, continue on with our previous examination and have
All right.
Mr. Barrero come back
On
in
call?
when the
Okay,
time's
Mr.
appropriate.
Barrera, we'll call you again when we need you, okay, sir?
Okay,
Thank
thank
you.
you.
Your Honor, if you could admonish him that he's subject to recall and can't discuss his testimony.
Right. You are subject to recall, sir. You're kind of in the middle of your testimony at this moment, I guess, in a way. So you really can't talk to anybody in the case to include the defense team at this point, because it seems like he suspended your testimony, okay?
Yes, Your Honor.
Okay, thank you. All right. Thank you, guys.
Your Honor, in terms of speaking with him, can I speak to him about the timing of when he may be testifying again
Well, yeah,
without?
we'll take care of that.
Okay.
We have his email now and everything, so if you could let us know, we can contact him and make sure he's set up.
Okay.
Okay.
Thank you.
Just give us enough lead time to do that.
Yes.
All right, want to come back to stand? In a moment, can you get that back off?
I'm hoping.
You want to give it a second to finish?
Yeah, don't get hit by the
You're going the wrong way.
max headroom device. We weren't to the 30th, yeah, we were on the 30th.
Sir, do you see the slide on the screen?
I do.
Okay, I believe that was something that we were going to provide additional report, which we'll be able to do. Let me move on to number 20.
What exhibit number?
I didn't have one. I stopped at 191 at life response. Oh, or is it Lily?
And I believe this is 190.
Nope. Oh,
No.
Judge, I have 190 as the January 23rd, 2023 login to CBRN 920 at 11:22
That's,
p.m.
that's not 190. I think it's, I don't know.
No, 193.
184?
Yeah, that's it.
Blue house, no, it's not one.
You got 189?
189.
No, well, you just,
189 had time
no,
stamps.
that has 4 more blocks. I don't, it's not that one either. That one was when they
Oh, I think
added
it's
blocks to it.
183.
So
This is 184 that he's got.
it's 184.
Yes.
The one on the screen right now.
184. It's not in evidence.
Correct.
Sir, can you see the slide that's on the screen designated as Defense Exhibit 184?
I see a slide on the screen, yes.
Okay. And what is that?
This is a Google map with overlay points that I put on to show 5 locations relative to the Banfield residence.
Okay. And what, if anything, did you do in your digital forensics analysis to create this?
I reviewed the Google geolocation records that we discussed earlier. Also, T-Mobile provided locational records related to, in this case, Mr. Banfield's device. T-Mobile records with location information were obtained by the Fairfax County Police Department, both related to all calls and data sessions. So those were also consulted and were inputted in where appropriate. I don't know if these particular points are from the Google records, the T-Mobile records, or a combination of both.
And, sir, this is the document that was created relating to those returns that we were looking for from Google and from T-Mobile, correct?
I was searching for the Google records. I wasn't asked to search for the T-Mobile records.
Okay. Well, just in anticipation of that. Your Honor, I'm going to move on to the next slide, which would be designated Defense 185. Sir, do we have those records?
You haven't moved. Why? We're still on 184.
Okay. Your Honor, the records are still be supplemented. He was
I understand,
working.
but you said you were moving on to 185, but this isn't 185, this is still 184.
I'm sorry. Sir, this would be 185, Your Honor?
No.
No,
Judge.
that is not. That looks like.
185 was
180.
the 21323 records.
Yeah. What number is this one? I have it as 180, is that correct, or no? No?
I have artifact information.
No, that's a different one.
Judge, I don't believe we've yet discussed January 30th.
I don't see it anywhere. Would you like to? We have not seen this one. So would you like to mark it as 193?
Yes, ma'am.
All right.
Sir, look at what defense exhibit that has been marked as 193. Do you recognize that?
I do.
And what is the basis to create that slide?
These are two login artifacts from the alleged suspect Gmail account, the CBRN 920 account, both on January 30th, 2023, one at 10:36 and 38 seconds p.m., the other at 11:03 and 25 seconds p.m., both from a Banfield residence, both from a Windows-enabled device.
Your Honor, move this in as defense exhibit 193.
No objection.
193?
Sir, can you explain to the ladies and gentlemen the significance of these artifacts?
These are two additional logins that occurred from the Banfield residence, again on January 30th, 2023, at 10:36, 10:37 approximately p.m. and 11:03, approximately 11:03 p.m. as well, both from a Windows computer, both into the CVRN 920 account.
Your Honor, I'm going to move to the next slide.
All right.
Sir, do you know this slide?
I do.
And how did you create that?
This is FetLife messages, again, from the FetLife, the complete FetLife message set. This is limited to two messages that occurred on January 30th, 2023, around the same time of the Gmail account logins we just spoke of, one at 10:47 p.m., the other at 10:58 p.m., both outbound from the account purporting to be that of Christine Banfield's.
And Your Honor, I move this in as defense
No
exhibit
objection.
194.
Oh, you.
No objection.
Okay, 194.
Should it be? No.
No.
And sir, can you describe how you acquired these messages?
These were acquired by the Fairfax County Police Department with a search warrant. These were provided in discovery in a spreadsheet, and that is what I used to create this subset here.
Your Honor, I'm going to move on to the next slide.
All right.
This would be marked as defense exhibit 195. What are these records from?
These are Google geolocation records, again, related to Mr. Banfield's device from January 30th, 2023. Two records, two geolocation points In the same time frame we've been discussing, one of these is at 10:50 p.m. on the 30th. The other is at 10:52 p.m. on the 30th.
Okay, and were you able to identify the entire record that makes up this screenshot?
I was, yes.
Okay, and that's something to provide for this and others that you did screenshots on?
Yes, this is part of the massive spreadsheet that has all of the records.
Sure, does this relate to those records as well? This would be 195, 96.
I believe it does once the plots are pointed, but yes. For now, it's just a Google map of the Reston Herndon area.
Judge, we won't look to move that into evidence until we get the document to Ms. Sands. And same with this situation, with this particular slide?
Yes, these are the two aforementioned Google geolocations, approximate location on the map.
Okay.
So Judge, that would be 197?
Yeah, that one's
197.
Thank you.
Judge, this would be identified as Defense Exhibit 198. Sir, have you seen these records?
I have.
And is this something that you created based on the artifact information?
This is just the artifact information copied out and pasted as a solo artifact for display.
Okay. And this is a different date than what we just previously looked at, correct?
This is February 7th, 2023 at 10:02 p.m.
And what are the significant parts of this exhibit?
This is another login to the alleged suspect Gmail account, also from the Banfield residence, also from a Windows computer.
Your Honor, I'd move that in as Defense Exhibit 198.
Any objection?
No, ma'am.
198.
And I'm sorry, the notable portions of this were?
The date and
Judge,
time.
asked and answered. I think we've
Sustained.
identified its value.
Next question.
Your Honor, I'm going to move to the next slide. And sir, are these documents that you used and created in your digital forensic analysis in this case?
This is a screen grab again from the FetLife larger production. These are 3 outbound messages from the account purporting to be that of Christine Banfield, all on February 7th, 2023, one at 10:08 p.m., one at 10:12 p.m., one at 10:15 p.m.
Your Honor, I'm going to move to the next slide. Actually, I'm sorry. I'd move to admit Defense 199 into evidence.
Any objection?
No objection.
199.
Your Honor, I'm going to move on to the next slide. Sir, what are these?
These are additional Google geolocation points provided regarding Mr. Banfield's device. These are for the same time period. This is February 7th after the conversion. These are in Zulu time, but February 7th at 10:04, 10:06, 10:08, 10:10, 10:12, and later in 10:12 with their corresponding geolocation coordinates.
And you have the supporting document from where you got this screen grab?
I do.
Okay. Your Honor, identify that, and we'll move to put it into evidence at a later time. I'm going to the next slide. This is what will be identified as Exhibit 201. Do you recognize that?
I do.
Is that related to the screen grab that was just in the last slide?
It does. This is the map that will be used to depict the geographical coordinates.
Okay, Your Honor, we'd identify that as 201 and move to admit into evidence after we provide the main document. Moving on to the next slide. Is that the same
It didn't.
situation?
It is with
the 202.
Is that still 201? Or no?
Well, now
Okay.
Oh, we've added the icon.
yes,
We added the icon.
one of the geocords is there.
And that relates to the same Google search warrant records that you received?
It does.
Okay. Your Honor, we'll ID that as 202 and move to admit once we provide the main document. Sir, do you see the screen in front of you?
I do.
Can you identify this document?
I can.
Okay. And how did you create this document and what does it contain?
This is a screen grab of timeline data from Ms. Banfield's mobile device or cell phone.
Your Honor, I move that in as Exhibit 203.
Any objection?
Judge, again, the document lacks column and row headers. I have no idea what.
Foundation is the objection.
Yes, ma'am.
Sustain the objection.
Sir, this particular document, is this something that you created?
I captured the screenshot, but this is information
Sorry.
that this is information that is presented to me in the forensic software that I use to review the artifacts from within the subject device, in this case, Mrs. Banfield's cell phone.
And are there headers and other such things to go with this document?
There are. This one in particular came from a timeline view as opposed to an artifact view. So this is a point in time, in this case on February 23rd. This one's in UTC. February 23rd, beginning just before 9 p.m. through around 9:28 p.m. And because it's a timeline view, it's everything that was going on at the phone at the same time. So it's not just emails, it's not just website visits. This one begins with an instant message, goes to an email, website cookies, and then back to messages.
Okay, I think the foundation of it is something that we're going to have to provide in order to be able to introduce that into evidence. Do we have those documents?
Well, this is part of this is from the portable case. So it's, millions of documents all in one thing. I can try to replicate this with the column headers if that makes it easier, and we could.
Now, the portable case, I think we've gone through that before. That's a tool in digital forensics, right?
It is.
And would there be header columns in that portable case as it shows?
Yes, there will be.
So it's possible to provide that for purposes of the Commonwealth's objection?
Yes, that can be.
Your Honor, we'd
that can be done.
identify that as Exhibit 203 and move it into evidence at a later time. Sir, do you recognize that?
I do.
Identified as Defense Exhibit 204. Your Honor, move this in as Commonwealth's Exhibit 204.
Objection, foundation.
Foundation, objection.
Do you have the foundation for this or where this came from?
I do. This is a similar view, a timeline view of the activity on Ms. Magalhães' phone from about the same period of time, February 23rd, 2023, beginning at about 8:56 p.m. through approximately through approximately 9:09 p.m.
All right, Your Honor, we'll identify that as 204 and move it into evidence at a later time.
Mr. Carroll, do you have any evidence that you can go forward on that you don't have to get other supporting documents for? Because we're just spinning our wheels right now, because we're going to have to go back to all of these, and so
I understand,
I'm just not interested in wasting the jury's time.
I have these presentations based on days, Judge, but based on the Commonwealth's objection of foundation, we need additional information in order to satisfy that foundation.
All right. That's fine. So you don't have any other questions without foundation?
Well, I can certainly check, Judge, as I go through. I'm just identifying these so that...
I know, but you're just identifying them, and we're going to go back, and it's not saving us any time. We're going to have to all do it again.
I can go ahead and see if there's anything that we can work with now.
Okay.
Sir, do you recognize that?
I do.
And what is that?
This is an artifact from Ms. Banfield's laptop, Lenovo laptop.
And is that something that you utilized in your digital forensics analysis?
It is, yes.
Your Honor, I'd move that in as 205.
Any objection? All right, 205.
Sorry, no objection.
That's fine, 205.
205?
205.
Yes, thank you. Sir, can you tell the ladies and gentlemen of the jury how this is a part of your digital forensics analysis?
So again, this is timeline activity. As I explained, I like to look at what was happening before a significant event, after a significant event, during all of the time periods around a significant event on relevant devices, the laptop being one of those. This is a file opening or file page access for a Word doc or a Word document, a Microsoft Word document, docx file from an Innova website. And this occurred on February, again, apologies, this is in UTC time. This occurred on February 23rd, 2023 at 9:33 and 52 seconds, so 9:34 p.m. Approximately 9:34 p.m.
Your Honor, I'm going to move to the next slide. Sir, do you recognize this?
I do.
And what is this?
This is an image from an Instagram page.
Whose device is it taken?
This is from Ms. Magalhães' device, her mobile phone.
Your Honor, I move this in as Defense Exhibit 206.
Any objection?
Judge, I'm not sure if it's just my screen, but it appears to be truncated. I think there should be more data below.
Oops.
We lost it there.
I was trying to reduce it.
Is there any data behind, after the fourth line?
There is not, ma'am.
There is?
There's not.
There's not?
No,
There's not, okay.
just to save Mr. Carroll.
That's all there is. Any objection to 206?
No, if the statement is that there was no other data on this page, then
There may be data, if it was there, though, it's definitely truncated, so it's not something he's going to be able to find. I'd have to check and confirm whether or not that's the case.
objection,
All
foundation.
right, I'll sustain to foundation.
Here, I'll move on to the other slide. This would be identified as Defense Exhibit 207. Sir, have you had an opportunity to look at that?
I have.
And is this something that you work with in your capacity as a digital forensic analysis?
It is.
Your Honor, move this in as Exhibit 207.
Any objection?
No, Judge.
207 in evidence?
Can you describe for the ladies and gentlemen of the jury, what is this artifact and what's the significance of it for February 23rd, 2023?
So this is a visualization of, it's two artifacts of the same thing, and this is an example of corroboration. So on the top half, we have the artifact of a Google search and website visit from Ms. Banfield's laptop computer. And that was on February 23rd, 2023 at 9:34, approximately 9:34 p.m. On the bottom half of the screen, the second artifact is what Google provided in their responsive documents to the search warrant. So we're able to just visualize the same search, but how it appears on a Google response versus how it appears from within the computer itself. Obviously, the Google portion is in UTC and differs by a second, which is not uncommon.
Your Honor, I'm going to move to the next slide. This would be identified as Defense Exhibit 208. I'd move that into evidence.
Any objection?
It's a duplicative of the last slide, or at least half of it.
I'm sorry, I didn't hear.
It's duplicative of 207.
That's the bottom of 207.
Correct.
Right.
Is there any reason, is it true this is duplicative?
It is, it can be
Okay.
skipped.
And we'll disregard. Actually, we won't, it's 208.
It is
So,
208.
Your Honor, I'm going to go to the next slide.
Sure.
Sir, do you recognize this slide?
I do.
Okay, and what's the significance of this slide?
This is this is an artifact from Ms. Banfield's mobile device, but lacking the requisite header information, I guess.
We'd identify this, Judge, as 209, I believe.
All right.
Sir, can you see what has been identified as Defense Exhibit 210?
Again.
And what is that?
This is Instagram activity from Juliana's mobile device.
And what's significant about this Instagram activity?
The time and date.
Your Honor, I move this in as Defense Exhibit number 209.
210?
I'm sorry, 210.
No objection.
210 in evidence.
Mr. Litsky, is there any further explanation of what this is beyond what you've already done?
It was activity occurring on the mobile device belonging to Ms. Magalhães on February 23rd, 2023 at 9:34 and 24 seconds p.m.
Your Honor, I'm moving on to the next slide. What, if anything, is this?
This is an annotated artifact obtained from Ms. Banfield's Windows laptop.
Okay, and is that in UTC time?
It is.
Okay. And is this something that you relied upon in your digital forensics analysis?
It is.
All right, I move this in as Exhibit 211.
Objection, speculative and testimonial. It has additional information on it that was created by the witness, not by the device.
All right. I'll sustain the objection.
These annotations, sir, are those something that we can modify so they're not on there?
Yes, I suspect the successive slides will have similar annotation.
Okay.
It should have been removed. My apologies.
Sir, this is identified as Defense 212. Do you recognize this slide?
I do.
And is this part of your digital forensic analysis?
It is.
And Your Honor, I move this in as Defense Exhibit 212.
Any objection?
No objection.
212?
And sir, can you explain for the ladies and gentlemen of the jury, once it comes on, as to what is contained in this? And
These are two telegram messages being sent from the account purporting to be that of Ms. Banfield's. These are in UTC time. These were both on February 23rd, 2023, the first at approximately 9:35 and 47 seconds p.m., and the second at 9:36. Both one way from the account purporting to belong to Ms. Banfield to Mr. Ryan, or to the account purporting to be that of Mr. Ryan.
Your Honor, I'm going to move to the next slide. Sir, do you recognize this slide?
I do.
And where does that come from?
It's a continuation of the telegram conversation.
Your Honor, I move that in as Exhibit 213.
Any objection?
No objection.
213?
And what is that for the ladies and gentlemen of the jury?
These are two additional messages, the same direction from the account purporting to be from Ms. Banfield outward. On the same evening, 2023 at 9:36 and 27 seconds p.m., the second at 9:36 and 31 seconds p.m.
Your Honor, moving on to the next slide. This would be identified as Defense Exhibit 214. Sir, can you identify that record?
Again.
Okay, and is this something that you utilize in your digital forensic analysis?
I did.
Your Honor, I move that in as Exhibit 214.
Objection, subject to additional foundation.
All right.
Sir, can you describe for the ladies and gentlemen of the jury as to how you compiled this timeline?
This is from the portable case data from Ms. Banfield's laptop. This is the timeline view, again, from the evening of February 23rd, 2023, from about 9:37 p.m. all within the 9:37 PM timeframe for website activity and application activity that occurred on her device at that time.
Your Honor, I move that in as Defense Exhibit 214.
Judge, at this point in time, there's still absent information. It's clear that the screen grab has truncated the entirety of the destination website.
All right, I'll sustain as the foundation at this time.
Mr. Litsky, is that something that we can have the complete picture within that slide?
It is.
Okay. Your Honor, we'll just identify that as 214.
214. Did you want to stop there?
I have one more slide,
Okay,
Judge,
sure,
if
sure.
we're
Perfect.
see where that goes. Sir, can you identify this slide?
I can.
This would be Defense 215. And how did you create this slide?
This is another timeline view from the device of Ms. Magalhães.
Your Honor, move this in as Defense Exhibit 215.
Objection, foundation.
Foundation objection.
Sir, do you have the foundation? It sounds like the columns and where this originates from?
I do.
Okay. Can we provide that?
I can.
Okay. Your Honor, I'll just identify that as 215, and this is probably a good time.
Okay, all right. Ladies and gentlemen, we'll go ahead and release you for weekend and beyond. I'm not sure exactly how long it's going to be. I will tell you we will make a decision if, well, first off, if the county closes, the county government closes, Fairfax County government closes, we're closed, okay? So that's easy. They might make the decision as early as tomorrow. So if you hear that Fairfax County government is closed starting tomorrow for Monday, we're closed, okay? So if ever the government is closed for Fairfax County, then we're closed, okay? That's easy. If they don't close, if they have liberal leave, then we make our own separate decision, okay, at that point. So if you only hear liberal leave, wait for our decision. We're going to make our decision by Sunday evening. And we have all your contact information, and we will let you know at that time, okay? Other than that, let me just give you your warning instruction for the weekend and maybe a couple days after, just to make sure you understand that you're still under your the court's orders as far as this case goes. You're not to read anything about this case. You're not to watch anything about this case. You're not to listen to anything about this case. This applies to television, newspapers, magazines, the internet, and any online sites. Further, you're not to read, watch, or listen to anything about this case on any social networking site or streaming service. In addition, you must not communicate with anyone about the case, whether in person, over the phone, by email, text, or instant messaging, or by any other electronic or non-electronic means. This also includes your fellow jurors, friends, family, coworkers, acquaintances, and strangers. I also instruct you that you cannot do any research or make inquiries about this case, whether online or by any other means. For example, you cannot look up information on the internet that is related to this case or related to the persons involved in this case or any places that are mentioned in this case. Nor may you consult dictionaries or use any other reference materials. What you learn about this case, again, is limited to what you learn in the four walls of this courtroom when the proceedings are underway, okay? So I'll release you for the time being, and stay safe and warm, and we'll see you next week. Again, sir, since you're still testifying, you cannot discuss your testimony with anybody to include the defense team at this time, okay? You can have a seat. All right, so we'll start at 10 on whatever day we come back. A couple things. Please use this extra time to reboot a little bit and get more organized. The wheels were coming off there, and I don't want to waste the jury's time anymore or witnesses' time, or for that matter, my time. Just remember that you are responsible for your record to keep it clean, not me, not Shannon, okay? So please be wary of your exhibits and your numbers and what you are. Moving forward, I expect, and this is what I expect from all attorneys moving forward, I want all exhibits pre-numbered and in electronic format separately in separate files with the exhibit number already titled on that file, okay? And make sure you have all your witnesses lined up and ready to go. Does that make sense to everybody?
It does.
Okay, we've got it. And make sure, Mr. Carroll, I think we need all your exhibits from today. Did we get the video to you?
Judge, your clerk kindly provided the one item. I am still missing all of defense exhibits today.
So we need to send all the exhibits in those same separate files by exhibit number to the Commonwealth and also to us. When you send the exhibits to us, if they're not in the separate files are numbered, Shannon stays here for 2 hours to get it all done so she can take care of it because she can't leave until all of that is taken care of. So you have to get it to us as soon as possible to take care of, but I just need more organization. I really do, okay? Does that make sense? Everybody get it? All right, see you next week.